included is not verbatim text from either of the state cases.
Correct. That's correct, Your Honor.
Okay, that doesn't mean it's a bad sentence. I had thought that I'd find that sentence and then I'd have context around it, but that was a synthesis of the state law cases, or it was pulled from one of the two federal cases, which I hadn't looked at.
It was, Your Honor. And may I address the court on the issue?
You may. Let me just rattle off what I think we need to address while we're waiting for the last two jurors. Then we need to get on the record the exceptions from yesterday's discussion, because I know there were a few that Mr. Stewart wanted to get on the record that he made timely. He's waived nothing, but we'll get them on the record. And then I need to share the verdict form. I'll put it up on the screen. We'll get a hard copy to you all. You should have received an electronic version of the draft charge as it stood based on our discussions last night from Ms. Niles before she officially signed off for the night. She should have sent that to all of you. So with that, why don't you share what you want to share, Mr. McLeod? Let me get my version of the charge up. Everyone's here?
Yes, Judge.
Excellent, thank you. Mr. McLeod, I'm ready for you.
Okay, Your Honor, and part of this, I guess I'll call it argument, but what I did is I went back and just kind of looked at history of Bodine and kind of its progeny, and also in relation to the Green case. I believe the issue yesterday was, Mr. Stewart was saying the Green case stood for the proposition that you don't have to be the owner of the property to be liable for a continuing business. I don't disagree with that, and also I think that decision was correct as far as it went. But the issue of whether the defendants had a legal duty to terminate the nuisance was not at dispute in that case, so it wasn't addressed. Bodine is not cited in that case. So I agree with that. And I think that case can still exist, but I also think that if you have a case where the defendant asserts that they have to have a legal duty to terminate the nuisance, that issue must be addressed by the court. And so Green did not address seller liability for continuing nuisance where the seller actually denied having a legal right duty to terminate the cause of nuisance. And Green has never been applied to such a case. The Bodine case relied on two damages cases where it's holding and has never been cited as being limited to injunctive cases. I recall Your Honor maybe say that might be a factor to distinguish.
I was just trying to reconcile the different strands, but
correct. There was a recent Georgia, or not recent, but there's a Georgia Supreme Court case called Shaheen, and I can give you the site. And then some of the federal cases actually talked about if the court has a question as to whether there's a legal duty. Some of those federal cases have actually made that a question for the jury as to whether there's a legal duty. So I think to the extent the court rules that way, I think that's why it's particular instruction for the charges. But I'm not sure that there is evidence that we had a legal right or duty. Let me give you an example. Analogy in this case would be, let's say my clients were the developer and had maintained control of the declarant's rights and were responsible for maintaining the common areas, even though they didn't own the property anymore. At that point, they would have had a legal duty to terminate the cause of the nuisance. Holders of properties that have easements that run through them would be another example. In the federal cases, you'll see there are a lot of cases that cite, anytime you see a case where it's a case against the city had the right to permit or refuse to permit something, and so they would have had the legal right or duty to handle that. So if you see a city case, that's where those go. Other cases refer to, hey, we didn't own the nuisance, or we didn't create the nuisance, but unfortunately we acquired property that this pipe that's running through it has a lot of oil waste and stuff. I think that's a Briggs and Stratton case. And so by virtue of the fact that we're now the holder of that nuisance or easement on that property that's containing the nuisance. We have a duty to terminate that clause, and the prior owners who have been sued have been let out because even though they were involved at one point, they're gone now. They no longer have a legal right and duty to terminate the nuisance. So I think that to me is the distinction. I'm not disagreeing with the Green case.
Sure.
I'm just saying it was only correct insofar as far as it went.
Well, and I think the way that they can cohabitate is that it's legal right and legal duty. I think Green tells us that you may have a legal duty that survives your departure from a situation. One way you depart from a situation is you sell the land. I appreciate Water's Edge never owned the land, meaning the swale. They did own the box. When they connected the box to the swale, I believe they had both a right and they had a right to do so, and they had a duty to connect box to swale in a way that didn't create a nuisance. I think the jury could find from the evidence, and Mr. Stewart could argue from the evidence that that's where the nuisance began. So that was the creation of the nuisance, and that creates the duty to terminate it, but it's an and, it's not an or. And so I think, I hear from Mr. Stewart on this, but I think I do need to include language to the effect of, I'd call it Baudin, if we're going to be French, but we'll say Baudin because that's French Georgian. But either way, I think we need to include the import of that case, and where you get to argue. I don't think it's you've already had your directed verdict argument. You may renew it, but I'm just previewing for you. I think that there is evidence showing that either your client thought they had a legal right to be there, or there was some understanding. I mean, legal right is a little murky. I'm not going to give a separate charge on legal right, but you're free to argue that. Listen to what Mr. Schonkweiler said. Listen to what Mr. Silverstone said. They didn't have a right to be there. In fact, Mr. Schonkweiler, in making his video, was worried I'm technically trespassing, not on the Ibezims property, but on the property of the homeowners association. So you'll work through that. But I think unless Mr. Stewart can find law that says this proposition is mistaken, it coexists with Green. There's that piece that the jury needs to be working through. And so the thrust of your argument is, we don't think we had a duty or a right. Maybe you'll say, assume for a moment we had a duty because this theory of Mr. Stewart's that we caused it. And so even though we've moved away from the situation, sort of the analog of selling the property, we did sell the property, we sold the box. That doesn't mean we could walk away from the nuisance if the jury were to find that we caused it. You'll say we didn't, but if you find that, we still never had the right to be back there to fix it. And so you can't find that we're liable for maintaining that nuisance.
Right. I think the and part of the equation is very important because it says and the duty to terminate.
Right. It's not or, because in your argument to me just now, like, oh, right, or duty, they're different. And I think your argument is weaker for saying duty. We had no duty to do it. I think that
Right.
that clearly goes to the jury, both to go to the jury, I believe. But I think you want to be empowered through a charge that I give the jury to say it's both. You can't find just that maybe your clients are responsible because they caused it when they connected the water runoff to the swale. They owned that, as in they were responsible for that, and they didn't fix it. Jury could find that. But if we couldn't get back there to fix it, then we can't be held liable for maintaining that nuisance. You want to argue that. I believe Baudin says you can argue that because that's the law. And I ought to tell the jury, not that you can argue it, but that conjunctive is part of what needs to be shown.
That's fine, Your Honor. I mean, I agree that if it's not a direct verdict thing, that there certainly has to be a jury instruction.
Okay.
And I would also add that my understanding of the evidence is that what we own is really not an issue in terms of the property we own, causing nuisance. The allegations are that we caused the nuisance by what we did on someone else's property. And I think those are the allegations by grading. Improper grading is what the complaint alleged, I believe.
Okay, well, folks are in some ways connected to what's in the complaint, and you'll focus on that if you want in your closing. But I think I find that we've heard enough evidence about the integration of the box to the swale and all that, that it's properly before the jury to be thinking about Water's Edge's responsibility for liability for at least the beginning of the nuisance. And there are arguments that no, pre-existed. There are arguments that you can't find us liable because, again, we're just the box and that's outside. It never was our land, never will be our land. I just think the jury's entitled to hear those arguments and work through it. They just need to be told that it is duty and right to be liable.
Right, and the proposed instruction I gave was from the federal case. Basically what I did was substituted the parties' names. I can find that case for you if you want to see what I got.
Is it not one of the four that you listed?
I believe that it is.
Okay, well, Ms. Niles is going to dive into all four, and I don't need to find it verbatim. I just, what I had understood you to say is, oh, that's in Baudin. And the principle is in Baudin, the language isn't, and that's okay. Did you have anything else you wanted to get on the record concerning the proposed jury charge? Okay, Mr. Kyle, anything you want to get on the record in connection with the proposed jury charge?
Yes, Your Honor. You correctly stated in attorney's fees portion of the charge that second sentence, however, if either defendant, parentheses, WEG, Mill Creek, or Water's Edge, close quote, acted in bad faith, you may allow them. I would suggest that you consider in the punitive damages charge stating somewhat similar to that, stated that before you may award punitive damages, plaintiff must prove that defendant's actions, maybe put a parentheses after defendants to show the same language, WEG and Water's Edge, because there's no claim for attorney's fees against the third-party defendants.
Okay, I see your point. It's that the jurors need to remember, because I think when I put capital D defendant of the Water's Edge group, but you are also a defendant, and I wouldn't want the jury to be thinking, oh yeah, what Mr. Tolley's company did was outrageous, and so we're going to want to get to that second chapter of punitive damages. It needs to be the actions or inactions of the Water's Edge folks. So I think that's a wise amendment, just so there is clarity by defendants. I meant those. Mr. McLeod, any objection to that?
No, Your Honor.
Mr. Stewart, you okay with that?
Well, yes, as far as no problem with clarifying about that. I'm still, I guess, a little bit confused about the apportionment plan. You're going to have all them put down together.
So please, one topic at a time. What's before you right now is an amendment to the punitive damages charge so that it flows similarly to the attorney's fees charge, where I make clear when I say defendant, I mean WEG, Mill Creek, and or Water's Edge group. That's my only question right now.
No objection.
Okay, I will make that change and you'll see it in the final version. Anything else, Mr. Kyle?
No, Your Honor.
All right, Ms. Wilson, did you have anything for your clients?
I don't believe so.
Okay. Now, Mr. Stewart, I know you have a number of things you want to get on the record in terms of exceptions from last night, and I'm happy to talk more about apportionment. I just wanted to get closure on Mr. Kyle's suggestion, which I am adopting.
But before that, going back, do you want me, I did go home, read quite a bit on Baudin and other cases around it. And I don't disagree with some of the things that were said here, but there are a couple of cases you might want to look at.
Okay, let's start with that. So tell me, but before I spend time looking at those cases, are they going to demonstrate to me that it is an incorrect statement of law to share with the jury words to the effect of, in order to be liable for maintaining continuing nuisance, Water's Edge must have had A, a legal right, and B, been under a legal duty to terminate the nuisance. Because if they don't undercut that proposition, I think that's the essence of what I need to incorporate.
I don't object you putting in there. I don't believe that that's correct as far as they had to have a legal duty, but I don't mind if you want to tell the jury they have.
Okay, that's all I intend to do.
I do believe that Bodine makes it confusing, but that's a 1960 case, and I have never seen it cited in any of these Florida cases I've done.
Well, and I agree, but I don't think it conflicts with Green and that West versus CSX, and I think the essence of those is already in the jury charge, and I think this is an additional layer of meaning that the jury needs to hear.
Yeah, and I think it's kind of the middle, and it's kind of confusing to me a little bit, but
I think that's a fair statement.
in Green, they cite to Smarto Corp versus Deal, whatever, and that's the case where they address the issue, what percentage of can the corporation be held liable, and because they arguably did not have a duty because they didn't legally own it and all that. So that talks about that issue somewhat, not directly on point, but it's similar. And then 1977, that's when the Supreme Court addressed the 3 permanent injunction cases. And the one is possibly, which doesn't address it directly, but the other 2, which they give some more insight as well, might want to look at is Cox versus Cambridge, which is 239 Georgia 127. And we already talked about Ponce de Leon is 238 Georgia 188. And then the other is City of Atlanta versus Wolcott. That's 240 Georgia 244.
Okay, and those 2, the 239 and the 240, those are gonna help me view Baudin in a different light?
I don't think it does that, but I think it does address when can you get a permanent injunction, which Baudin goes to that.
Okay.
And
we may work through permanent injunctions depending on what the jury does, but my thought was we don't trouble them with anything about injunctions because they have nothing to do with injunctions.
agree 100%.
Okay,
Baudin, to me, when I read it, it's talking about, that's on the issues really addressed. It's not addressing about nuisance and all that stuff. And those cases address those same issues. Supreme Court, 17 years, kind of laid it out. And most time when I get an injunction in these cases, those are 3 cases that are cited by me and Brees and cited by judges.
sure. And I will tell you, like you, I struggled a little bit in saying, how does Baudin transfer into what we're dealing with, which is liability and not the injunction? And I wasn't sure if somehow the analysis would be different. But if it's distilled down to liability for a continuing nuisance, it seems like something that I ought to share with the jury, because one form of your liability is to go fix it, and a way a court can ensure that the fix occurs is to enjoin it. And that would then empower Water's Edge to get onto the property and fix it. Because if their answer to you and your clients was, well, and I don't think it would be, we'd like to help because that relationship has soured, but we can't, even if we wanted to. We don't want to, and we can't because it's not our land. The injunction can fix that problem.
Yes, I think Baudin addressed that, like I say, and I don't think Baudin in any way limits what the jury had to decide in the first portion, but if you want to argue that, but I think those 3 cases will give a little more light.
Okay. Well, I will look at, I did read the Ponce case, but these other 2 I will look at, and they were in rapid fire succession. If they're 238, 239, and 240, that was the heyday of
1977, those 3 came out. It's kind of boom, that's the law that
big year for you.
my children went to college on Ponce de Leon.
All right. Well, my guess is some of these other lawyers weren't alive then, but either way, I'm glad that I'm sure you were.
I'm talking about when it came out, probably the last 15 years.
Got it. Got it. As a result of those, you've been able to put kids through school.
That's right.
What else do we need to get on the record in connection with yesterday's discussion?
Like for the charges,
Yes, sir.
I would, as I just have put on, I like to exception or object to not, of course, not willingness to give the charge on failure to produce a witness.
Okay.
I mean, that's very important in this case. And so this time I still accept or object to the apportionment until that's kind of worked out. I know exactly how that's going to be handled. I may withdraw my objection.
Okay.
But I did go back and read again 51-12-33. As far as the notice, maybe notice, but I'm not sure if I even understand exactly what you mean, but they're going to be all put it just as defendants on the verdict form for apportionment instead.
Let's look at the verdict form and maybe that'll address your concern. Were there anything else you wanted to get on the record?
No, Your Honor.
Okay. I emailed it to myself last night.
Going bad. Live TV.
All right, it should be in front of you. I'll get a hard copy for everyone to look at, but if you look at your screen, here is page 1 of the verdict form. Is it up? So the first thing the jurors will do is decide, are the defendants liable to the plaintiffs? And they'll put in a dollar amount. Let's pretend it's 100,000. So they check the first one. We fine for the plaintiffs in the amount of $100,000. If you fine for the plaintiffs, you must apportion fault among the following. And I've listed it out in that way. Note number 1, I say defendants because I don't see a meaningful way for the jurors to break apart the liability of the two defendants. I'm happy to list them separately. I think they'll struggle with that because are they then going to double count and say, well, you know what? I think the defendants are 20% responsible. So I'm going to give 20 to WEG Mill and 20 to Water's Edge. Well, that makes them 40% responsible. I haven't heard any argument or evidence that would show that one of the defendants is more responsible than other because it's basically just an ownership structure. But I am open to listing the defendants separately. I don't know that's what you really want. I mean, it'll be what you want. I don't know if that's really in your your client's best interest, but that's note number 1. Note number 2, there are no instructions on here. I will tell the jurors as I hold up the verdict form, you need to put a number next to everyone. That number can be 0. You can decide that the plaintiffs have no fault in this whatsoever. Put a 0 in there. These numbers need to add up to 100%, hence the 100% at the bottom. And you shouldn't modify the number that you put up in that first line if you find that the plaintiffs are due some damages in this case because of your thoughts about the apportionment. Don't do the apportionment first. Do the damages first. Once you've come up with that number, 100,000, then you put your percentages down there. And you'll see, Mr. Stewart, that's who I intend to list there. So I don't, it's not meant to be confusing, and I'm happy to make it simpler, but that's the approach I think we ought to take. And it flows from at least one of the proposed verdicts. I looked at all 3 of the proposed verdicts, some of which were real complicated. But I think this distills it. Let me just show you the second page, and then we'll go back to the page that I think is the one you're going to want to discuss. On the second page, we further find that plaintiffs are or are not entitled to punitive damages, period. Sign it. That's it. So let me start with you, Mr. Stewart. Does this make clearer how I intend apportionment to work? Yes or no? And then if not, what could I do to make it clearer?
Yes, overall, I think it's a very good format. Some files, and I use similar ones in my case. Just explain to me, if the jury does find 30% against, Mill Creek or say Backyard Realty, like under this, what does that mean as far as, since I didn't sue them, but there's still 30% of fault, how does that work out as far as the final judgment entered?
It would be as if Wells Fargo was 30% liable.
Well, see, Wells Fargo means, it just means nothing. That's a
Right.
directed verdict before the third party defense, if that's the case.
Correct?
Why are they still in the case then?
Good question. And maybe Mr. Dorsey has a motion, but they're not in the case for you. You didn't bring them in. And so let's say they were never brought in. I bet we would have received a notice of apportionment from Mr. McLeod, but we did. That was count 3 of the amended complaint. So I've already found, and I'll make it clear on the record, that I believe that the purpose of 511233D, which is the notice provision, is satisfied by including count 3, which provided all of the requisite information. The purpose, as it's been defined in Atlanta Women's Specialist 310 Georgia 331 of that notice provision, is twofold. 1, it aids in the truth-seeking process. We get the right parties in the mix. And 2, it prevents unfair surprise, i.e. folks are given notice. Well, I do find that Backyard Realty and the Mill Creek Lakes Homeowners Association, Condo Owners Association, were very much put on notice. I also find that the plaintiffs were put on notice. There it was in living color as count 3. It is functionally not any different in my mind from having a separate apportionment notice. That's exactly the language. The only difference is that it sounds like, Mr. Stewart, you were looking for what you saw for Wells Fargo, where there is a pleading, the title of which is simply apportionment notice. I didn't find any case law, nor do I find in the language of 51-1233D a requirement that it be a standalone item. Notice needs to be provided, and here it was in the form of count 3 to the amended third-party plaintiff complaint. You and I have already disagreed about that, and you've made that record, but that's why I think Backyard Realty Group and Mill Creek Lakes COA are appropriately listed here. And to answer your question, if 30% is allocated to Backyard Realty Group, there's nothing you collect on that. And that's as it should be, because you didn't sue them.
Yeah, and why didn't I sue them? Because third-party defendants brought them in, and then the third-party defendant, they're the ones that fight it. I have a claim against them. When they give notice, they brought them in. They're parties to the lawsuit. So am I supposed to file a lawsuit to bring them in when they're already in? If I get it's 120-day notice on the statute. Notice, if you don't bring them in, we're going to put a verdict for them. You need to bring them in. They brought them in. They're in already. So I'm supposed to go and file what should I file? A motion saying, okay, they've given notice now, even though they brought them in, I'm file a motion to bring them in too?
Sure, as defendants and not third-party defendants. Let's say that the way this had played out is that Mr. McLeod was successful in some way in getting the contribution charge in front of the jury. And the jury looks at this and there's no apportionment available for the homeowners association. That would be a strange outcome for this jury if they couldn't apportion responsibility to the homeowners association based on the evidence they've heard. They're going to struggle with that, and they are going to under allocate to someone, or maybe they over allocate to your clients, but it's going to be an allocation of fault that is faulty. It is not truth seeking. We don't have all the appropriate parties in the apportionment, but the way the third party plaintiff's complaint was drawn up, that was a potential outcome. You were free at any point. You never did. You were free before the third party plaintiff complaint was filed to sue the homeowners association and Backyard Realty. You don't need to explain why. It eludes me why the homeowners association wasn't sued. But I'm not an expert in this field, and there may have been technical pleading reasons why you couldn't, that legally you couldn't. And I don't need to explain to me, but you didn't. So you were never going to collect any money from the homeowners association. So whether they're out here now or not doesn't change that.
This is without notice all the time. They fight throughout most summary judgments saying, oh, we're third party defendants. They're fighting it out. And that's the whole thing we've been going under. I couldn't sue them because of the HOA membership of my clients, and they have arbitration clause. They would not been they would be a party. Okay. And so
you could never sue them, but you were on
them in for a contribution. So whatever we get for them, they get part back for them. That's the way the law worked for years. And now, because I'm supposed to file a lawsuit to bring in a party that's already been brought in, because that's what it says. If you don't bring them in, we'll put them on the verdict form.
But if you
brought them in.
Well, but it sounds like you never could have brought them in. If you couldn't have sued them, then how are you in a different position?
Well, I could have brought them in, but they could have filed a motion to have it sent to arbitration to get out. And so it made no sense to bring them in.
Well, except it made sense, I guess, in your mind, if you didn't want, I'm not sure. Once you were on notice that apportionment was a possible outcome here, you had a set of options. And the option you selected was, I'll just see how it plays out between the third party plaintiffs and the third party defendants. One result was, here they are on the verdict form.
And under your decision then, I could not sue, which I had a right to sue, Water's Edge and WEG without going to arbitration. Under your theory, I had no right to sue anybody without going to arbitration, because if I brought the others in, the whole case was thrown out of court. And so they're saying that I chose to sue them.
You did choose to sue them.
And I'm being punished because they sued each other.
How is the fact-finding, truth-finding efforts of the jury punishing you? Why is it that the jury should be unable to apportion fault to the homeowners association?
I'm not guessing it's word's fault, but that should be under a separate category from them fighting it out. And they decide whether they want to make backyard realty, whatever, give money to Water's Edge for the money to award against them.
But what if the fact finder, whether it's a judge or a jury, thinks, you know what, there is a separate liability for the homeowners association. They dropped the ball here, but there is also independent liability for Water's Edge. The Water's Edge should be 20% responsible, and the homeowners association should be 40% responsible. I guess this is 60 because of the fence. And the unwillingness to raise the fence up and locking the fence and all these things, we think that the plaintiffs are 40% responsible. There's your 100%. A fact finder could very reasonably believe that there is independent liability for the homeowners association. Your perspective is the fact finder should never be able to consider that.
No, they consider it about whether on the third party defendant, just like third party has always been, the front mind themselves. Instead of going revamping the law, so it requires me to go to arbitration, not file my suit at all.
I'm not requiring you to do anything.
The law is requiring it. If that's the ruling, that if they give notice, if you don't bring them in, even though we brought them in already in a third party action.
But your argument is circular. Let's say all that Mr. McLeod did was file an apportionment notice about the homeowners association. That's all they did. You're telling me you wouldn't have brought him in anyway, because if you did, it'd go to arbitration. So how are you in a different situation?
I brought him in, but at the same time, it would totally change how the case is presented and how, what witness may I put up and how I fought. Because I was wondering yesterday, I said, oh, we're getting together, we're working out now because we're going by what you decide doing this apportionment. That's not been all the way through this case. They've been fighting each other about it, and that's good, they're fighting. But now you're making them hold hands. And if I'd known that at the very beginning, I would have totally prepared the case differently, because that's not what third party is all about.
Well, this will present an interesting issue on appeal if it goes in a way you don't like. But I think that under 51-12-33, it's appropriate to include Backyard Realty Group and Mill Creek Lake Homeowners Association as apportionees. I think the jury is entitled to consider the case that way, because there is evidence that would show at a minimum that the homeowners association is independently liable for some of the fault. What the jury does with that's fine. The fact that if you're put in a trick bag because of the arbitration provision doesn't somehow mean we shouldn't apply apportionment law. That's silly. That means that by a contract, you could make some part of the law not apply to a case, and that you've got it reversed. You can build your contracts around the law. You don't build the law around the contract. And I think that the homeowners association from Jump Street, the moment they acquired the common area, they carried with them a bag that says potentially liable. And the jury, the fact finder, ought to be able to consider that. And Mr. McLeod, through his litigation, created a number of options for his legal team, one of which was apportionment. Notice was out there, and that may have complicated the way you approach this, because if the outcome was merely contribution, then you argue one way, but the outcome was, as I've seen it and ruled, that it would be apportionment as opposed to contribution. I don't think the contribution claim would have been successful, but it's not before me right now because they're going forward with apportionment. I think that there's independent potential liability here, the way the land was owned, the process occurred, et cetera. So, but I'm also surprised that this is news to you now. It's what we've been talking about for a couple days now.
Well,
that admittedly is news relative to way back when the litigation began and the third party complaint was filed. So that I appreciate, but this is where we are now. So given my ruling, my question to you is, would you structure this in a different way? Or as you said, this is the kind of verdict form you'd use. Is there something more you'd want me to put on there?
For that portion, no, as far as the format of it, I was just object. So my question to you is, since they were allowed to bring in all the facts about the first lawsuit and why we dismissed it and brought it back during closing argument, could I get up and argue to them? We only sue them because the law, that's all the people we can recover from. That's why we chose to sue them, because we can only sue people we can recover from. That's why we choose to sue them. That's the legal thing we did. And they've been arguing, we made a mistake by suing the other folks. They're right, it was a mistake, and we sue the right people now, only give damage against the right people.
So no, and the jury didn't hear because I told the lawyers to stay away from why it was withdrawn. The lawyers followed my direction, which was the lawsuit was withdrawn. We didn't use the D word, dismissed, so that the jurors would be thinking, wait, was it a faulty lawsuit, or was there some judgment made that there wasn't merit to the claims against the homeowners association and Backyard Realty, or was there a settlement? We withdrew it, we consulted with a lawyer, and the case was brought here. So
In that case, there was no lawsuit against Backyard Realty or WEG. They only sued Smith and Tolley. And so it's, when they keep talking about, oh, you want to sue them companies, my clients never sued those companies.
That's contrary.
yeah, that's not the evidence.
Oh, it is.
There were two lawsuits, and the amended included the corporate. I mean, the jury heard that testimony.
They filed an amendment, but it was dismissed for answers even filed or anything.
We,
And so that was not a lawsuit that went forward against them. They did that, apparently they must have got somebody else legal. They only sued those two people, and that's the only ones that ever went to court.
you have a different recollection of the record, but my answer to your question is no, you may not argue. Look, the only two people who are legally liable, you can say the evidence is such that responsibility is 100% on Water's Edge shoulders. But it would be inappropriate, and I will correct that in front of the jury if you argue to them, you know what, you may not understand the law, but the only people who are ever going to have to pay any money if you allocate fault would be these people and these people. Might as well then get into insurance too. Let's get into that and some other things that you know are impermissible. So I'm hearing you say, I'm frustrated by this, but the format of the verdict, if you're going to persist in your erroneous rulings, my words, not yours, the format of the verdict form works for plaintiff. Let me go to you, Mr. McLeod, and I want to get our jurors in here. You're the only one who hasn't been able to talk about the verdict form yet. And I don't know that the third party defendants have, but you looked uncomfortable with defendants being listed as a single.
I've still been a little bit unclear as to whether the defendant, WEG Mill Creek LLC, was, this is not a parent-child company situation. These are actually two separate companies with a little bit of different ownership structures.
But am I correct that WEG Mill owned the land?
WEG Mill did own the land.
Okay.
That's correct.
And then Water's Edge would be the operating entity that would have.
They're the construction company.
Okay.
Yeah, and so
Transfer of title.
yeah, my understanding now of the complaint is that the allegations is that the damage was all caused on property that wasn't owned by WEG Mill Creek.
Of course, the damage was on property owned by the Ibezims, meaning the damage to their home, but it wasn't WEG Mill's property anymore.
Correct. And so then we get into the second part, was there control and duty to terminate part for WEG Mill Creek. To the extent Water's Edge Group Inc., the builder did something on the association property that caused the nuisance and it's continuing, then we have the jury question as to whether or not they had the duty to terminate that. So that's my concern about lumping them in.
Okay, no, that makes sense. I'll separate them out. I think that makes sense. So I'll do that. Any other change you'd want to the verdict form?
No, Your Honor.
Okay, and Mr. Dorsey.
I'm sorry, I have not consulted with him on what he's gonna say. I was just gonna ask to see, I like the verdict form. As far as the punitive damages portion, if putting in the descriptive defendants like we did in the jury.
Yes.
Beneficial on that line, just, we know that they might not read all those.
Yep.
This they will read, so just that you had that.
Yeah, and wherever in the apportionment is clear because your clients are broken out, but we'll just go with the names. Okay.
Quickly, Your Honor, 2 points. The order of the defendants on here, you're going to put defendant WEG and defendant Water's Edge. They brought in Geo Sam, Wells Fargo, and Portrait Homes.
Correct.
I think since they brought them in, they should be under the defendants, and then Backyard Realty and
Mill Creek
Mill
Lakes.
should be at the very bottom. It's a minor point,
Okay,
but I think it ought to be considered.
okay.
Number two, on punitive damages, can you pull up the screen? I
Yeah.
can't see
Yep.
how you worded it. We further find that the plaintiffs are or are not entitled to. I think the code section 51-12-5.1 says, in any case in which punitive damages are claimed, the trier of fact shall first resolve from the evidence produced whether an award of punitive damages shall be made. So I think the wording should be, do you find that an award of, please, we have to use the word whether the award of punitive damages shall be made as opposed to they're entitled to punitive damages.
So then I could say, we further find that plaintiffs are or are not, should or should not be awarded punitive damages. I think you're wordsmithing here. If the issue is the word entitled, I'm happy to use something different. But I think the structure is the way I'm going to leave it. We find that plaintiffs are not, or should not be awarded punitive damages. But I'll look at the language in 51-12-5.1, make a revision. We'll all look at the verdict form again. But I think I understand the recommended changes. I don't have an issue with those.
How about, can I comment on the punitive damage?
Yes, sir.
I would ask that we award punitive damage, but as far as to the plaintiffs, is to deter them and everything. It's not money that's supposed to go us to award us money. It's supposed to be money to deter them. It does go to the plaintiffs, but the way it's worded, a lot of times you say, do you want to consider punitive damage or do you want to award punitive damages, period, without saying for the plaintiffs?
Got it. Okay, so it would be, we further find that punitive damages should be awarded, should not be awarded.
Yes, Your Honor.
That'll do it. That gets the award and we get plaintiffs out of the mix. Okay, excellent. Don't mess it up, Mr. McLeod, but tell me what you think.
I'm just thinking, wondering if the jury's going to wonder who the awarding punitive damages against. Like which.
Yes, okay, that's fair. And that gets back to Mr. Kyle's, or I think Mr. Dorsey brought it up. Let's not make it murky. So what if we say this? And I'll spell it out, water's edge, et cetera, should not be awarded against. And that also gets to Mr. Stewart's point that, yes, it goes to the plaintiffs. That's not the point. It is punitive damages against the malfeasor, which the only two it could be in this case would be WEG Mill and Water's Edge.
Yes, and that's my concern is that for whatever reason, based on the evidence, the jury thinks that punitive damages should be awarded. But I think they need to understand the distinction between the defendants that, they have to find that Water's Edge.
Yep. So I'll flesh it. You can see on the screen now. I'll get both defendants listed, but it will say we further find punitive damages, and they pick one, should be awarded or should not be awarded. And again, I'll list both defendants. I want to get the jury in here. Mr. Stewart, does that work better for you?
Yes.
All right. Mr. Kyle?
Yes.
Good catch. And Mr. McLeod, you're all right with this? Okay. Mr. Sharkweiler, if you get back on the stand, please. Mr. Stewart, you ready for cross-examination?
Yes.
Let's get in position. And one thing, just for the record, Mr. Stewart, you raised a concern about the fact that, and I apologize if I didn't make it clearer, that these proceedings are publicly available. They're, of course, obviously publicly available. We have to have an open court. Just in this day and age, they're more broadly publicly available. And as best I understood your concern, there's been a home address mentioned. But of course, the home address is splashed across all the pleadings in this case. So if there's anything else that's going to come out that you think we need to be circumspect about, I'm happy to encourage folks to do that. But the location of the nuisance could hardly be kept from the public in this case. And it is in every meaningful pleading in the case. So I'm a little confused as to how anyone would think that that wouldn't be as publicly available as anything could be in a case. But as I said, I'm happy to advise folks to be thoughtful about something other than, of course, the location of the nuisance.
Because most trials, 2 or 3 people may show up and maybe it goes through the paperwork or that. This is live broadcast nationwide, I guess, or worldwide, to any nutcase or crazy person wants to do that. They see him and people saying all these terrible things about him, and this is where he lives, and they get mad.
Don't bring a trial if you don't bring a case if you don't want to have things aired out in public.
No, we wouldn't. If we knew it was going to be on live TV. If we'd been told that, we might have present a little bit different. It'd be good to know that.
Let's bring the jurors in.
Pushing these buttons.
All right, to the jurors. All the jurors are present, count for judge.
Thank you, Deputy. Everyone can be seated. Good morning, ladies and gentlemen.
Good morning.
So I've got some good news and bad news. You've already experienced the bad news. It's 9:45. We were here till 6:45 last night. And I thought that meant we had finished everything. But lawyers will be lawyers. And what I was told would be about 10 minutes this morning took a little bit longer. All important legal stuff relating to the charge that you'll get when we get to the charge. So I apologize that you were stuck back there, but I know we replenished the snacks and the water, et cetera. So you're going to survive. The good news, to streamline things today, we can provide pizza from Rosa's if collectively you want to do that. And by streamline, I mean, that just means lunch can be a little shorter because you're not going to have to walk and go get it somewhere. It would be a cheese pie, a veggie pie, an everything pie, and a meat pie. So it should scratch every itch. But if there's someone here for whom pizza absolutely won't work, gluten, dairy, whatever it is, I don't want to preclude you from getting lunch. But the goal of doing that is that we could have our lunch break be a little bit shorter and get more done, not necessarily recoup the entire 45 minutes. But I just need to know if there's anyone for whom that won't work. Because if it's good, you're the last person I would have thought pizza would be a problem. I was figuring we need to get a 5th pie.
No, sir, it's great. I want them, if one of the meat could have no pork on it, that's no problem.
Okay.
One of the meat, yeah.
I don't, yes, I'll see if we can do that. Maybe the everything or the meat. It's a great question. And I'll check with
And
our
I'll pay
pizza.
extra if I have to, no problem.
Okay, because you have cheese, maybe they'll dedicate the entire cheese one to you or the veggie one.
Or beef and cheese.
Okay, so no pork. Well, maybe we'll just say, let's do meat that's not pork, and that'll make it easier. But if that rules out sausage and pepperoni,
No, we won't.
you're kind of killing the crew.
No, that's
Yeah. This guy, everything with him is high maintenance.
Get the pepperoni man, but just, I think I get one with beef and chicken or something.
Okay,
No pork.
it's Rosa's. I don't think they do chicken. I mean, this is
beef.
classic pizza, and then like that's who puts chicken on a pizza if you're from New York.
Can we just figure it out at our break? Figure out 4 pizzas?
Nope.
No? Oh,
I'll manage it.
okay.
So
Cheese.
it is you're in or you're out, but we will.
We'll do the cheese.
We will get one with meat that's not pork. That's not hard to do, okay? The other one is gonna have meat on it, don't touch it.
Thank you,
And we'll make sure the 2 pizzas don't touch each other. All right, so we'll get pizza. I don't know exactly when that'll be. We'll make it, it'll be lunchtime.
Thank you,
but
sir.
We'll do that. Least we could do. You've given us a whole week and maybe a little more. Where we left off was Mr. Schonkweiler was on the stand. He had been examined by 2 sets of attorneys. and it is time for Mr. Stewart to ask questions of Mr. Schonkweiler. Mr. Schonkweiler, you remain under the oath you took. Oh, one last thing. If you all were hoping to see Deputy Gordon today, he is at a bachelor party, not in the United States of America. So I'm hoping, I don't know how he affords this on his deputy salary, that he comes back. I'm hoping that he is legally allowed to return to the United States. So it'll be a reason to come back on Monday to see him, because he's supposed to be back on Monday. We'll see. All right, with that.
Your Honor, there's stuff on the screen. I don't know if it needs to come off or stay muted.
Yes, it
muted.
does. So do not unmute it. So stay muted. And then got it. It is being live streamed, which is something that has been put up on the screen throughout the trial. Thank you.
Good morning, Mr. Blackwell. How are you today?
Good, sir. How are you?
Good. Appreciate you being here. We heard you talk about your background, you worked with Mr. Silverstone, these two companies, things of that nature. What's your educational background?
I have a bachelor's degree from Purdue University.
What subject?
It was a technology degree that specialized in engineering.
You're not a professional engineer or civil engineer?
No, sir.
You're not a hydrologist or anything like that?
Yes, sir.
You suggest you, Mr. Silverstone, have built, I think, 800 to 1,000 homes over the last 15 years.
Yes, sir.
You split, not working together. In what year did you stop working together?
2020, the end of 2020, the beginning of 2021.
You made the video we saw. Is that, were you still working together then or you are still?
No, sir. We're working together.
And over those 100,000 homes, was all those water edge group? Did you have many others?
Each community had its own company. Water's Edge Group built the homes under those companies.
So you build a subdivision, finish it, close it down, then go get another company?
Yes, sir.
You and Mr. Silverstone, always the partners?
Yes, sir.
Okay. So if you built something in Chamblee after Buford, that might be called Pretty Lakes Company or whatever the name is, or it's always Water's Edge, but it would be Water's Edge and then the name of the community.
Typically, that's what it was. Yes,
Got
sir.
it. So Water's Edge is in there, and then there's the name of the community.
Correct. We wanted to keep each community separate. We didn't want to lump
Why
it.
do you want to spend the money? Why can't you use second corporation?
That was the inside that he created when we first started as partners, that's how he wanted to manage the finances. So that'd be a question for Ian. I just supported it. It was fine.
And so this subdivision, phase 2 is what the two of you built. There's already 120 houses that were supported. Recession came and shut down. The y'all you built phase 2. Is that right?
I don't know how it was phased, but yes, we bought the last 50 or 52. I think it was 52 lots.
I was asking, I think it was 174 altogether, so it was 54, but did some other people buy some of those 54? Did y'all buy all 54?
So when we came in, there was another builder there that had bought some lots and it did not work out. I don't know who that builder was. And then we bought whatever the remaining lots were. And we didn't finish anybody's homes or anything. We built our own homes.
So I mean, you built 54.
I think so, yes, somewhere around that.
We heard testimony that the plans paid $219,000 and fees, I think, $235,000 per unit. Was that the price for all these units, or what was the price range?
They ranged, I think, from the high 190s to 220 something.
High 220s, like pay 230. You're talking about before fees are added on, things like that.
Yeah, I mean, if you have closing attorney's fees or closing costs, that's nothing that we put in there. That's their responsibility. If you're a cash buyer, you don't have certain fees. That's nothing that we're a part of.
I'm not going to criticize, just asking questions.
Yes, sir.
You sold all 54 of them.
Yes, sir.
They sold pretty quickly during the hot market.
We met our absorption rate. Yes.
Successful subdivision. Or no major difficulties or problems when it's built.
No, sir.
Did you personally, when you're going out there on the site, Mr. Silverstone, doing the books, or whatever, you personally oversee tying of the swell into the drainage system?
There was no tying as far as piping. There was a pad that was set, and we poured a foundation on top of that pad. The drainage was already established.
That's fine. You had a bobcat, went out there, you had to clear it off, and what much grass, and you put in the dumpster and all those type of things. But you had after 10 years, that lot sitting empty. All the rainstorms, everything, it obviously impacted that swell and everything. You someone took that bobcat out there and had to regrade that and make it right, so water run down, slope, and proper grade and all that.
No, even if you look at the pictures, the paths were set down. If you look at the picture, there's a distinctive hill. Same with the road that goes down it. The road was established. The high side's on the right side of the building and the low side's on the left side. There's no major anything that was done. The swell was there.
But to get the house, and once you built that, you had to do this grade, that positive grade you're talking about.
The grade was already positive.
1 inch per 10 feet, the code requirement that has to be. You heard that term?
Absolutely. I've heard that it's not. Go ahead.
Okay, so you know that's code. So you had to pretty much precise to see the 10 years if that hadn't changed at all. Once you had all those workers out there and pouring concrete, trucks coming across and things, all that nature. You had to do some work and level that to make it work right, didn't you?
The back swell?
Behind the units.
No, it was established. Same with it. It's like you're asking about the drop inlet. Did we mess with the drop inlet? No, you see pictures of the drop inlet. It's there. We didn't adjust the drop inlet. The grades were established.
Once you're back, the bobcat other drips right into the swell area to take care of the grass.
Minorly, it took off the grass to clean up minor underbrush. It was not to move major dirt, and it did not.
Okay. You use a bobcat. The bobcat's a piece of paper weighs usually between 1,000, 4,000 pounds.
Yeah, it weighs under 10,000 pounds. Yes.
That's used commonly in certain sites for ground preparation, landscaping, and things like that.
It is a common piece of equipment.
Did you personally go out there and drive that bobcat?
No, sir.
Who was first? What company built the bobcat?
I don't recall.
So you built all 54 was the same company?
At that time, we had 3 or 4 subdivisions going. So there could have been 2 or 3 different vendors that it could have been. I don't know which one it would have been. The project manager could have picked that.
All right, so this time you have this subdivision where you built 54 townhomes. What are the 2 or 3 other subdivisions you have going at the same time?
There were townhome communities also.
And how many of those towns?
I mean, I can speculate. If it was Laurel Gates, there was 90 some townhomes. If it was, we were transitioning to, I have to go back and look. I mean, I know there was 2 or 3 subdivisions we were doing at all times. So I don't recall 8 years ago what subdivisions they were.
Okay, and you had, we're talking about.
Mhm.
You had almost probably 100 townhomes you're building at the same time.
I think probably back then we closed probably 70 to 75 units. I mean, Mill Creek, if I recall, Mill Creek was a 2-year subdivision for us.
And they're all the same price range, 190 to 220 or.
They were different. The subdivisions outside of that community?
Yeah.
Yeah, they were different. Well, those Laurel Gates, there were 3 to 5s, $300 to $500,000. We had another one off of Windy Hill. I can't remember what it was called, but it was the same price point. It would have been in the 4s and 5s. This was one of the more first-time home buyer Mill Creek Lakes was.
Well, some bitch, one was 200, 300,000, the other one's 400, 500,000.
Yeah,
You going back and forth to all 4 of these places at the same time they're all being built?
on a weekly basis, yes.
How far you at, what is this group?
How far was that? What do you mean, how far was that Water's Edge Group? At the office?
Your time, you're there, my understanding, Mr. Stone, yes, you, him, and the secretary, maybe one of the other employees, but everything else was subcontracted out. Are you the one that was out there working with Mr. Knight overseeing these subcontractors?
I was with Mr. Knight, yes. Mr. Knight was the day-to-day person that was there every day.
What was the other house when you were there?
I was there once a week, if not twice, but a minimum of once a week. I traveled every community and was there with them for, a half a day. and walk-in houses and ensuring what we needed to do. The day-to-day schedules and stuff, that's what the PMs were for.
Were you there when they did the final grade of back of building 30, toward patio slabs, concrete slabs and all that? Did you do that?
I was there in the beginning when we walked the pads to make sure that there was no issues that needed to be taken care of. I was not there for the forming or pouring of the community. No,
You went out there in the Bobcat, finished grading off or cleared off the swell, you what it is.
no,
You don't know who actually did the work.
I do not.
Right, and you said, that what is there, didn't own the swell area, any of that, that's the problem areas, correct?
That is correct.
But you did have the authority to go in that area and get prepared, so you get a stiff occupancy or CO, correct?
If we needed to, we could have, but there was nothing that was done in that swell that was majorly altered.
So if you needed to, you actually did do that, didn't you? You didn't leave like it was 10 years, and never been touched. You had to go out there and smooth it out, clear it, and make the swell work right.
The swell was already correct. There was no making the swell right. The swell was already there.
We bought geosand, they sold to you, did they do any work from the time they painted from Wells Fargo Bank? Did geosand just sell it to you?
I have no idea what they had to do to get it. I was not privy to any of that.
You know, if anything was done between time to shut down recession, 10 years earlier, was time you worked on the site.
I didn't,
Anything done on that block, at all.
I'm not aware of any of it. GeoSam back then bought thousands and thousands and thousands of lots. They were a very large group. And so what they acquired and what they had to do to acquisition it, I am not aware of that. A sales rep, outside sales agent would come to Water Judge Group and say, hey, I have this deal, come take a look at it. And that's what they did.
All right, so when your workers went back and graded down, prepared for this time, concrete patio, 5 to 6 units, worked in the swell as far as smoothing it out, whatever, you're not doing anything, to smooth it out, whatever. When all that was done, you had permission, that was done, and you didn't trespass anytime, did you?
No,
How did you have authority if you didn't own the land?
how did I have authority if I didn't own the land? I don't understand. I'm sorry.
Well, we've heard a lot about the fact that the actual commons area went from GeoSam directly to the association. You never even owned it. But you're out there pouring concrete slabs and things of that nature. And you're not trespassing, it's not yours. How did you get permission to do that if you don't own it?
I wasn't in the back of the swell pouring concrete. We're in the front of the house, in the front of the pad going there. We never drove concrete trucks or anything in the back of the swell.
How did you put a patio on the back then?
It was pumped. Everything had a boom pump. There was never trucks that drove over there. You couldn't, you'd crush all the utilities back there. There's electrical lines. So there's a boom truck that pumps all townhomes.
Right, so you
On the
have a
road.
Big truck, concrete truck coming to the driveway or where the driveway's going to be, and then pump it over the roof for the patio.
The patios were poured at the same time as the slabs. We couldn't get that done. That's why they were done in the beginning, in their initial spot. So when you formed the foundation, the slabs were poured also. At the end, we poured the driveways.
Okay, so you pour the slabs and the foundation. Don't just go there and put boards to frame it out where the concrete was going, you have to smooth it out and all that. The work was done to frame out where you're gonna pour those slabs in the back.
Yes?
When they frame it back, they don't just stick them there, they make sure they grade it down, get every work that's done behind the townhome in the common area, correct?
If a Bobcat turned around in there, maybe, but the Bobcat accessed it from the front and went to the back, and then it was formed front to back.
Why not actually, I thought they formed it, I got 1x4 boards or 1x6s, and they framed out the patios, you had some sub workers out there actually working in that common area.
They probably stepped on to get outside, yes, because if you're saying that the back of the patio is the back of the pad, and then that's the common area, then yes, did they step on the common area? Yes, sir.
Well, let me, you tell me, they said you bought a lot ready, the building went up. If you walked out the back door of my client's house, take one step, you're in the common area, even though they got access, they said that's their particular area they're in charge of. With your ownership, where's that group that time? Just a 4 square wall area that you built.
Yes, sir.
all your workers had to go across the common areas. And we talk about framing things, but they definitely were in those common areas doing work. Correct?
They were walking on it. They were not moving dirt.
And the subcontractors you hired, who actually poured the patio on the back? Was that Midway Grading?
Again, I don't recall.
And you mentioned that Gwinnett County had inspectors that came out for each individual unit on 6 within the building 30 10 different inspections.
About 10-6, yes.
And you said the last one, for your CO was get a positive drainage test.
No, part of the final CO, it's the same inspector, comes out and he ensures in two different things. One, he ensures life safety issues to make sure that there's nothing that can be harmful to the public or to the resident. And two, ensures that there's rested vegetation and that there's positive drainage away from the home.
Positive drainage means that when the water comes off the roof or wherever, it's forward, it goes towards the swell, it doesn't go towards the house. That's positive drainage, right?
It is.
Your workers looked at that and made sure that was proper. When they poured the slab, they had to put the slab at a certain angle to make sure it's ran off that direction and everything.
That is correct.
And when you clean, the swell was functioning right, the mouth pumps closed in March 9, 2018. Everything went well, there was no problems. Building 30 was really good function as far as no defects in swells or anything.
That's correct.
The county inspector come out and if there was a concern, the slope wasn't like it's supposed to be, to make sure it runs the way instead of towards the house. You'll have to do work around and use a transit to make sure it's going the right direction, right?
Correct.
But you said these lots are so good, that he just eyeballed it. He never even took any measurements.
The inspector, as far as I'm aware of, no, he did not take any
He's there
measurements.
once a week. Do you know whether that's true or not? Or you just guessing?
Am I guessing if the inspector took a transit out?
That they use a transit when they came before they gave the COs.
I think my project manager at a construction meeting would have said, Inspector so-and-so made me get this out. And I think that would have been a very symbolic thing that they would have said. So, but no, I was not there when your question was I there when the inspection was done? No, sir, I was not.
All right. So is your belief in testimony that the inspector came out and just from a distance or got close to it, looked good to me, he's eyeballed it, assumed the swell looks right, and that's all it was done?
Yes, sir.
Did you have a hydrologist or anybody work for you to try to evaluate the water runoff that's going positive swell?
Again, no.
What is the square footage on that, the roof? I assume the floor foundation stands for those units.
What's the square footage of the roof?
Or the pad itself, how many square feet, is it 1,600 square feet?
I would say those are 2,000 foot units. They have a garage. So the main level is 1,000 square feet.
All right, so you got 1,000 square feet and 6 of them. That's going from what we talked about with hydraulic and stuff, soil and dirt to impervious, from being impervious, with water run through and soak in some runs off. Now concrete and roofs, it flows a lot more, correct?
Yes.
How much increased volume of water did you put going on that swell that existed at the time of disposal that had not existed for the last 10 years?
So as I said before, there is a final plat in which that swell was created. The engineers that final plat that did that with the developer established how that swell had to be and what drop inlet and what pipe size had to be in that drop inlet to be adequate for that water. There was a final plat with several inspectors that go out there on site to verify that that work is done correctly. Has nothing to do with the builder. The final plat is then done, the earthwork is finished, and the builder is issued a building permit to erect a building.
You got that permit, so Watershed Group itself never hired a civil engineer, anyone to evaluate or hydrologist, evaluate the water.
No,
Is that typical that you would do that, given that you're acquiring land that has already been platted?
no, because in developments, it's the same with the soil. They have to have compaction tests. So before you get the final plat, they have to hand all these compaction letters from those engineers to the county. That's part of that checklist to get a final plat. So for a builder to come back and to do $100,000 worth of due diligence for something that's the developer's responsible for, we've never done that.
And the other developments, the other construction that you were doing at those other locations that Mr. Stewart's asked you about, you didn't have hydrologists or civil engineers doing something there that you didn't do at Mill Creek.
No, sir. We've done the same thing every single time.
What you were doing there, preparing to stick and positive drain control, and those other things, it's mandatory to get that CO, correct?
Yes, sir.
No CO, not allowed to sell them.
Correct.
Without the CO, you can't rent it, nobody can move into it at all. So
Cannot make it a habitable dwelling.
let's talk about when you went to do work on the basement. You introduced pictures that were taken August 15th, 2018.
Okay.
Does that sound about right?
It does.
They closed on March 9th. 5 months later, plus a week more, is when you're out there at the site for who went out there to do that?
So myself, project manager who took care of the baseboard?
Who went out, met with the planners that night? Who from August 15th, who was from Ward that met with?
Myself and my project manager.
That was Chris Knight.
Yes, sir.
Who actually did the work? Pulling off the basement, that you or Chris Knight?
I do believe it was me.
You have experience in doing sheet rocking or?
I do.
What, just from over the years, did you go to school for that or what?
No, most trades don't go to school to learn how to do things. They learn from their parents and their families. And I come from a long line of renovators and maintenance factory workers. So it was taught to me at a very young age.
And you two of you discovered when you first, no problem, but later did say there was a void in your car.
Yes, sir.
You find the void as a hole in the wall.
Between the two buildings.
That void, a hole in the wall, was looking at the back wall would be on the right side of the property, right?
If you're facing the home, it was on the right rear.
Right rear, go out the back door and open it. The same as the hole had been just right next to where the fence divides unit 5-4.
That is correct.
Now, you said you didn't do work, but didn't Board of Ed group also put in the dividing fences between each unit?
We did.
And that was in the common area.
No. The dividing fences are on the slabs, on the patios.
But aren't the patios in I thought once you step out the back door, you're technically in common area. And so those slabs extend out into the common area if you've got a fence, or have I misunderstood?
From my understanding, Your Honor, the common area starts at the end of the end of the patio.
End of patio, not pad. So there's actually some dirt that.
Correct. So where their AC is at that's not in the common area. That's on their pad still. So the edge of the pad of their exterior pad is the end of the common area.
Pad is probably what's confusing me. I assumed pad was the concrete you poured that is effectively the floor of the townhome. But you're saying that the property boundary might extend another 10 feet to include
the exterior patio.
And of
Yes.
course, there's dirt next to it or grass or whatever. But so the property line you're saying would end once you step off the patio.
Yes, sir. That's the way I've noted.
So the patio and the AC unit that stood right there and all that, that's on the land that was owned by Ward of Ed until the closing.
From my understanding, yes, sir.
And so where the hole that went through the wall right next to that wooden fence, that also, step outside and look at that, with the AC between that and the wall, that was owned by Ward of Ed at that time.
From my understanding, yes.
This wooden fence, it's out a little bit past the patio.
I don't recall that.
Well, the video you showed yesterday shows that. But other videos show that they stick out about 3 or 4 feet past the patio. Was that in the common area? That's still your property.
I don't recall them sitting past the patio.
All right, is your,
But assume they do, assume just for the purposes of the question, and the jurors will be able to look at pictures, not just your video, that show how far, not the plaintiff's fence, but the privacy fence, the thing that's just one part of the fence. It doesn't encapsulate the yard. Assume for a minute it extends 2 feet past the patio slab. That putting up that last 2 feet, people would have been in common area.
No, it's a rectangle box and the houses are set forwards and backwards. There's usually a 1 to 2 foot offset that goes backwards and forwards. So if one patio is shorter than the other person's patio, which it would be because it offset, even though they're the same size unit, then their fence would go to the edge of their patio. So I don't believe they're in the common area. It's just in that rectangle where you're offset. You don't want a building that's completely flat. So therefore they're moved back and forth 2 feet.
all right, so your belief, not, you heard, I thought some different testimony, but your belief is the fence itself, the patio, all that was put on land, that was owned by Water's Edge.
Yes, sir.
So you didn't have to have any kind of permission or interaction with the association to do that, but that was your land.
Correct.
Tell me about the rock, that check dam that was put in with smooth swell. Who did that?
Water's Edge Group did.
Now, clearly, that's out in the middle of the swell, and your testimony is that is the common area. We had nothing to do with that.
That's correct.
Who gave you permission to put the check dam in the middle of the swell?
So we were, I don't know who gave us permission, but they were concerned about the heavy flow of water, and it was washing pine straw. And so as a courtesy, which we do on case to case basis, we said, okay, well, we'll slow the water down. We will put a series of check dams in that will slow the water down as a common courtesy. And we went at that out there at our expense and assisted in that.
You said, and our courtesy. We heard Mr. Smith say that nobody told me. That's when they went out there and saw it. He's president of the association. You're not sure who you got permission from? Did you get permission at all from anybody before you went out there to help them out like this?
I don't recall.
Well, what do you think will happen? Do you believe you wouldn't go out there and work in the swell without permission, or did you go ahead and do it?
There was obviously a warrant. Again, there was obviously a warranty call about the pine straw running, and there was someone that we would talk to. I don't know if my assistant Ashley had talked to Mike about it, or an email was out. I don't recall how it went from A to B.
Okay, so somebody might have talked to him, but you don't know for sure.
I don't know for sure. No, sir. We had an assistant that
I'm sorry, go ahead.
we had an assistant that took care of our warranty. So every Tuesday, again, like I said, we have these construction meetings. Everybody comes to our home office, and Ashley was our warranty coordinator also, amongst other things. And she would go over any issues that there was. We would talk about how we were going to address them. And if there was emails that need to be sent out in regards to something, Miss Ashley took care of that. So when you're asking, how did it go? Who sent it to him? I don't know.
So you went out there as a courtesy, put these rocks in the swell. You said, how many different check dams did you build in that subdivision as well?
Besides that,
Yeah, besides that.
none that I recall.
Oh, so that's the only one you did.
Yes, sir.
You must have complaints from someone saying, hey, we got water problems, and therefore courtesy we're out there and slow the water down. Why else would you go out there if that wasn't the case?
Okay. Yes.
So you definitely went out and said, we're going to try to help this water problem by putting these rocks in the swell.
We were trying to slow it down because there was a concern about washing pine straw. It wasn't that the swell was eroding or going higher up on anybody's property. It was to help out with landscaping issues.
All right. And who built the check dam for you?
I don't recall.
Is it Mr. Duckett, the landscaper that's out there that works with the association?
I don't know who Mr. Duckett is.
Okay. So you don't, would it be one of your subcontractors?
It would have been one of our guys, but I don't have a Mr. Duckett.
You ain't know what's, okay. Now, you're talking about this hole, so y'all put inject cement or whatever in there and plug it up. Is that correct?
Yes, sir.
The only reason you would plug up that hole because you didn't have a positive drain.
That's not true.
Negative drain, the water's going into the unit.
That's not true. No, that's not correct.
Well, all because of the fence, but how would water run that direction? Water should come down and slope down, so it should go down, out. Why did it go into the house?
It's just like, why did the Ibezims put sandbags on their patio?
I'll tell you.
No, you know what? You don't tell him because, well, but you know, you don't answer his questions. So
So answer my question.
keep answering. So if there is a fence that is blocking it and water runs up, it's like a swimming pool, shallow end, deep end. As it keeps going up, it's going to go to the shallow end. If you have a block that's holding it and it raises up, it's going to go above the level of the slab and it's going to enter. We found that entering, we resolved it, and then also said, hey, here's a water line that's on your fence. We showed it to him. I said, you need to cut this fence. You're going to have these issues. You need to cut the fence.
There's a water line on this fence. What water line are you talking about?
On the inside of his fence, there was a water line where the water rose. You could see a definite line on the fence.
Water level, not a line, pipe, not a pipe.
No, sir, not a pipe. Where the water had at one time, it rained drastically. The water rose, could not get out of the fence. And it created a distinctive water line on that fence. And he was shown it.
Your testimony is solely due to building that fence, the water backed up and went into the house.
Yes, sir.
What about the hole in the slab next door? Water's coming at the fence right at the very place you decide where the hole's at. Did that have any contribution to that problem?
I don't think it would have even shown. I mean, you had a drainage pipe on the right-hand side that was running down, and it was if it cascaded over because there was a large amount of water from the upper side, it was still going to cascade over the slab, and it would still went into a positive direction. By that fence being there, if it cascaded over, it directly hit that fence.
All right. You saw the videos, you've been here a couple days.
I didn't see the videos on Tuesday morning. No, sir, I did not.
For trial today, in the past, have you seen the video where the water runs right in the corner there, right up where you said the hole was at?
I never saw the hole in the house.
In the backyard, where that fence is at, in between the air conditioning unit and the back wall, is where the hole is. The water runs right there. Right to the right would be where the hole was that you passed, correct?
Okay, yes.
What did you do to prepare, fix, or try to improve the problem with the slab that was defective on unit 4, the one next door to my clients?
This is besides putting the hydraulic cement in?
Well, you put hydraulic cement to stop the water getting into the house.
Yes, sir.
But they still have a problem with water running from the neighbor's lot and filling up their back patio.
So from my understanding, that was not done while I was there, but they put an extension 2/3 of the way down onto that gentleman's slab, onto that patio, the exterior patio.
Yeah, that catches the water coming off the roof, shoots it out. What about the water coming under the slab? Because there's a big hole under the slab and the water floods to my plant's backyard. What did you do about that?
I'm not aware of any hole in another person's slot. That was not there when we were there.
And from your testimony today, we now know if there is a hole there, that is on Water's Edge property. It's not the common area. It's right against the wall of unit 4.
In my opinion, it would be. But we were never notified of any other hole.
You know, you're aware of my client, you heard him testify. Yesterday, he testified for the last 5 years, water's been coming out of that fence of that area, and it still comes on the fence of that area. Is that true? Do you know, is that true or not? That part of water's been coming out of that fence for 5 years?
No, sir.
My clients don't have, under their purchase of that unit, they don't have any rights to go on unit 4 to do any work, do they? My clients want to go change the concrete slab on unit 4, they couldn't do that.
No, sir.
Right, and did you or Chris actually put the concrete into the hole unit?
The hydraulic cement?
Yeah.
Yes, sir, we did.
I mean, did you or Chris do it? Do you know?
Chris did it.
Right. And you showed the video, did you know real later on that they tore down the check dam? Did you have any input about what that's going to be removed?
I had no clue that they even put the drainage in,
Branch in the pipe.
the pipes. I didn't know any of that had been done until I went out there and took that video.
And so your testimony, we'll get that second. That after they closed on the purchase of that house, even though you did do some courtesy work, it was the association who had total responsibility for any complaints they had about swell, the backyard, things like that.
Yes, including the fence that they put on.
Okay. And how does that work between the association out there when you did, I just trying to fix what's wrong with the swell, and you're going out there and putting the check dam on the swell? Are you working together, you're a team, or working against each other?
I don't think we ever worked against each other. I mean, if Mike called myself or Ian, we were cordial and answered the phone and, tried to resolve the issue.
We were in the element. You think you got permission,
Correct.
heard from Dr. James Sabah, all this specialist, who testified that as well as poorly built, water flow check dam was poorly built and caused water to flow to the units, not away from it. If you would actually evaluate when it's finished in built, that's not helpful.
Well, I would say that the video that I showed would tell you that I don't know if I agree with Dr. Spots. I mean, if it was moving water towards the units, that pine straw that you saw would be washed away. It wouldn't be there. If it was directly affecting that we did something wrong, then the video that I showed, the pine straw wouldn't be there. If this huge amount of water, which water is pressure, would have blown that pine straw all the way down the wall, all the way down the bottom to the end of the building. And it did not.
I assume the Dr. Spots was wrong, you're right. Who decided to put the 20 rocks or so on that check dam where the left side slopes down and it comes back up instead of having it mound in the middle? Who decided how to lay that check dam out?
The contractor.
You don't know who that was,
I do not.
but they were hired by what was that?
They were.
You're saying it was done good, or you have no knowledge whether it was done right or wrong?
I mean, I walked back there and I didn't see any defects that would concern me, especially after there was several rains. And then the rain that I went back to check it out, it didn't seem to be any concern.
Dr. Spots, a hydrologist or a soil erosion expert, he said it's done wrong. He's wrong, you're right, correct?
I'm saying that I don't feel that we did it wrong. So, but I'm not going to discredit that person. I have a lot of questions that I could ask him, but I'm not here to do that.
I just want to do vouch that the check dam was built correctly, was helpful, not a problem.
In my opinion, it was.
Other than you going out there and look at it, anybody really tell you why they did the way they did, or say, yeah, it's working good or anything?
No, sir.
All right. Now let's talk about at closing, you get my clients a 210 warrant.
Or QBW.
QBW.
It's two different companies. So they have similar programs, but the company was not 210 it was Quality Builders Warranty.
Okay, so this doesn't have a 210. Now 210 means certain things are warranted for 2 years, certain things are warranted for 10 years, right?
Yes.
You have that some places you didn't have.
We did not have a 210 warranty. That was not what was sold to them. We gave them a Quality Builders Assurance Warranty. It's two different companies.
Okay, so you have QBW as your warranty company. What is your understanding of that warranty? We heard testimony that only covers within the four walls of their unit. It doesn't cover anything outside there. Does it cover things outside the unit?
So in my mind, what the best thing about Quality Builders Assurance Warranty is for cases like this, that and it happens very, very rarely, but if the homeowners have an issue or a dispute that we can't resolve, they have an arbitrator that goes in there and says, hey, this is what it is. And they'll tell us, they'll say, if they don't agree with us and we have to fix it, we'll go fix it. If they say that it's not corrected or it's properly done, then they say, hey, it's not properly done. And we, at that turn, close the warranty ticket. So that's where I saw the values of it. As far as the ins and outs of every single thing that it provides, it's a basis for especially first-time home buyers of what's normal, what's not. And it has a guidebook that goes with it that they are given.
Well, it's talking about a specific case. They complained, they went to try the warranty, because they make complaints, so strong, it's just a fence, go file your warranty. They said the problems with the swell and unit 4 slab, that's not covered by the warranty, because that's not under warranty. Does that make sense to you?
That's what they said.
Well, you sold a lot of warranties, you do the work to correct them. That warranty, your understanding from your experience is that the swell is not covered all by that warranty.
Correct.
And the lot next door, the warranty's not a building 30 warranty, it's a warranty for very good, correct?
Correct.
So the problem of the slab on unit 4, there's no warranty for that, is it?
If there's a slab,
On unit 4, the neighbor, they're in unit 5.
they have the same warranty, same QBW, so they would have to claim their own warranty call.
Right. So my class in unit 5, they're complaining about what's happening in unit 4. So if they make a complaint, they can't have the warranty come and fix somebody else's property, correct? On the warranty,
Correct.
that's clear cut, black and white.
I do believe so.
And if they got that from the warranty company saying, this is not warranted, we don't cover that. You think that makes total sense to you?
Yes.
And you agree that we crazy my folks to spend money to appeal the decision when there's no way in the world it's covered.
No, I don't agree with that.
Why would you appeal a ruling that you totally agree, black and white, that it's not covered?
Because there was because of the fence. I mean, they could appeal it and, you know, another arbitrator might have came out there and saw something different.
When you talk about the fence, what about the swell? They're saying water's flooding them from the swell. And it's not working right. And plus now you put a check down, it's making it worse. And the neighbors watch us flooding us too.
I think
That's what they appeal. And they say, no, that's not covered on the warranty. So they spend money and go to the arbitration.
Was the
Yes.
check dam installed before or after the warranty would have expired? The warranty is good for 1 year, so it gets us to
I'd say it was
early
after.
2019. Check dam was after the warranty
I do
expired?
believe so.
Oh, no.
I don't,
Let me give you some data.
sure.
Picture shows, put in place for us in August 15th. In August 18th, the check down was built about the same time. You come back the next year, you put it in that same time, you put in, when you fixed up the hole in the wall, didn't you?
I don't recall.
August of what year?
August 2018.
I don't know, that's why I'm asking.
I don't recall.
Right, well, that, tell me then, you came out there August 15th, 2018, fixed that hole in the wall. Did you come back a second time? Complaints from them to put a check down there, or did they come in about the same, maybe 2 weeks later, but at the same time?
I don't recall when that was done. I recall the next week to 10 days that we came back and we shot the grades to verify that there was positive slope all along his property. And we did that. And there was positive slope.
Right, the timeline support. You did the work on the wall, we got that picture showing August 15th. My client said about the same time we went out and did work in the swell as well. So, did you do work in the swell about the same time to fix the hole, or was it another year later?
It wasn't done at the same time. So like I said, I don't recall the current events of when the check dam was put in, but it wasn't done at the same time when we were there. I know that. I don't recall when it was done. And what I'm getting confused, I took that picture in 2020, so I don't recall that check dam being done right away. I don't recall that. But I don't recall the time.
It's showing it's still there in 2020, but nobody had done anything at that time.
The picture shows that the picture shows that there was nothing done at that time to the fence, correct?
All right. Back to your knowledge, maybe was the check dam ever taken down, so it's still there today?
I have no idea. I haven't been back there since that video was taken. I've never been back to that project.
All right, so you said when y'all punch that hole, you did find that there's some water went through the wall and the carpet, just a minor bit of water, wasn't a whole lot of water.
There was not, it was not wet. at all.
Your testimony, you were here, my client said, we still have problems with the space for turning brown. We have to paint it every so often. It's been going on. Even today in the corner, there's mold or mildew forming. What would cause that?
Well, listen to everybody else. I mean, you got a pipe that somebody installed and you have a gutter that's backing up, and then there's sheer water bouncing on the house that can move up. I mean, there's a lot of things that could be that, but that's not the original issue that was brought to us however long ago. I mean, now listening to the testimony of the last 2 days of, we took a pipe, was the pipe the right size? And if you have large amounts of water, how many are going through it? But if you have water cascading over a gutter, that's a big issue.
The testimony was from day one to March 9th, from April 15th, the first time they reported and installed, there's a water problem before the fence. April 15th, there's a water problem, and it hadn't changed at all. I've been having problems all the time, water flooding my backyard. So today, that could be causing the ground moisture in the house, right? Well, you said it's water coming off the roof.
I'm saying no, they had a clogged gutter and the gutter's cascading, the water's cascading over the gutter and hitting the ground. That can cause issues.
Did things change? It stayed the same when they put the pipes in, the water cast over versus the water just coming through the wall on the fence between the units.
If the water from the neighbor's house, it had positive slope, it was going towards the drainage well. The next issue you're talking about is they had water that cascaded over their gutter because it either couldn't accept that much water because they piped it or it was clogged, is a whole other conversation of water and how it can splash up and get in the house. It's totally two different things.
Yeah, back when you finished and sold the house, we seen pitch that unit 4, there's a fence there, and you had the 2/3 of a pipe that went 2/3 down the patio, and then it stopped, and the water just ran out right there onto the patio.
Okay.
That's how you set it up. That's how water is left at the time of closing, right?
Yes.
And that water, each unit is supposed to flow downhill, correct?
It's supposed to flow away from the house.
So if that spout from the roof goes down, turns, and goes 2/3 away, and water's coming out of it, does the water go under the fence into my client's property?
Does the water go under the fence into my property? Some of it may, yes.
I think yesterday when you said, well, similar association would have connected and extended to the out further and hooked in that pipe. You said, yeah, they did that. I wouldn't have done that. You thought that was a bad idea to connect the pipe into the other 4 or 5 feet into the pipe that put in the ground?
I do believe that, yes.
Why do you think that was a bad decision for your homeowner association?
Anytime you pipe something, there's a chance for clogs and backups. So you always want to do it as natural as you can. This quote, raging river, it's a drainage swell. It's no different than if you're on the side of a road and when it rains really hard, you see water flowing down it more. The drainage swell is a drainage swell. If there's a heavy amount of water running down it, there's a heavy amount of water running down it. It's not like any other homeowner where it rose and it got in someone's house. That's what the swell is designed for, to take that stormwater and take it to a drop inlet.
All right. Based upon that, you would have told them, don't do that and leave it how it was. Keep that pipe on those 2/3 away and let the water run out on the slab and let some go in the fence.
Yes, I would have wanted to run naturally and I wanted to run into the swell.
Right.
That's what the swell was intended for.
The water there plugged the hole, did nothing with unit 4's problem, put the check dam into the swell sometime long. That's everything you did. Or that to solve the problem.
Yes.
And then they said, well, you still have a problem. It's totally 100% in the fence. We're not doing anything else more about it.
If they would have rose the fence and there was still an issue, what I don't understand to this day is why were they so bullheaded about cutting a fence? $150 to send a repair person or whomever to cut the fence what the builder recommended. If something still would have been an issue after that, we would have been there and said, no problem, we'll address it. The main problem is this fence. And they still to this, well, 2020, I don't know what it is today. The fence is still on the ground. There was bags on the ground because water rose up, but they never cut their fence to allow proper drainage. Ibezims, my backyard's a mud mess. It doesn't do this. Well, why? because the fence is on the ground. Proper water can't get out. Now there's trees and stuff around there too. But again, if you're not going to solve runoff and you're encapsulating it, you're going to have an issue.
Okay, and that's what he should have done. So you're solely believe the fence of 100% the problem.
I am, yes. I'm still to this day convinced of that.
And you heard him, maybe you heard, but when Mrs. Smith, the home association came out and said he went out in the rain with umbrellas 20 to 30 times, and the fence had nothing to do with it. That's just a red herring. It's not a problem at all. Did you talk to him about that? Did he tell you?
No, sir.
Did you talk to anybody in the association and say, hey, y'all gotta fix this? They told you, it's not the fence, it's the grubbing work that you did when we bought the place.
No one ever told me that.
Well, he said, Mrs. Smith, that it was horrible at the time of closing when he saw the swell out, it wasn't graded properly. Do you agree that it wasn't graded properly?
I do not agree. It was graded properly. And I never had a conversation with Mr. Smith about that to this day.
Who did you talk with? Association trying to work together. You're putting things in the swell. They're trying to put pipes in and things like that.
So we've really covered a lot of this a bunch of times through your questions of this witness. Can we move to a different area?
Oh, yes, you are.
Thank you.
When you sold that, your carpet in that house was good quality, I said.
Yes, sir.
What type of carpet do they get when those units? As far as what is a 10-year, 30, 20-year warranty or expected life expectancy on that carpet? Yeah.
No, I mean, we give a 1-year builder warranty, but again, I mean, carpets is based on your usage. I mean, you could have a bunch of dogs and cats and or babies and kids that dump stuff on it. I mean, that's if all of a sudden there's a 4-foot square in it where a pet's laid there and the oil's from the pet, that's not a warrantable item.
My clients replaced the carpet 2 years ago. They said there was a smell and mildew. You know if that's true or not?
I do not.
Have you reviewed the June 10th, 2018 El Nino report, especially as you're hired by the association to evaluate
I did
the
not.
situation? You said you didn't know Mr. Duckett.
I do not know a Mr. Duckett.
Mr. Duckett, in his report, El Nino and their report both said the slab next door is a problem. You need to tear it up and fix it. Did it ever come to you that that slab on unit 4, the one next to my client, was a problem and needed to be fixed? Did you ever hear about that?
No,
Both said that. Do you agree or disagree that probably needs to be done?
I disagree
Why would you disagree? You haven't evaluated.
because I know there's positive slope on that slab.
Well, I'm talking about unit 4 we have pictures to show that up under the concrete, the sand, the dirt's eroded out. You stick your hand up under the unit, water floods out of that. Do you agree or disagree that needs to be taken up and fixed?
I think there's an alternative way to fix it. And I don't think it needs to be, the concrete needs to be totally removed.
Okay, and you talk about how bad the fence was. The engineer for El Nino, especially in the licensed state of Georgia, Dr. Spots, hydrology expert, both testified.
So no one testified from El Nino.
His report introduced earlier, and Dr. Spots testified that all you need to do is just realign the ditch a little bit, and it'll go right around the fence. If it's a problem at all.
Objection, that's not what the testimony says.
Well, the testimony is the testimony, and this lawyer has confused it by telling the jury that someone from El Nino testified, which is incorrect.
And further objection is the report does not say that all that needs to happen is to realign.
Okay, but on redirect of your witness, you could explore that. Mr. Stewart is free to characterize the evidence, not claim someone testified who didn't, but he can interpret the report as he sees fit. And the El Nino report is in evidence, so that's something that we can share with this witness, Mr. Dorsey.
I just joined the objection to the extent of Ms. State's prior testimony. Dr. Spots actually testified that he didn't know the fence was a critique, so he didn't include that in his analysis of what the swell may or may not
Okay,
be.
the jurors are going to recall Dr. Spott's testimony as they recall it. Let's get right who testified and who didn't. And next question.
Plans Exhibit 18 was introduced. It's El Nino's report. He gets 2 options. 1, you can modify the fence, or 2, you can just realign the swell and have it go around it. Dr. Spots came out after and says, yes, you can realign, go around. That would be very difficult. Work says to do that, didn't
No, I'm not, we are not realigning. We did not stick a fence in there. We did not, that's not our property. We would not address that. That's if the HOA or the association wants to do that, or the homeowner wants to do that because they're the ones that wanted this fence. And then part of putting the fence in is, hey, you also have to pay to realign this drainage because this is going to create issues. Then that's between them, the association and the owner, not between us, Water's Edge Group.
you? You don't want to do it, but you have an employee or a subcontractor have a bobcat, in just a couple of hours, he could do a realignment around that fence. It wouldn't be very hard to change it slow if you wanted to do it.
Assuming Water's Edge decided to do it, how long would it take?
I mean, I think it would take longer than a day to move that because there's the slope of the hill where in my mind, half the slope has the fence in it. Half the drainage easement has his fence in it. So you're going to realign it. You got to take that hill out and move it. So I think it's more than, it's a good bit of work.
Okay. In the report by Elvino and Dr. Spot says, yes, you can move realign the swell a little bit. You have the equipment, you don't have to pay anything other than for the equipment and the driver to realign it. How long if it took a day or 2 days?
I think you'd have to have dirt hauled off. I mean, you're moving the hill. There's a hill behind that swell. It's not like it just dies off.
So you wouldn't do it, you don't think it'd help in any way? Okay, you hired a gentleman to come pour those slabs. You still have the same subcontractors, I assume, or in contact with them? How difficult would it be to take out the slab in unit 4 and replace it?
I mean, it would be a pain.
Other than to come out there, maybe jackhammer, guy cracks up or one.
How would you get the concrete back there?
Well, you'd have to have a line.
Truck can't do that.
No, you'd have to have a line pump. So you create a line pump to do it. And that's what I'm saying. I don't feel that's necessary. And I think that you could argue that all day long that that's not necessary. Especially there's outfitters, if there is a void or something, you could do there's hydraulic cement injections. I mean, there's just so many other alternatives if needed.
One option would be to go back there and crack it up and have a wheelbarrow and make cement right there, and you can pour it right there and make a patio that's 10 feet by 10 feet.
If you so choose.
Pardon?
If they so choose.
Your board judge wanted to do that, that's something you can do, not much trouble.
We're a general contractor. Anything in a residential, if they needed it done, there's something we could find a way to do it.
All right, we saw that video that you took in 2020. You're showing that the fence is partially in the swell. We also saw right in that back corner, right where the back wall is, a 2x2 electrical box that would be in the swell as well. Did you see that?
It is in it. It is in the swell, but it is also a utility easement there. And it's all part of the common area.
Okay. So when you finished on March 9th, 2018, sold my class, that 2x2 box was put in the swell. Maybe that's what the design called for, but you put these boxes right in the swell.
We did not do that. That's by Georgia Power. That is a Georgia Power. We have no responsibility for the utilities. That utility was there. Water's Edge Group never installed that, never did anything. That is part of Georgia Power.
And do you believe the fact they got these 2x2 and 2x3 boxes in the middle of the swell, that's not good? It's good or not good?
I'm indifferent. I mean, that Georgia Power stuck it there. They know what it was, and that's their responsibility, not Water's Edge Group. You're not dictating where a utility company's putting their stuff. I mean, you're just not.
Yeah, no, they control it. Is it indeed with the water system that's designed in the plans to have a water flow behind this building 30 going to drainage inlet?
As I said, there's as-built with final plats. It shows where that stuff goes. That stuff was designed and built and approved by the county, and it was put there. It's nothing that after the fact Water's Edge Group decided, we'll just stick this here. It's not like that.
Not talking about who put it in, it's bad or good. You believe in your expertise and your experience that having that electrical box right in the middle of the swell is good or bad?
It is not in the middle of the swell, and I'm indifferent. It is where they said it was supposed to be, and as long as Georgia Power feels responsible for it, I'm fine with it.
Not in the middle of it, but it goes out as far as the fence they installed, doesn't it?
It's on the corner of the fence.
But it's as far out in the swell as the fence.
Okay, yes.
And then you talk about the drop inlet, it says it's non-maintained. What do you mean by that?
So when we went back out there, there was just soils and pine straw, and there's just debris around it.
Okay. So who's going to maintain it, right?
That had been the HOA.
Association should be doing more with it. Was it inlet itself, the top or anything like that a problem, or just how to be maintained?
I would say how it was maintained around it.
In your opinion, then, you told me, you recommend tearing down the wall.
What wall are you talking about?
I don't recommend tearing any wall down.
Out, the fence they built, the back wall of the fence, moving out of the swell, that would not have any problems the last 5 years.
If the fence was raised 4 inches or greater, I do not feel that there would have been any of these issues, and we would still not be here. We would not be here today.
And you have zero knowledge about what theater that I have, unit 4 slab, right?
Correct.
Of course, do you believe my class, they say it's still a problem, it's been from day 1 to now, that's not correct.
Repeat your question, sir.
They said from April 4th to 15th, we know there's a water runoff problem before the fence is ever built. It says continue to this day. We still been to homeowner association, been more that it's still a problem. Do you agree that's true or not?
As far as the doc,
I'm sorry, it's not appropriate to ask a witness if he believes another witness.
Do you believe there's still a problem? There's been a problem since April 15th to now.
so April's when they moved in. July is when they put the fence. Let's make sure we're making our timelines correct.
Yeah.
What April?
They moved in March 9th, 2018.
Okay.
They complained.
March, April, right? 2 months after they moved in.
Back up. March 9th, 2018, they closed on the house, they moved into the unit. April 15th, 2018, they spoke to Tolley community, saying, we got a water problem.
A year later.
No, just let me give you all the dates.
You just said 2019.
Yeah.
I apologize.
So that's why what am I?
Okay, so just,
Let me try one.
it's gonna be a long question. He'll let you know when the question's done.
Yes, sir.
Try to make it as less long as possible.
I want to give you a couple of dates, because you want the context. April 9th, 2018.
March 9th.
Thank you. I went, March 9th, 2018 was the closing. April 15th, that's a month later, a little over a month later, 2018, they complained about the problem. May 22nd, 2018, they applied to get the fence. June 18th, 2018, they get approved for the fence. July, sometime first July 2018, the fence installed. So from the time of closing until the fence went in, they should have no water problems at all, correct?
There was correct.
When I contacted Tolley in April, they should make it up.
So again, we don't comment on, he's not asked, you shouldn't ask him whether he believes another witness's testimony. You know that's improper. It wasn't right the first time. It's not right the second time. So ask a question other than, do you believe or find truthful some other witness's testimony?
I wouldn't quote another witness right there, guys.
Okay. I don't know what you were doing then, because that's what I heard.
I got another question.
Mr. McLeod, do you have any redirect for this witness?
Yes, Your Honor.
I need this.
Yeah. Schaumbauer, Mr. Stewart just went through a little timeline prior to the purchase. We built the fence in July. During that time period from the purchase until the fence was built, were you aware of any complaints of water intrusion into the house?
I was not.
What would the condition of the swale have been during that period when there were heavy rains? What would you have expected to see based on your expertise?
In the swell and heavy rain,
Yes.
there would be water rushing, moving through that swell to the catch basin. And that's what it was created to do.
And in your opinion, what would the volume or velocity of water would you have expected it to be in little or wide?
I said it'd be a medium flow. I would say that you could have 4 to 7 inches of rain, of water, of runoff running down that swell, which would accommodate it just fine.
And that swell was designed to operate like that?
Yes, it was.
And when would that design process have taken place?
At development time. So, and then it would have been inspected and finalized at final plat.
So would that drainage swell system that leads to the inlet, would that have actually been engineered as part of that development process?
It would have been.
And would a hydrologist have come out and evaluated that drainage swell? What were those plans to approve to make sure that it was going to handle the volume of water that's going to be put into the swale?
Yes, sir, they would have.
And has your company, Water's Edge, ever developed, completed a development where you served as the developer and the builder?
Yes,
So have you been through that process before?
I have been.
Okay, so you're familiar with all of those processes for compaction
I am.
and for the hydrology. So you understand the process, correct?
Yes, sir.
And I've just handed you what's already been, I think that's been entered as D8.
The fence guidelines,
Yes, the fence guideline.
it's in.
Before I do that, I'm going to, well, let's talk about D8. I think the fence guidelines is here to see that they said. Those fence guidelines require that in order to, for the association to approve a fence, and you can look at them, there's a section in there called drainage. Do you see that at the bottom?
Yes, sir.
Can you please read that for the jury?
New fence construction should not interfere with or change water drainage around the unit as designed by the builder.
Okay. And did the association ever contact you when the fence application was made by the plaintiffs?
No,
What would your opinion have been if they had asked you and shown you the plan for the fence as it currently exists? What would your opinion have been as to whether that should be?
I'd have said that should not have been approved and it would alter the drainage, the drainage easement.
Okay, so you do not think that it should have been, the fence should have been allowed to have been built in the drainage swale?
No, should not have been allowed
And why do you have that opinion?
because it's going to alter the way that the whole system, the whole drainage easement was designed to perform. And by putting that fence in there, you've altered the performance of that swell.
Okay, and you've heard Mr. Stewart talk about, well, that's an easy fix. We'll let them put the fence in and all we'll do is we'll just simply move the drainage swell around that fence. Do you think that would be as a practical matter, would that be feasible?
No, not at all.
Okay, and I'm gonna, we introduced some pictures of D38, any objection to be published in, please?
If they've been admitted, you can publish them. Okay.
Okay. Voila. Okay. Mr. Schunkweiler, do you recognize this picture?
I do.
And tell the jury, or I think everybody is fair to say, is this the plaintiff's fence?
It is.
Okay, and so as we're looking at the picture on the left side, closest to us, you can see the fence running. Is the fence running towards the drainage inlet?
Yes, it is.
Okay, so that's the corner of the fence where the water comes through the swale and the fence is partially located in the swale. Looking at that picture, what do you think in your expertise would have been required to move the swale, to leave the fence and basically realign the entire drainage easement around?
So that's what I was saying is it's not a little job. I mean, you'd have to clear all this and this is a hill that's climbing. It's steep. So in order to do that, and you've taken half the drainage swell and you have to go back one or two houses to gently get it to go around, that's a major ordeal. I mean, that's a lot of work and earth moving.
How much earth moving? You see there's a tree line there.
Mhm.
Your expertise, would this involve the moving of trees?
Oh yeah, you'd have to remove a bunch. I mean, you'd have to go, and that's the thing. Then you're just talking a whole bunch of other questions because now you're cutting it into a bank. So you have a shear cut. You have to address that. There's this not just.
In your expertise, is it possible that a retaining wall at that point might be required?
Yeah, I think that they would have. I mean, you have to. You can't have a shear cut. It has to be a 2-to-1 slope. That's code. So if you're going over a 2-to-1 slope, you have to retain.
So in your opinion, if the engineering report said, "I would just move it as well a little bit around there," and there was no recommendation to remove these trees, build a retaining wall, would that have worked?
If they didn't,
If they did not do those things, would that have worked?
no, they would have to move those trees and add a retaining wall.
So in your opinion, you couldn't just dig out a little swale right beside the fence and then all of a sudden the problem is solved?
No, the county wouldn't allow you to do that.
So we're talking about perhaps we're changing permitted drainage easements and plans.
Yes.
And so is that something, would you dare to do that?
No, and the cost to hire an engineer to go do that and go through the county to get those permissions is a long time. It's not a go walk in and get a permit.
So in order to do that option, you would have had to have gone and gotten a permit from WEG.
We'd have had to alter the final plat.
You couldn't just go out there and do it.
Not moving that far back to accommodate that fence, no.
So really what we've got here at this point with the fence, keeping the fence there and not cutting it up is a pretty big problem.
In my opinion, yes.
No further questions.
Mr. Dorsey.
No questions.
All right. Mr. Stewart.
Oh, yeah, no, more.
Ladies and gentlemen, here's how we're going to work this. I would like you, if you have any questions for Mr. Schonkweiler, to write them down. And then you're going to get your morning break while the lawyers and I review your questions. Don't run away until I get all the questions. And then when you're done with your break, we will ask those. I will ask those questions of Mr. Schonkweiler. So jot down any questions you've got. And Deputy, if you'll collect those and get them to me, please. We need to get you hand warmers. Thank you, sir. Guys may get about a 50-minute break. Number of questions here. think we got it. We're going to have our break now. Jurors will go back there. Mr. Shankweiler, you're welcome to step down. We'll bring you back in when we're ready to go with the questions. Thank you. Counsel, I'll see you around.
Thanks, sir.
We don't have seats. I have seats.
Stretching.
Right there.
It's probably draining the battery.
No, not on the phone, sir.
It's free, that's.
Yeah, right. No, man, it's fine. No, man, it's not. Oh, you don't know, this guy's a God-fearing man. Okay. Let me help you out. Let me help you out.
So I'm just trying to get the most. Cheers. So you should just. Stadium.
You can look real quick. We're in there. So it's this fence right here. And I was sitting there yesterday. Yeah, they had that bracket down there. Yeah, but it's still.
We'll have to reinforce it when everybody's here, but right now, they don't need to stay.
Nobody's sitting in it.
Okay.
Nobody's sitting, everybody knows. That little bracket ain't until full mine.
We'll have to get some, you know, we'll see. Thank you.
You're welcome, that's great.
To answer questions, right? Just to answer the questions. Yeah. Don't talk. Yeah. He's gonna try to say, "Oh, guys."
I don't know, I wasn't there. No, it's not as much.
Yeah. He'll take that shot.
Then I'll just roll back up here.
So, I don't know, if we got in.
He's like, it's what it is, man. It's so he's nuisance thing. And that's how he likes his money. They do. So you should see. Especially, I think it's one of those trees, I think they have to step on. All that right there. All the trees are. Okay. So what you're saying, the issue is this problem with the homes. What it is.
That's
See, I don't know. It's a 6 inch.
I mean, I can show you.
Like no. And that's just good. That is funny. Yeah, exactly.
Good old military.
Good old boy. Really, actually. Still hasn't. There was a area in the back that was big training. They made it crazy that people metal down square. So the water would pass through. Yeah, like chicken. Not chicken, it was bigger. Oh, that. Yeah, some big squares, yeah. So the water came through, but it did keep people from going. Wow. Yeah. It was no, this was not a problem. No, I'm saying unbelievable. He wants to put the first. Oh, 31, yes. This year, yeah, they're not in this one. Yeah, in that season. She asked, no, this is low. So, yeah. And sustain that. I think the black. Part of the unit. That's why they say slabs. Unit. Was part of the unit. Because it's there. What is it? Because you know the so you should right. You know, condominiums, you got on facings and stuff, you own everything under the foundation. Depends. I don't own necessarily, like you don't own decks. Yes, you do. Someone, yeah. But you are responsible for that. You're not even, aren't you responsible?
Yeah.
Only the payment. No, not you, the owner is responsible. But when you actually own the land under the deck, is it finished?
The landowner deck is. Hello. So, I mean, it's really depends on each, how we're building, whether like that.
No, I have to see, that's what I said, I have to see.
And we get, it's all kind of the foundation, you know, things sort of.
Well, I-
Court come to order, remain seated.
But we're not.
Are they all ready to come back? Let me see if we have all our lawyers. We do. Great. Can we get back on the record, please?
On record at 1 AM.
All right, Mr. McLeod, you're looking for the two photos we talked about? Okay, just let me know while I'm going through the other questions if you find it, and I'll ask at the very end as well. Let's bring the jurors back in.
Going for records?
This is a lot of questions. You're scratching some itch for them.
So what?
All rise, observe, please.
Thank you, sir. Welcome back, ladies and gentlemen. Just trying to organize this wealth of inquiries. Why don't we do that? Just give me 1 second. Okay, and you have the same picture for both. Excellent. Thank you. So, Mr. Shankwaller, we're going to start with the picture that is on the screen. Two questions. One, if you look at the fence closest to us, so not the Ibezims fence, that's the complete fence, but the thing jutting out by the pad there. First, how far out does the fence extend? Does it go beyond the pad or to the very edge of the pad?
So our fences only went to the edge of our pad. Whoever's fence that is not us.
Okay, assume for a minute that that's the Ibezims fence.
Okay.
I understand you didn't build that, but I don't have a touch
I'd say
screen.
it's 8 feet.
Regardless of how far it is, the fences that you installed,
Yes, sir.
Water's Edge installed, are coterminous with the patio pad.
Mhm.
They do not, you need to say yes or no.
Yes,
Okay, they don't go beyond it.
no.
Got it. I think there was some confusion earlier about that. Second, we see two downspouts that appear to then be integrated into whatever drainage system the HOA installed later on after these were built. Why are there two downspouts that appear to come from one building? I thought it was one downspout per unit.
So what they could have done is they could have connected the other downspout from that unit and had a turn on it to run them both down at the same way. It's not, I don't believe it's two downspouts on one unit. The unit's only 24 foot wide. So,
Okay, I know we can't see, this photo doesn't give you that angle, but
well,
there
what
are
it
not
does,
two downspouts for a single unit.
no, not that I'm aware of. But if you see the other one, you don't see a downspout on that corner of that home there. So I'm assuming that it's the other unit. They're together
Okay.
and ran down the wall.
That they just channeled two separate downspouts all the way to this ingress to the new drainage system.
Yes, sir.
Okay. Question about the check dam. There's the check dam. Pine straw not disturbed beyond the check dam. In other words, the flow, the grade towards plaintiff's house. Pine straw seems to be missing in an area immediately before the check dam. What does that tell you about what the check dam does, flow of water, et cetera, if anything?
No, it does. It's telling you it's slowing it down, and that's a silt deposit. So there's some silt on this hill that's come down, and that it slowed the water down, and then it created a silt deposit. So the check dam is doing what it's supposed to be doing, slowing it down.
Thank you. You can take the picture down, Mr. McLeod. When Mr. Smith testified, he talked about dirt mounds that were behind their trailer, meaning the trailer you all had. And you mentioned there was the construction trailer where the four-person had his office, whatever it was. If you were only doing vertical construction, why would there have been dirt mounds behind your trailer?
I don't recall that. Again, we didn't move any dirt. So if GeoSim did something in that back section while we were up in the front section, I wasn't paying. It had barricades there. We didn't go back there. So I wouldn't have done anything. And I know we didn't do anything because we had no budgets for development. We had a house budget, and our profitability was based on a house budget.
Do you know how involved the inspections are that the county or municipal engineers would have done to determine that grading is proper throughout the development? In other words, some guy comes and that looks good to me, or they get those, you mentioned some tools that you've used before. Do you know what's involved in an inspection that would yield a CO?
Yes.
For grading purposes?
Yes. So first off, those inspectors aren't engineers. They have a CABO or some type of certification. They're not a licensed engineer. Some of the people that are in the development field that come out, those guys are engineers. So as far as thoroughness, I mean, typically each inspection takes them 20 to 30 minutes, depending on what inspection it is. They do walk through the house. They do open and close and make sure that it's to a industry standard that they've adopted.
Okay, I didn't ask the question well.
I'm sorry.
But hold on, this just in. Okay, I know it's cold in the courtroom. Oh, okay. Okay, thank you. And you can decide at lunch whether you want cold or hot. That seems to be the two options that we've got in the courtroom, because I've asked. Sorry, Mr. Schunkweiler.
It's okay.
I was referring to the inspection that would have occurred to yield the plat. So not you've built and people are coming in and make sure there's not a hole in the roof and it's not too cold.
So
It would be that swale, about which we've spoken so much, satisfies whatever the code requirements are. in Gwinnett.
So they do what's called as-built. So the plans are approved through Gwinnett County, and then tractors arrive, developers arrive, they develop the ground. Then when you're finished, you have to do what's called an as-built, which means the surveyor comes back with and surveys everything, and then it goes back to the engineering company and they verify that all those calcs are right. Then they submit those to the county to say, hey, these all match. And the engineer stamps it, he's a PE, and then there's other documentation that's done, but then they do sign off, and we as builders are able to build on the property.
Explain to the jury what due diligence, if any, Water's Edge engaged in to confirm that the drainage design that the developers had done remained up to code. And if you didn't do any, why you didn't do it. Does that question make sense?
It does.
Because, and to put it in context, as we've all discussed, all that work by the developer is a decade old when you are arriving to scrape some soil off to make sure that the pads are ready for the concrete, et cetera.
It does make sense.
Okay.
So let's just talk about building 30 and what due diligence. And when you're looking at a final plat and you're looking at the pads, if the pads had been washed away, then there would be a concern there. But the pads had steps to them. And then the slope in the back, as you can see on the pictures, has the same follow. If there was a big pile of dirt or something in that, then that's something that we would raise to the developer saying, hey, this isn't right and you need to fix it before we're going to come on site, because we don't have the financial budgets to do it. So that would be the due diligence that we did.
So this is the walkthrough you described. If the dirt pads were hilly, or there were like what looks like a little river that had been eroded into it, that is a clue to you to say to Geosam, from whom you're buying it, hey, we're interested, but it's clear that drainage is not working here. With no building here, it's still not working.
Correct. Or these weren't fill lots, but sometimes, developers balance dirt out. You have a big pile of dirt here and you have a hole here. Well, then they take this dirt and put it in here. They have compaction letters for every single pad that they do. We don't ask for them because it's certified into the final plat. But if there's a big cut lots, we would ask for the soil compaction letters. This wasn't the case on this property though.
Okay. So is it your opinion that the original drainage work, not pipes, but flows of water that would have been designed by the developers and approved in the platting, worked properly prior to you building the buildings?
Absolutely.
And then, in your opinion, did it work properly prior to the installation of the fence?
No, it did not work properly after the installation of the fence.
Prior to the installation?
Prior to the installation of the fence, it worked properly. And can I continue on that? Or?
You can, because I'm going to ask a follow-up on that question about prior to fence,
again,
post fence.
There are homes upstream from this gentleman's. And if there was an issue, there would have been other issues in other homes. And there's not. And out of the 800 homes we've built, there's not been one foundation issue, and there's not been one issue where negative grade has backed water into a home. Not one in 15 years.
So, given your answer, how do you explain, if you can, that assume for a minute that the Ibezims had begun complaining to the HOA or to Mr. Tolley, to the management company, Backyard Realty, before the fence was installed? We've got water issues. So the fence is installed. There are still water issues, as we've heard. how do you explain that window of time? We've moved in, there's no fence, but we're having water issues.
It was not documented. We have no record of that.
Okay.
We-
So if
we-
it happened, it wasn't brought to your
It was
attention.
not brought to our attention. If it was brought to Tully's attention, I don't know, but it was never brought to our attention.
Okay. But I assume for purposes of my question, that there were complaints made that there were water runoff issues into their yard before they put their fence up.
No.
No, I'm asking you to assume it. You can't say, no, I won't
Oh,
assume
I'm
it.
sorry. I'm saying you were telling me there was.
No, I'm saying assume for my question
Uh-huh.
that the Ibezims reached out to the property manager and said, look, we're getting water into our backyard when it rains before the fence. How do you explain that, given your firm conviction that the fence was the issue?
If there was,
In other words, the condition predated the fence.
we would have addressed it, but it didn't have backflow. So I don't see how it wouldn't have been an issue.
Okay. I think you've answered this. I think it's slightly broader. I think you said you have had no, across all the units built that Water's Edge built at Mill Creek, no foundation issues.
That's
other
correct.
than here.
That's correct.
Okay. Across the projects you were building at that time, how frequent or how common are foundation issues?
None. We've never had one. Never.
The warranty that Water's Edge Group sold, first of all, was it Water's Edge that provided the warranty?
Yes, sir.
Okay. And did the home buyer buy the warranty? So if the home was $219,000, then it was another $1,000 for the warranty?
No.
Or part of the purchase price included the warranty?
Part of the purchase price included the warranty. Water's
Okay.
Edge Group paid for it.
Okay. I mean, in theory, the buyer did, but it wasn't.
It's not a line item on their closing statement. It was a line item in our budget.
Okay. Included in the 219, if that is the price, if I was paying all cash, included in the 219 is the warranty.
Yes.
And the warranty that Water's Edge provided for every unit at Mill Creek was QBW,
Yes.
not 210.
Not 210.
210 is an actual product.
Right. It's like saying Rubbermaid, but you have a Tupperware bowl.
Okay. So if
Same
someone's
stuff, but it's not Tupperware bowl.
got it. If someone is talking about a 210 warranty for Mill Creek properties you built, they're mistaken.
They're mistaken. We provided a quality builder assurance warranty.
Typically, before a mortgage will be issued, the lender wants to make sure the property has been inspected. There's an inspection and often inures to the benefit of the buyer as well.
That's correct.
What is your understanding of what type of inspection, if any, was required either by law or by the lender in this case?
Well, by the lender, they did have a FHA loan. They're gonna have an appraiser that comes out there and they're gonna inspect the house to make sure that everything is done. Landscaping's done, appliances are in, and it is move-in ready. They are not gonna give a clear to close from the lender if landscaping is not done, one appliance is missing. The lender will not sign off and will not fund it. So that was done, whether they had an inspector, a private inspection, our agents say, if you want one, it's fine. We just need the list 48 hours before we do the orientation because we want to address any issues prior to, and that when we come to the orientation, we can talk about it. We're not taking a 20-page paper and trying to go over yes or no, or this code related or not.
So there was an inspection, but it was paid for by,
The homeowner
okay, they had to pay for it, but it was for FHA purposes.
for financing purposes.
Okay.
There's an appraiser that comes to all the lots unless it's a cash buy. Then they have the right not to pay for an appraisal or not. But if it is any type of loan, it doesn't matter if it's an FHA or a conventional, an appraiser is going to come out and review that property.
And you've mentioned the appraiser would have looked at landscaping. Would the appraiser have made at least a visual assessment of the drainage system?
Absolutely. If the appraiser saw, let's just use this. Let's say there was backfall and there's a pile of mud and dirt sitting on the patio. The appraiser is going to take a picture of that and say, hey, we got an issue here. And I don't want to, because they represent the lender. They don't represent the builder. So they represent the lender and they're going to want to make sure that that lender is protected. And if there's a major issue that they see right up ahead, they're going to note that and it has to be addressed prior to closing.
And the unit that the Ibezims purchased had been upright and in a position to receive water runoff, if it was receiving water runoff, for how many months before that inspection would have occurred? The closing's on March 9th, 2018.
Yep. So you're saying how long before we had all these rains? So at least 2 to 3 months, this house was getting rained on, water run, before they moved in. And there was no issues.
If I were given the option, I know this isn't this case, to buy either a QBW or a 210, which has broader coverage, or that's apples and oranges and you can't compare?
No, Ian and I, we went through this, and Ian can talk a little bit more about it. But the main reasons why we went with QBW is it's backed by Western Mutual, which is a huge billion-dollar company, and 210 is a more local-based company that could go out of business or could not go out of business, even though they're very prevalent here in Metro Atlanta. If you go to other, I almost said countries because you're other counties or municipalities, like Nashville or something, they might not be there. Where you can, on QBW on the front of the book, it says backed by Washington Mutual. And to me, that makes the homeowner feel more comfortable. Like, wow, there's a big monster bank that's backing this, that they're going to be around. If we leave or we, whatever, there's some grit behind it.
If there was a warranty issue raised by a home purchaser, is that something, I don't know who Ashley is.
She was our warranty coordinator.
Okay, so she was a Water's Edge employee?
Yes.
All right, so I bought a Water's Edge home and now there's some water coming in. I get Ashley on the phone. Does Ashley say that's covered, it's not covered? Or what is her role in ensuring that my warranty concern gets to QBW?
It never goes to QBW unless there is a dispute.
Okay.
99.5% of all warranty issues, there's a portal, goes into the portal, it's emailed. Ashley then sends it to the project managers. Our project managers have 2 weeks to respond. If they don't, and Ashley doesn't have, hey, this homeowner's been contacted, works in progress, then it comes up in our construction meeting. Then they get held accountable because there's bonuses that they get paid for based on the warranty. The devil's in the details. I want to make sure that every homeowner, after the sale of the home, that the project manager, we didn't have warranty coordinators as far as service techs that go out. The PMs had to take care of that. So, and they wanted to take care of it because there was financial reasons for that. So Ashley, back to your question, QVW was never involved unless there was a homeowner dispute.
Okay, so to unpackage that a little bit, when you were describing that there were vendors who came who said, we're not comfortable based on the interactions we had, those would be responses that your project manager and his subs or her subs were trying to take as a result of the warranty concerns that the Ibezims effectively pushed through Ashley.
Yes.
So at some point, we've seen there was a letter delivered to the Ibezims that says, this is covered, this not. If you disagree, you have to appeal, which gets you into arbitration. Does that letter come from Water's Edge or that letter comes from QBW?
That letter comes from QBW. Water's Edge has no clue what that letter says until they receive it.
Well, why would QBW be sending a letter to them if it never goes to QBW? Your team is handling. Ashley is making sure that the project managers go deal with it. How does it get from that level, Ashley managing it, to QBW sending a letter saying, we're going to cover this, we don't think we're going to cover that. If you dispute that, appeal.
So we fixed what we said we were going to do, and we said we were done. They disagreed with that. So therefore, once you disagree with it, we don't say, well, that's just it. We say, okay, there's QBW, they're the arbitrators. If they come out and deem that we need to fix it, we will go take care of it. Gladly go take care of it. So this is where it got escalated. We addressed what we felt we were obligated under the warranty to do. They felt there was more. They went to QBW. QBW then went out there, and then they sent that letter saying, this is what's done. This is not what we're going to do. Whatever they said we were going to do, we went and did.
So level one, you kept it in-house.
Yes,
my
sir.
Terms, not satisfactory to the customer. It's explained to the customer, then you go to QBW. That's level two. QBW did some work, so that's all we're going to do. And then level three would be that arbitration through the appeal, but
They didn't do it. Correct.
they didn't do that in this case. Thank you. At orientation for a new home buyer of a Water's Edge home in the Mill Creek community, is there information given to the home buyer about the fact that this is an HOA community.
That's the sales agents. And I'm assuming they had an agent. And that's another thing. Their agent had to have told them that they were represented that, hey, there's an HOA, here's the guidelines. If you have an agent, that's the first thing they're going to talk to you
Okay,
about. So I don't know.
We don't know.
Oh.
That person, no agent here right now, but when you say sales agent, that's not a Water's Edge employee.
We have in-house, well, Berkshire Hathaway was our sales, in-house, I won't say in-house, they're not. Berkshire Hathaway new home sales sold the homes at Mill Creek Lakes. We had a person, I don't know if it was a male or female, we had a sales agent on site in a model home. They would have set those expectations.
All right.
Not the
But
construction.
Assume for purposes of discussion, it's a guy named Charles. So
Okay.
Charles is in the model home.
Yep.
He actually is a Berkshire Hathaway employee.
Yes,
Okay, not a Water's Edge.
no,
But what you're sharing with the jury is that it's your expectation. You don't know, but it's your expectation that Charles would have told any would-be buyer, excited, love to show you this model home. There's a homeowners association.
they would have.
That explains the pool over here.
Saying the
that you
pool,
could use.
they would not have said it. They would have said, this is what the low dues are. And also they know those dues way before closing because they have to get pre-qualified. And part of the pre-qualification is, let's just say the house mortgage is $1,000. Well, they got to pre-qualify for 1,200 because the dues are 200. And that's part of, it's not like a utility where I can manage it. It's a fixed cost. So they knew what those HOA dues were way before they walked into closing. Now, whether they forgot and they're excited, that's a whole other conversation.
Have you installed check dams in any other communities or other parts of Mill Creek?
In other communities I have, yes. Not in, that was the only one we did in Mill Creek.
Okay. And do you hire did you hire a contractor to install the check dam that we saw in the picture?
We did.
Is there a county code or municipal code that governs the distance that a swale should be from the building that it is serving as the drainage buffer for?
I'm not aware of one, but I don't know that. The only thing I know is there's building setbacks off of property lines. I don't know.
Did Water's Edge have any knowledge of the homeowners association guidelines at Mill Creek about how far out fences could go from the structure and how that might intersect with swales?
No, I was surprised there was a fence in Mill Creek when we first started there. I don't think there was maybe one fence, and it was during the downturn where someone just stuck it in. There was no fences, so he was one of the first ones. I can't remember of any other fences that were installed.
Okay. I meant to complete the check dam questions. I left one out. Who at Water's Edge made the final decision that what we need to do to address some of the water runoff issues is to put the check dam in?
That would have been me.
Did you at some point reach out to Mr. Tolley about the fence?
I did.
Did you ever receive a call or any communication back from Mr. Tolley?
Not that I recall.
And your communication to him was the fence is an issue?
Yes.
Okay, and you don't recall any, we don't think it's an issue, or we agree, or you just don't recall any feedback at all from Mr. Tolley?
I don't. I think that if I had to recall it, I would say that after that, we had a construction meeting with Ian and Ashley and I, and Ian would have helped me in that regards of sending an email out. Is how we would have delegated that.
You could explain to the jurors again, Water's Edge owned and thus sold pretend it's a square, the square that is the four walls of the home, or also a few feet into the backyard so that it included the patio slab and the remaining rectangle that would then make it overall a quadrilateral?
From my understanding, we have the house and the concrete patio outside of the home is the owner's property. Once you step off that patio, it's common property. It's HOA. So in the world of condominiums, if you want to walk your dog behind those people's property on a leash, behind their homes, you technically can. It's common property. It's everybody's. But the patio itself is owned by the homeowner.
So if I was sitting on my pad on a lawn chair, some neighbor 3 units up couldn't put his lawn chair on my pad as well, saying, hey, this is common area,
No, but he could sit his lawn chair technically in the swell and have a beer and
get washed away.
get washed away and no one could say anything. Or get on a kayak. I mean, whatever.
No. Was having a fence installed, not just that one segment that we've seen that extends only to the edge of the patio slab, but I guess something that would encapsulate the little bit of the backyard. Was that an option that you offered to people who were buying units?
Never. We never offered any fences, nor would we.
Did Water's Edge ever reach out to the purchaser of the adjacent unit that had the concrete slab? So this would be a unit uphill, where there were water issues for the Ibezims coming from that concrete slab.
So no, we never reached out to them. But when I was there, I didn't feel those homeowners had any issues. They had a downspout that was on their property. We extended it and it ran out. So I don't feel at that time. Now, after piping and all this other stuff they did, there may have been an issue. But at the time that we were there addressing issues, I don't feel their property had any issue, had a direct effect with the Ibezims home.
Okay. Can you call up Mr. McLeod as our photo guy? I think it's from the Almenia report, a picture that would show us, if you're facing the back of the Ibezims property, the left-hand corner. So it will show the neighbor's slab and then the hole underneath it. You know the picture I'm talking about? The Almenia report is plaintiffs 18. So you may not have, well, I know you've got it, but because we've seen it. Okay, if you'll pull that up. While he's pulling that up, did Water's Edge ever inquire of the homeowners association who was the fence builder? In other words, what company, and try to work with the fence installer to get the fence adjusted in any way?
No.
So can you explain to the jurors, and this will relate to the picture in a minute, you described work that Water's Edge did to inject hydraulic cements into some place, and that was going to deal with a concern that the Ibezims had brought to Water's Edge attention. Orient the jurors and me, because I think I was confused as well. What hole were you filling with hydraulic cement? Was it underneath that slab of the neighbors, or was it part of the foundation of the Ibezims unit?
So if I'm looking at the back of the house, the houses are like this. There was a void on their house at the bottom. It was about a 3-inch high, 1.5 inch wide gap that where the slabs broke down, you could not broke down, step down, you could see a void where this firewall was lower because of the step down. And we then treated that with a waterproof material.
Did you then put a board over that, or it was
No.
simply the injection of the hydraulic cement?
We never put a board over there. We never would do that.
Okay, not this picture, one that actually shows the back of the house. So it shows some siding, and that's perfect. So see where that arrow is pointing?
Yes.
Is that where you injected the hydraulic cement?
Up against touching the house, not.
So you use this touch screen.
Yes,
so
sir.
You know how to make it
I
work?
got it. We got it. We got the technology.
No, don't move anything right now. Let's let him mark it because it'll change where he marks. All right, but up against the house
Up
and
against the
not
house.
laterally underneath that slab.
No.
Okay, there is a picture in evidence somewhere that relates to work that was done to fill in underneath that concrete slab, and then there was a board put over it. That's not Water's Edge work?
No.
Okay. Last question from me, and we'll see if there's any follow-up. There were pictures shared with the jury, they're now in evidence, of what the sheetrock looked like when, sounds like you were the one, removed the baseboards.
Yes.
and the sheetrock was not intact. There had been some damage to the sheetrock, or at least it wasn't smooth. There were pits and holes and whatnot. Assuming that's how it looked, what I heard, the question is, why would the baseboards, new baseboards, be put on without addressing the defects in the sheetrock? It wouldn't be visible once the baseboards were back on it, but it wasn't nice, smooth.
It's not going to be. You can remove any house. When the baseboard, when the house is drywalled, it's drywalled, and the bottom of the drywall, it can be kicked. It's finished. When we put the baseboard on, if you notice, when you pull the baseboard off, there's no paint behind that. It's not painted. It's the trim goes on, it's caulked, and then it's finished. So the bottom of it can't have holes in it or be beaten up because it was never finished by a drywall finisher. It stayed in a rough stage.
Okay, so it's cosmetically imperfect, but that you're saying if you pulled baseboard off any of your units,
Yeah.
you'd see that it's not pretty and finished and smooth because the baseboard covers it.
The baseboard covers it, and it's not finished. The drywall's not perfectly finished until after the trim goes in. So you have trim, you have called a trim point up. So the drywall man comes back and punches that all out, because a trim guy, he's not paying attention where he's swinging, long pieces of material. He hits the wall, it puts a dent in it. The guy comes back and touches all that up, and then you start your final paint after your trim is done.
Okay. Mr. McLeod, you're welcome to take the picture down unless you've got questions involving that. Do you have follow-up questions for Mr. Schonkweiler?
I do.
It's now by default a slow question because you haven't asked it yet.
Ending, Mr. Schultz, listed on 39. Will you take a minute to review that and see if you're familiar with that document? Take your time.
Okay, yeah.
Okay, you're on to introduce 39.
39 or 9?
39.
Oh,
39.
No objection.
no objection from Mr. Stewart. Mr. Dorsey?
Okay.
39 is admitted.
Mr. Schultz,
Yes, sir.
this is an email from Ashley Miller to Ashley Miller to the plaintiff, Mrs. Ibezims. You're copied on this email, correct?
I am.
So what I want to do is, this is in response to an email that Mrs. Ibezims had about trees that were located behind her. Correct?
It was.
And so at the end of that, well, in the second paragraph, you can see it's saying regarding the trees you mentioned, our company removed all trees within a reasonable distance of your home or building. Is our stance that any growth or maintenance would be considered an HOA responsibility, correct?
Yes, sir.
If for some reason there's damage, your HOA should be covered by the insurance policy, blah, blah, blah. However, this would not be deemed a builder responsibility. Though typically when an owner installs a fence, it is their responsibility to clear any areas that would be affected by the installation of the structure, right?
Yes, sir.
Okay, and then below that, there's been some question about the warranty process. And I think this making clear to the plaintiff in June of 2018, I think that's the day of the email. So this would have been June 28th, 2018, after they closed, March, May, April, June, 3.5, coming up on 4 months after closing. And so actually, at the very bottom, just wants to let Mrs. Elizabeth know there is a warranty process. And so she provides her with, because our company is dedicated to fulfilling all commitments to be transparent. Copying Mike Tolley in on this email so that all parties are aware, clear of our stance, and the items that are outstanding as discussed. I'm available by email or phone. And should there be a warranty concern, they can be submitted by the warranty portal, which is explained in the welcome folder that was provided in closing. I'm hopeful this answers your concern. Should you have any questions, please don't hesitate to contact us. That's how y'all responded to the tree complaint, correct?
Yes.
Okay. Prior to, and there was no complaint about any water in this June communication, correct?
Not that I'm aware of, no.
I'm gonna scroll down to the bottom. You reviewed this whole email.
I
correct?
didn't review the back pages. My apologies.
Well, take a look, and I want you to do the respective recollections for us.
Okay, I'm sorry. Okay.
Okay, so on June 26th, on the very back page, Mr. Colleague asked me, she was just trying to figure out, like, hey, I'm a new homeowner. We're building a fence. There are some trees that might impact that fence. We were putting up a fence and we were concerned about the branches falling and other environmental concerns with these branches. We need to find out who we can speak to. And if the HOA is not responsible, then what are our options? So she's trying to figure out who is responsible for addressing her tree issue, correct?
Yes.
Okay. And then if we scroll up, Mr. Tolley responds, right now, you are still with Water's Edge. Please contact them about this, as they should have cleared that area for you. And so Water's Edge disagreed with that conclusion.
We did.
And so in response to those concerns, Mrs. Ibezims, I'm sorry, she's still confused. Mike, when you say I'm with Water's Edge, what do you mean? Do you mean is the HOA responsible for the long grass tree maintenance? So she specifically asked, is the HOA responsible for the maintenance? Mr. Colleague responds, the association is responsible for landscaping. Water's Edge built the unit, had the responsibility to make sure the trees were clear. If you're telling me that they're in a position that could damage something, they need to be brought into this conversation about the trees. And that's what precipitated Water's Edge's response from Ashley Miller, right?
Yep.
Okay. And so just to be clear, y'all are making clear, not our responsibility.
Not moving it. It's common area. We were not touching those trees.
Okay, and then you were also making sure that Ms. Doesn't understood that she had a process for any warranty items, and y'all provided her with how to access that process.
Absolutely.
Were the trees that would be closest to the Ibezims property line, the trees that we saw outside the fence that you were saying would need to be removed if this swale were magically redirected? I guess it would be to the right if you're looking
Right.
down the swale.
Mhm.
Those would be the trees closest to, they were kind of close to the fence, but closest to the property.
Correct.
And then with respect to any other complaints about water intrusion, you didn't receive any complaints like this one or forwarded to you from Mr. Tolley or the association or anyone for that matter until after the fence was built.
Correct.
That's all I have.
Mr. Dorsey, do you have any questions for Mr. Schunkweiler? Mr. Stewart?
2 minutes, yeah.
All right. I love it when you say that. You've been 2 for 2.
Sir, I heard you testify that March 9th, 2018, they purchased this home, things were perfect. Swell was working properly, there was no problem at all on the day they bought that home. Is that your understanding?
Yes, sir.
And so you had done everything right up to that time, correct?
We felt we did everything right. Yes, sir. But the house was 100% ready for him. It was move-in ready for them.
You
Yes,
agree that what you bought from GeoSam was perfect too, they didn't do anything wrong, correct?
correct.
Wells Fargo, who owned it before, well, for GeoSam bought it from them. Wells Fargo didn't do anything wrong, did they?
I have no idea what GeoSam had to have not corrected. I wasn't a part of that. I wasn't privy to that. I bought from GeoSam.
You understand the fence was his sole problem. Wells Fargo had nothing to do with that, correct?
Wells Fargo had nothing to do with the fence.
Your belief is 100% of the fault is what the fence did, not what GeoSam, Wells Fargo, or you did, correct?
Correct. The fence is the issue.
And the same with the developer. The developer who built this plan and got the lots ready, they did a great job. You have no complaints with what you received from the developer that went through the bank, went to GeoSam to you.
I have no issues with it.
No question.
All right, Mr. Schonkweiler, thank you for your time. Ladies and gentlemen, we're not breaking for lunch yet, just to manage your expectations. We're going to get in about 20 more minutes of testimony before we break. I have to go to a meeting in the building. The reports I'm getting from our support squad is that your lunch will be arriving between 12:30 and 12:45. I also have asked if there is a way we could have not Sahara Desert or Arctic, but normal with the temperature. We'll see what happens. But the request has been put in to try to have it be somewhere in between so that our technician doesn't have to wear a parka in the courtroom. I wanted to actually send a picture, but I didn't. Oh, yeah, I still got it on to prove that I was serious, but I didn't. Mr. McLeod, still your case. Call your next witness, please.
I'll call Ian Silverstone.
Okay, Mr. Silverstone, you are retaking the stand. We're going to swear you back in because this is a separate round of questioning. And ladies and gentlemen, Mr. Silverstone has already testified. It's perfectly appropriate for a different party when presenting its case to recall a witness. Mr. McLeod is under very clear instructions that he is not to ask questions he's already asked Mr. Silverstone before, because you've already heard those answers. All right, Deputy, if you'd swear Mr. Silverstone in.
Raise your hand for me. Please swear affirm the testimony given in the court today the truth, the whole truth, and nothing but the truth, so help you God.
I affirm.
You put your hand down. Have a seat for me. Please state your name and spell it for the record.
Ian Silverstone, IAN, and SILVERSTONE.
Silverstone, I'm handing you a series of documents. Will you take a minute to review those and see if you're familiar with those documents?
Do we have an exhibit number?
There's several exhibit numbers, and after he reviews them all, I'm going to introduce them all so we can do this very quickly.
Well, as long as Mr. Stewart and Mr. Dorsey know which ones are up there, so they're not going to say, wait, I need to see those. They know?
I'll know what they are with no objection. They'll come in.
Well, boom. Mr. Dorsey?
Yeah.
Okay. It's fine for Mr. Silverstone to look at them so he knows what he's talking about. But once you give us the numbers, I'll say the magic language.
Yes, I'm familiar with them.
Try to keep people from falling asleep.
Wait till the temperature goes up. It'll get really bad.
Okay, Your Honor, I move to introduce exhibits D1, D2, D3, D4, D5, D6, D9, D10, D12,
They are all admitted with no objection from plaintiffs or Mr. Dorsey's clients.
Thank you. Mr. Silverstone. When did you first learn of the lots being for sale in the plaintiff's community?
Probably 2016, maybe 2017.
And what was your understanding of the lots for sale that you were looking at to buy?
Well, we were approached by GeoSam and asked if we were interested in pad ready lots in the condominium association.
Could you hold the mic closer to you?
Sure.
You are-
Sorry.
Yeah, it doesn't move, it bends, but it is bolted
Okay,
down.
I'll just
So
sit closer.
you actually move closer to it.
So
I have to try to hear you all the time. I can understand you. So if you could speak up to the jury.
it's okay. I don't understand myself either.
If you would, when you talk, you can talk to the.
Okay.
So just to tell the jury about the project, what we were doing.
Okay, so as I said, GeoSam approached us 2016, 2017, asked if we were interested in purchasing pad ready lots, which was very attractive to us because it means you can start building immediately. So we said yes. We came up with a letter of intent, which would have covered the things that we needed, that we were not responsible for common areas, that, you know, that we, yeah, basically not responsible for common areas, that all the pads had been prepped before, were compressed, etc.
Because they were offering to sell you pad ready lots.
Mm-hmm.
Yes.
Yes.
Yes. And was it your understanding that you would not be purchasing any of the common areas of the association?
Yes.
Did you do any due diligence to confirm that fact?
Yes.
Which fact are you asking? That they were pad ready or that he was not buying common areas?
First, did you do any due diligence to confirm that they were pad ready lots?
Yes.
And then did you do any due diligence to confirm that you weren't purchasing any of the common areas?
Yes.
Tell the jury what things you did to do for your due diligence.
We would have read through the covenants to see, you know, what responsibilities we had, what if there was any maintenance responsibilities, etc., and ensured that the HOA was responsible for maintenance of the property. We also would have looked at the plats themselves to ensure that they were going to go into the association. What else would we do? We would ensure that the deeds belong to the appropriate people, so that GeoSam had the deeds and they were transferring those deeds to the HOA, and that we would have nothing to do with that transfer. That was between them and the HOA. So that when, at the time that we finished a unit and the common areas were done, that was something that would be worked out between the HOA and GeoSam.
And did you do that in this particular case?
Yes.
Okay. And so Exhibit D1, these are the covenants of the community.
Yes.
Okay. You can hold on to these if you want.
Okay.
I'm going to take just a few minutes and read these to the jury.
Yeah, good luck.
Was there anything in the covenants that required the builders to provide any maintenance obligations on the common areas?
No.
And do you recall reviewing the plat to the condominiums?
Yes.
And do you recall if there were any notes on the plat regarding who was responsible for the maintenance of the HOA areas?
Yes, there was, on all the plats, there was a note to that, if that the HOA was responsible.
Okay, and the plat that is marked for D2, there was, that's for phase one of the community. That didn't have anything to do with the plaintiff's residence, correct? That was an earlier phase.
Correct.
But the plat that's been marked as D3, it's titled Mill Creek Lakes Phase 2. And
Yeah.
That is the phase that involved the plaintiff.
Yes.
Right. And do you recall if there was a note on there that spoke as to who was responsible for the maintenance of the common?
Yes.
And do you recall who it said would be responsible for the maintenance?
The HOA.
And I believe in note 23, I'm going to read this for you guys rather than try to pull it up and highlight it and take 10 minutes. So, but these are going to all be in the record. You're welcome to fact check me, like I said earlier. But note 23 says recreation area will be owned and maintained by homeowners association. Do you recall that?
I do.
An open space must be deeded to and maintained by a qualified homeowners association.
Correct. That was very important for us to do the deal.
Why was that?
That's because if the HOA is not maintaining that area and there are any problems, then that comes back onto us. And so it's in most deals that within HOA, you want to make sure of what their responsibilities are and what, if any, we have. Also, we wanted quick turnaround, so we didn't want maintenance, landscaping, that kind of stuff.
And in your title search, did you also confirm that the party you were purchasing from GSM, did you confirm that they actually own property?
Yes.
Okay. And what I marked as D5 was a deed under power of sale. And was it your understanding that Portrait Homes had owned the property prior to GSM?
I did.
And this deed under power of sale, that's a foreclosure deed.
Yes.
Okay. And so Wells Fargo, who took title to the property?
Wells Fargo foreclosed on Portrait Homes, and subsequently, and then subsequently it would have gone to GeoSam. I don't think there was another party involved, if I recall correctly.
And so Exhibit D6, that is a limited warranty deed from Wells Fargo to GSM.
Right.
Okay. And then as part of D6, there's also an assignment and assumption of declarant's rights from Wells Fargo to GSM.
Correct.
Okay, what is your understanding of what that assignment and assumption of declarant's rights, what legal effect did that have?
That means that GeoSam had taken the declarant's rights, or basically the HOA. So I'm not sure the state there is. I recall the HOA was currently working with GeoSam to assume all of the rights, but they were now the declarant or fully responsible for all common areas at that time. And they were handing it over as units were built to be fully managed by the HOA.
So is it your understanding that GSM took a deed to all of the property in phase 2?
Correct.
And is it your understanding that GSM also took an assignment and assumption of the declarant's rights for all of the common areas of that property?
Correct.
Okay.
Again, that's important because we don't want to manage an HOA in that particular project.
And then exhibit, sorry. Then exhibit D9 is a limited warranty deed from GSM to WEG Green Investments. Is WEG Green Investments one of your affiliated companies?
It is.
Okay. And so WEG Green Investments took title to the phase 2, including the plaintiff's building pad, correct?
Correct.
Not the common areas.
No, just the building pads.
Did any Water's Edge Group company or affiliated entity ever take an assignment and assumption of the declarant's rights?
No.
GSM? Then in With respect to Exhibit D13, that is a quitclaim deed of gift between GSM Capital US, Atlanta LP, and Mill Creek Lakes Condominium Association, Inc. Are you familiar with this document?
I am.
What is your understanding of what this document is?
Let me just make sure I understood it correctly. It's GeoSam to the HOA, correct? Yeah, so this is the GeoSam when they quitclaim the property or the common area around so they quitclaim the common area to the HOA at that point in time.
Okay, and what's the date on that document?
I was trying to figure that out. I think it's 18 February 21.
Is that the recording date on it?
That's the recording date, yes. Did I miss a date?
No, that's right. That's the date it was recorded. So that would have been prior to Mr. and Mrs. Ibezims purchasing the residence that you sold them, correct?
Correct.
So at the time of the sale to the WEG Mill Creek sold the unit to the Ibezims. This deed, what is your understanding of who is responsible for the common areas behind the units?
The HOA.
Who would have been responsible to maintain the common areas prior to your purchasing the plants building ready pad building 30?
GeoSam.
And then after the quitclaim deed of gift that we just spoke about, Exhibit D13, at that point, who would become responsible?
The HOA takes it on.
You finish my question.
Oh, sorry.
Upon execution and recording of this quitclaim deed of gift, who would have been responsible for maintaining the common areas?
The HOA.
Let me see the covenants. There's actually, are you aware if there's a covenant that relates to that?
Relates to what?
Relates to the HOA taking control of all the common areas and being subjected to the declaration.
I would assume there is because we did the due diligence, but I don't recall.
Let me see if I can. What, will you read that paragraph of the declaration to the group?
Okay, this is an assignments by declaration. All rights which are specified by this declaration to be the rights of the defendant are assignable, mortgageable, pledgeable, or transferable. Any successor to or assignee of the rights of the declarant hereunder, whether as the result of voluntary assignment, foreclosure, assignment in lieu of foreclosure, or otherwise, shall hold or be entitled to exercise the rights of the declarants hereunder as fully as if named as such parties herein. No party exercising rights as declarants hereunder shall have or incur any liabilities or acts of any other parties which previously exercised or subsequently shall exercise such rights.
Okay, that's a lot of legalese that it's hard to understand what that means. But was it what was your understanding of that provision?
That once you've assigned the rights, the whoever receives them.
Right. So your understanding that once the deed had been executed to the HOA, that provision they've been responsible.
Yes.
For maintaining the common.
For maintaining the common areas.
What exhibit number was that?
This is D1, and that is.
Okay.
Page 43, the last section, section 32. Mr. Silverstone, you contend that the third-party defendants that you brought into this case are responsible for the damages caused to the plaintiff's residence. Is that correct?
I do.
Okay, what do you base that on?
Well, firstly, with allowing the fence to be built. I mean, that was a major faux pas. I believe in the original declarations, as I recall, and no fences were allowed in the community. It was subsequently modified to allow fences under certain stipulations, one being to ask the builder. And I think you heard Trevor testify to that we would not allow a fence in that area. If we were to say that there could be a fence, we would have asked them to wait for the first year so that we could make sure that there were no problems with drainage or anything, or roof water or anything like that, because all of that stuff will occur in the first year.
You mentioned that the declaration prohibited fences from being installed. I want to refer you to section 16 of the recorded declaration.
Okay.
It's titled decks, patios, fences, and sheds. And the whole provision reads, a unit owner is prohibited from installing or causing the installation of any decks, patios, fences, or sheds on the condominium or common elements. Only those decks, patios, fences, and sheds installed by the developer and the association are permitted.
Correct.
Is that the provision you were referring to?
Yes.
Mr. McLeod, we're going to need to stop in a minute. I'm not rushing you. Are you at a natural break point or are you almost done?
I have no further questions.
Woo. All right. I didn't know that. That was not staged.
Well,
Okay.
that was easy. I'm going to miss this chair.
Okay, but you're not done.
Oh, I'm not done?
In fact, I got two questions.
Oh, just a sec. I was actually to see, Mr. Dorsey, are you going to have questions of Mr. Silverstone? Okay, well, let's do your 2 minutes. Take your 2 minutes.
Two questions. See the clock?
Yeah.
Isn't it true that hot and delicious pizza supposed to be at 12:30?
I'm sorry, I didn't catch that.
No other questions.
Okay. All right. Mr. Silverstone, you are free to step down.
Thank you.
Right, juror questions. You're not free to step down.
Oh,
I'm gonna need to send an email. I'm gonna be a couple minutes late, but let's do that. Take your time, write your questions. I'm not trying to shortchange anyone. We've got some prolific questioners, so do that.
Actually happened. This is the first one.
There's some more. There's some. In there too. You named it too, and how many notes?
Thank you. What are these general questions that aren't for the witness? Yeah, like how are we gonna get answers for questions that aren't for the actual witness? Yeah. I have no answer.
All right, counsel, come around. You're right back. Stay right
Like
there.
I sent one in for Trevor. That wasn't exactly for him, and they didn't get an answer or didn't get asked. So I'm like, Yeah. Yeah, I know. We're not typically discussing, we're talking about what we were doing, yeah, procedures. We're not in contempt, you're in contempt. Yeah, I've got like 4 or 5 for Mike if he gets back. Yeah, I'm guessing the second defense, I'm guessing they're gonna call him back up. Same with hopefully the president too. I mean,
Over 10 hours and 10 hours. Maybe.
well, we'll get into it hopefully this afternoon or Monday.
I'll be.
We're trying to hint at the case, but we're not trying to discuss.
I'm not even listening. But you can sign that you're on the side.
You know, I'm gonna ask when the judge gets back. I'll just be the one. I'll just do it.
I guess once you go in, once we deliberate, you can ask, you can send questions out.
Can you?
I think so, because we did that when I was there. We sent some questions.
Oh, okay.
I think so. I think you would. Unless they change the rules, but we did, we sent some questions out. But you can ask the judge to be.
Yeah, I might as well.
But you see, actually, I don't have send a note to the judge.
Ooh, that's good. That's a good idea.
You send a question to the judge. That's how you get your question answered. Send the question and it's directed to the judge. And when you ask this Officer Williams.
Do we get answers to questions?
You add another jacket when you leave?
Witness.
I don't know
why. I do have a Peloton. I'm not gonna take this. I have a bike. I ride the bike. Where did he go?
Dang it. Is he over there?
Yeah. You want to?
What's his name?
William.
Deputy Williams? Can you give this to the judge? It's not a question for this specific witness. Yeah, it's a question for the judge. Huh?
She said we up to something.
Order, man, see?
Thank you. Mr. Silverstone, who is responsible for common areas at Mill Creek during the warranty period that the warranty you sell to a buyer is still active? So if the QBW is good for a year, who's responsible for common areas? You, the warranty company, or the HOA? Or someone I didn't think of?
The HOA.
HOA. So warranty has nothing to do with responsibility for common areas?
No, warranty is just specific to, and as it relates to the house.
Okay. You shared with the jury that the contents of the covenant and who was responsible for the common areas, et cetera, was an important element in your decision to buy the property from GeoSan, the property that you did buy. Did your review of the covenant show you whether there was any language about building fences or not.
Yes, the covenants disallowed building fences by homeowners.
So we had a fence built in this case. We've heard about it. We've
Yes.
seen pictures of it. Do you know if the covenants were amended to allow that fence or if that fence is inconsistent with the covenant?
I believe that the covenants were amended at some point. We actually weren't made aware of that, but they did allow for fences under certain conditions. One of the conditions being that they would consult with a builder.
Were you consulted in connection with the construction of the fence at the Ibezims lot?
No.
There's a question about the quitclaim deed. You introduced about 500 documents. Was there only one that was a quitclaim deed?
Yes.
Okay, if you could get that, get me the exhibit number and then get that for Mr. Silverstone. I think it's 13. It's the only one I've got that says quitclaim on it.
Yep.
That's 13?
Yep.
Okay, and Mr. Silverstone, first, tell us what was being quitclaimed to whom under 13?
Can I just read the paragraph?
Do, not a memory quiz.
Thank you. This deed made the 16th day of February 2018 between.
Oh, I don't want you to read it out loud. That's a lot of legalese.
Oh, okay.
Read it to yourself, but my question
I got
first
you.
is, who is getting what through this quitclaim deed?
Okay.
And I don't want Mr. McLeod to answer it for you. Okay, you're just
Short surveying is a legal description.
great.
I don't think you wanted me to read the legal description of the land,
I
but
don't want you to
basically
read
this is the
anything
common
out
area.
loud.
Okay.
The question is,
So
what did that do? The quitclaim deed
the
did what?
quitclaim deed transferred the property from GeoSam, all the common areas from GeoSam to the Mill Creek Lakes Condominium Association.
So common areas, swale, streets, parks. Went
Everything.
from GeoSam to the HOA.
Yes.
What's the date of the quitclaim deed? When was that recorded?
Well, it was recorded in, looks like 21, but the date of the quitclaim is 16th day of February 2018.
Say it one, because those last two digits are the important ones and I couldn't hear you.
16th of February 2018.
February 16th, 2018.
Correct.
GeoSam quitclaimed to the homeowners association, the common areas.
Yes.
You said that in this development at Mill Creek, Water's Edge did not want to assume responsibility, the HOA responsibilities. Does that mean that in other developments, Water's Edge has served as a homeowners association and assumed those responsibilities?
Yes, we've served as the declaration and established the homeowners association in other communities.
Keep going.
It's not something that we want to do. We prefer to buy from the developer, and the developer normally has that responsibility. But during the recession, we had to do what we had to do, and being a developer was part of that reality.
But when you could avoid it, your preference was to be a builder and you sell the lots once they're developed, meaning something is constructed on them and you are not involved with covenants, homeowners association, et cetera.
Correct.
And at Mill Creek, that was the situation.
Yes.
What would have happened in this case if you, in fact, had been the declarant and were responsible for HOA matters at Mill Creek and there was this water issue?
Then we would have been responsible for, as the declarant or the owner of that property, we would have been responsible for it. But we weren't. The declarant, this was a community that hadn't been developed by us. It was a distressed community, had been developed by Portrait Homes many years prior to us. And we would never have taken on the project if we had to be part of the declarant rights, because there's a lot of legal stuff that has to be done, and it just wasn't the type of thing that we do.
Given your assertion that you were not the declarant and thus not responsible for the common area, how was it that Water's Edge installed the check dam, which appears to be in a common area?
Well, we have to touch the common area at some points in the process, like making sure the swale is done, that, you know, that the swale works properly, etc. That's pretty normal. I mean, if the HOA didn't like what we did, then they could have just said to us, we don't like what you did, and told us to move it, and we would have. Generally, our relationships with the HOA is pretty good. You know, some HOAs will tell us, if you're going to do something in the common area, you need to tell us. Others will say, do what you need to do, get it done, you know, make sure it's working, etc. In this particular case, this is not something that we had any influence over. The homeowner refused to follow up with warranty and give us warranty calls. The HOA, I guess, did some stuff that they on their own. They allowed the fence into the property. That, I mean, based on all the other buildings, and I'll just use the 6 units in building 30. None of them have water issues. The only one that supposedly has water issues is the unit number 5. And that also probably caused any damage that there is to the slab, which I haven't seen, so I don't know.
The Ibezims unit is not the lowest unit of the slope. There's actually a unit below theirs.
Correct.
You're aware of no water issues with that?
No one's reported any water issues to us at all.
Mr. McLeod, any questions for Mr. Silverstone based on those? Mr. Dorsey?
No questions, Your Honor.
Mr. Stewart?
No, Your Honor.
All right, Mr. Silverstone, thank you for your time. You can step down.
Thank you,
And
sir.
any documents you were handed, just leave there. The lawyers will clean them up.
Okay.
You just get your water bottle. You got something in your hand, so you should leave it there.
On this,
Yes, please.
Oh,
Right there.
okay.
You don't need to worry about it. Great. Ladies and gentlemen, we're going to break for lunch. The pizza is on its way. I don't know exactly when it will get here, but soon. And one of the 2 pies has meat that didn't come from a pig. I don't know which 2, but hopefully it will be obvious. I'll ask, but we were able to accommodate the request. So hopefully you guys can figure that one out.
There's two pies without pig.
So go back there. We'll get you back in here when we are able to start back up. Ms. Brown-Williams, I need you to sit still, please. Everyone else.
All right, little George.
So I asked, we have a question that either
All right, Ms. Brown-Williams, I want to make sure we accommodate your situation. You all can be seated. If we stop 5-ish, I don't mean 5:30, but if it's 5:05 or 4:55, that'll address your need?
That's perfect.
Okay, you just wanted to make clear, this wasn't a night we're going to 6:30 because maybe you were deliberating would work. I'll protect you from that. So I can't promise 5:00, but if it's close enough to 5, you're good.
5:05.
Okay, good to know. That's our tolerance range. Thank you so much. You bet. All right, Mr. Stewart, anything before we break for lunch?
Oh, Your Honor.
Mr. McLeod
No, Your Honor.
and Mr. Dorsey.
No, Your Honor.
I don't know exactly when lunch is going to end because I need to let them eat the pizza and it's not here yet. I will know more. I got to go be late now to a Zoom call, but I'll know more when it arrives. I think you'll know because they'll have to come in through here. but let's assume it would be sort of a half hour after it is here. Do you have the pizza? Yes. Excellent. So let's try to be back here by 1:15. Okay. Thanks. We'll go off the record. We need to figure out which one doesn't have pork on it. There are two, and I wasn't trying to be flip with them. I just didn't know which one. So if you can make sure Ms. Hansberry is able to identify either to you or to them, one of them has pork and two of them don't have meat at all. But if you could take care of that. Okay. Thank you. Maybe they'll give you a slice if you do that.
Everything good?
And then yeah, no, that's cool. I just basically.
Get my mask.
Yeah.
Yes. You want me to get you something?
Absolutely.
I'll go. I work for food.
You work for
I
food.
work for food.
I got a lot of work for you then.
You guys need.
There we go. Hey, y'all made it back. So y'all gonna.
5 days, 4 days.
Oh, y'all, that's where y'all be. There you go.
We don't have much time.
Yeah, you don't have much time. That is survey. Brought from home.
That didn't require much cooking. No, it's cooking to me.
Well, like I told her, I'm actually. She was going to the office. I'm saying, oh, hell yeah, I have so much today. Yeah, that's good.
You want the same as usual?
It's fine. Whatever works for you.
You can have whatever.
I'm a omnivore. I was just ordering lunch. Through the client wanted to know what I wanted to eat. I said, I'm an omnivore. I eat everything. Are we set up on Wednesday, Tuesday?
Eyeing that house for years.
Really?
It's really nice. Looks like a really nice house.
It's pretty cool. It was a COVID.
Okay.
Well, we matter of courtesy, we invite her. She really didn't have much to do. Yeah, but apparently Waits has got his knickers in a twist about Leah. So okay, all right. All right. All right, that's fine. Okay. All right. Anything else going on? Okay, all right, good. Okie dokie. Well, we're breaking for lunch and we'll see how long we go today, and I will talk to you later in the day. Okay, bye-bye.
What is he normally?
You want anything, a hamburger, Subway,
Get you a hamburger.
any old thing.
Okay, I'll see you guys.
Media opinion.
This is a question. This is. I guess. We got. Larry's not there. And the, with that portion. He's probably gonna get lots of checks.
Yeah. Yeah.
No, I didn't do that. It is. But it does.
Sorry. Yeah. Oh, really? Yeah. 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 Something that's been. Yeah.
Yeah. Yeah, exactly. This Friday. It's cold and. Yes. Yeah, exactly. Some success.
I'm wondering if the absence of wall has any effect.
I think it does because the swale is supposed to be located. It's permanent. We've had this hill, we heard the Trevor said that he said that the dirt would have to be cut, come back here. And so if you think about it, here's what happened. Do you notice that wall comes to be built?
Big bucks.
So well, let us argue. This was phased. They did.
Yeah.
She is involved in that expresses. He's not going to verify.
Yeah. Sure. Yeah, is anybody going to say that? I think that contributed to the variation absence of the wall.
This is an issue for the jury. If Dr. Split said that he testified that this will actually.
It's worth it. It can't hurt. Outside can hurt. It may take.
They say. Sorry. That's a. But man. Make a claim.
Yeah.
It's been a while. If that failure is contributing to a nuisance.
First of all, I'm not convinced as well. I haven't heard any evidence of anything. But if there is, I'm not convinced what the cause of it is. Just rainwater that can't escape and back because of the fence that backs up. Is the water in the swale? That's not
getting. You're talking about the patio block?
Mm-hmm.
Yeah, that's what I always said. I think there's two separate issues. And think that was never the first complaint. It's generally. The flooders was part of it. It was just a swale issue. They thought that there should be so much water. It wasn't Thanksgiving in your house.
And trees were gonna knock their fence down.
And it was back. Did you do it?
Yeah. Well, somebody has to look at the plan and say that wall in there. I mean, her, because what the county told her 80 years ago. But if you, her letter, and then somebody looks at the plan who knows, says that wall in there. And it should have been there by the developer.
So the proof says.
Can't she say the wall in there?
Okay, so.
Too. If you get her.
You brought some with you, right? About that, think about that. I don't know if I have. But there's water. I'm gonna use.
Yeah. I don't know that. That may give her a chance to talk more about it. He told the jury no next time. I think that she's testified.
His name, like, so. Bugs because of, but anyway.
My dad, if he argued, starts to argue about it.
It's not going to tech scales.
Well, keep Charlie. Yeah.
My friends say my dog, my wife's usually 3 dogs. Get up with it. Take them out early, but I don't know why they get up. But I try to put it back in the bed. So Lizzie, it's about time. She didn't pay me to. So it's hard to go to sleep and wake up. So I just give in. My wife says you're still. I just got this from sleep, so I take her down. Feed her, let her go outside to do business. She comes back. Bugs used to come there as well. Now he just sleeps right through the night. I had to put down King Charles. It was the first King Charles. Cancer. He already lived. Even if he corrected it. We have a dragon. One night.
All right. Here's a client who wants me to send a demand letter to the other party for $25 million.
Sure, those there.
Good, 1:15.
In 2 minutes.
We don't do that. I'm gonna let them know real fast. I will. So.
What do you have in the Super Bowl? What do you have in the Super Bowl, Chiefs or Eagles?
And you know, I want a little cheap, but the people in it.
Yeah. Eagles, man, where's that?
Adler, Marvin, Bell.
Well, he got to go home and get over that injury. He still played all right. Had an injury.
Well, since we got ladies.
Well, let's go to option 3 because that didn't really have to go say 3.
No.
But it's crazy.
Went out, got something.
What'd you get me? Yeah, so you went showing on us. You don't feel like it.
Yeah.
Yep.
Over age.
Oh, wow. Never read those right now.
Oh, yeah.
Are you from?
My dad.
That's, oh,
Yeah.
From here.
yeah, I'm from here. Oh, well, she's from up north. So I'm more of a college now. And so I make her.
Sound like that was.
Yeah.
I joined the team.
Yeah. We went to the Falcon Steelers. There were more Steelers. It was like 80% Steelers fans.
And my chief. Yeah, he get like 6. See them to get over the hood. Some game, he like, man, I ain't gonna get. So they take. I appreciate you, chief.
Oh, that's really nice.
I don't know. Tom Brady leaving, so
Yeah.
might be able to do something else.
Yeah. I'm ready to leave. So.
He's okay, right? He took over.
Yeah.
But is he retired or he going? Because I heard he's going to be going to him.
Oh, I think he said he retired. Yeah, like he's done.
Okay.
Yeah.
That'd be good, man. Send somebody that don't work here.
Does everything.
He had. And you see the LeBron ticket
Oh, for the
basketball game that's coming up?
60. I think he needs like 60 something.
Yeah, he needs 63 points. So that ticket's going for like 92,000. Wow. Just to see him break the record.
Yes.
He's not gonna even break it.
Yeah. If he doesn't do it.
I said, oh. Yeah.
I think he's gonna do it next Thursday.
Yeah.
Here's LeBron, though.
It might just get out of the way.
Yeah. Oh, really? Yeah.
Yeah.
I think from LeBron does that. Because Brady, LeBron, baseball.
Yeah.
Yeah. There's a stretch, these offers and cedars.
Yeah. it's about young, so I'm not saying thing with young life. Next 3, 4, 5 years.
Yeah. I think it's gonna be big out for the Memphis Grizzlies. He could really do.
Oh, yeah, all right.
Yeah. I like watching him like games and stuff. I don't know, compare them to trade in the jobs for the team. Like, trade. Yeah. Just, he's done, like, the city's done a lot for him.
Yeah.
It's just,
But what's the new buddy they brought in? Murray or Mark?
oh, Javante Murray from Spurs.
Good.
Yes.
I ain't even like that.
A 6'7" guard. Yeah. That would be new face of the franchise. Hopefully. They have to tell the Hawks gonna take.
It is legit big man though.
Who's that?
It is a legit big man.
Yeah. You don't think Big O could do it?
They go and get the White Howard, go and get full seeds, bring them back.
Why not bring back J.R.?
Well, I had seen something on the internet, I don't know how true, but they said J.R. Sweeney was golf in college.
Yeah, he's a golfer. He's really good too.
For real?
Yeah, J.R. Like you can do, like they have stories on it, so he's actually really good at golf.
Yeah, I seen that he had went back to school and he was on the golf team in college. Like,
I'm gonna tell you something crazy. He had a 4.0 his first semester. JR. He made some crazy stuff on the court, but he's supposed to be like a really smart guy. I just remember that finance. I hope I'll perform around.
Wolf down your lunch.
Those are the kids, but it's spicy. I really don't eat too much of that. I'm forced right now because my wife usually makes everything. I eat outside, get stomach ache, and as soon as I go home. I had no choice down here this week.
You know, they're still eating quarter after. Where would you start to eat out there, quarter after? Pie and then.
See, I don't watch the Warriors. I mean, they're a great team, I just, their games. Oh, yeah, Warriors. They're a good team.
Yeah, last time they told you, they fixed it up better now. They fixed a lot of tracks up.
Fixing what? On the trucks?
Yeah, and that's not that big. They fixed it. Like that Coliseum, it's tight.
Yeah.
Like that Coliseum. In California.
That's coming this weekend, right?
I think so.
6, so I've been keeping up with the travel. Yeah, this weekend.
What's the new gym with the Gen 5 cars?
Yeah, they just.
Yeah, a lot of people can't things like hurt. Bush got hurt. Kurt, he retired off of them.
Yeah, it's one of my drivers in that competition. They repaid the ladder last year. It hadn't repaid in 20 years, so you know, it's getting back carefully behind. It's a big dilemma because they don't repave it because when it's not paved, you get a lot more wiggle. When they repave it, it's hard to pass. So it makes it more boring. But that's when they went and made it more steep like Daytona in Atlanta. And they narrowed the track. That was scary.
Yeah, I'm going with the Jordan team. I'm going. I think they got Gradson now. Noah Gradson to be the new full-time driver from over there. because Kurt is not there, it's gonna be Bubba and Denny's the owner. He still races under the other people.
Oh,
Yeah,
I remember one.
so he's the owner of 23 Jordan's brand.
you two them all together?
They bought it together, partnership. He was mad, he wasn't mad last year, but he was like,
No, thank you.
because that's why I think he helped Bubba. They said they helped Bubba. He said he didn't let him win. The second one he won. He said he let, everybody said they saw he didn't let him win. You know what I mean? Because he gets a lot of benefits of it. He's a part owner, but the owner got mad because it's still racing for him. And, you know, other people win.
Saw that. Everybody got mad last end of the year. Bubba didn't get-
Court come to order.
Didn't warm up in here. You able to get us back on? Yeah. Before you do that, can you check, Deputy, see if their jurors are close to being done with lunch?
Okay.
Thanks.
We ready, Judge?
Great. Okay. We're not quite ready for them. Let me canvass the lawyers, but we'll get started in just a minute. Let's get back on the record, please.
Back on the record, 1:25 PM.
Mr. McLeod, do you have more witnesses you're calling?
I do, just a couple.
Okay. Couple as in two?
Two, maybe three. So
Okay.
On the fence on one of them.
On the fence.
But one of mine will be literally just.
It can be, they're gonna be as long as they are, but they're here. We're able to move through the rest of your case. Okay,
We will be finished today.
okay. Mr. Stewart, anything we need to work through right now from plaintiff's side?
Oh, yeah.
Mr. Dorsey?
No, Your Honor.
Okay. One of the jurors gave to the deputy a note that says this: to judge, how do we get answers to questions the witness or no witness is qualified to answer? So I intend to answer the question by saying, you get the evidence you get and you do not conduct outside research. Any issue with answer to that effect, Mr. Stewart?
Oh, yeah.
Mr. McLeod? Mr. Dorsey?
No, Your Honor.
All right, great. Let's bring the jurors in, please. If you could have your next witness on warm standby and not far away. You don't need to call the person yet, but I alerted building management that that bench is,
Came up, I showed it to her.
oh, good, excellent. That was,
All rise for the jury.
thank you, Deputy. You all can be seated. Welcome back. Ms. Hansberry told me, that's the woman who delivered the pizzas, that the boxes were clearly labeled, so no one was running a risk. Is that good?
Thank you.
Thank you.
Thank you so very
Thank
much.
the chef at Rose's. Although I did pay for it, so you can. Couple things. One, you guys have begun to become barnacles in your seats. You should feel free to move around a little bit, but if you found the right spot, I guess you can keep your spot. But if people are wishing they could sit in a different spot and someone won't move for them. Second thing, I guess it's third. I was handed a question, an anonymous question from the jury by the deputy that says, how do we get answers to questions the witness or no witness is qualified to answer? Fair question. I will remind you that you get the evidence that you get in here. You do not conduct outside research. If you've got a question in your head that you've put on a card and it's not asked of the witness, it's either a legally improper question or it falls outside the parameters of the evidence, you get to ask questions, you don't get to call witnesses. So you're going to receive the evidence you receive based on the decisions that the lawyers here make. Don't let your desire to have a question answered that hasn't been answered prompt you to violate the cardinal rule of no outside research. Okay, thank you. Mr. McLeod, your next witness.
I'm gonna call Mike Tolley.
Mr. Tolley, come on up again.
Have you already been sworn in, Judge? I need to swear.
No, he testified a few days ago, so please do swear him in. Thank you.
Raise your hand. Do you swear in front of the testimony given the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, please. Please state and spell your name for the record.
Mike Tolley, last name Tolley. And I'm getting to stare at myself again. Good. It's worse than a mirror. Had peanuts, didn't have time to run out and get anything. I didn't get the pizza, you know?
Well, we'll make you a juror next time.
Maybe I'll skip the pizza.
Yeah.
I'm putting in front of you, exhibit D7. We're familiar with that document.
Yes.
No objection.
Mr. Dorsey?
This is the management.
D7 is admitted.
Mr. Tolley, is this the management agreement between you and Backyard Association? Excuse me, between you and the homeowners association during the period relevant to this lawsuit?
Yes.
Okay. And please tell the jury what your obligations were under this community agreement, community management agreement with the association.
Okay. Our agreement with the association is basically we come in and we work with the board. We collect the assessments. We meet with the board and the board decides, like, say, hey, you know, the buildings are getting older, they need painted or something like that. We'll go out and get quotes from vendors, do all the dirty work, basically the best way of saying it, and bring the quotes and stuff back to the board, submit that to them. We're kind of like, you know, the boards are all volunteers, so they have day jobs. And so we're the kind of getting the emails and handling all that stuff during the day.
I believe Mr. Smith described you as a worker more than anything else. Would you agree with that?
Grunt, yeah.
So not so kind terms. But in paragraph C here, basically, you were hired. One of your major responsibilities was, and this is according to standards acceptable to the association. So you're basically acting as the direction of the association. Is that fair?
Yes.
Okay. To cause the common areas of the properties to be maintained according to standards acceptable to the association, subject to any limitations imposed by the association, or subject to any limitations that are in the declaration of restricted covenants, correct?
Correct.
So that means the common areas are supposed to be maintained according to the declaration of condominium, correct?
Correct.
All the covenants contained there.
Correct.
Okay. And you're not actually located on property, correct?
No, we're only, according to the contract, we only come out once a month.
Okay. So you're not there generally walking around identifying any issues, is that correct?
Correct.
And you're not responsible for doing inspections on the common areas to see what needs to be maintained either, are you?
No.
Okay. And in fact, I think at the back of this agreement, you have a bid specification list that you guys agreed to.
I do.
Okay. So let's look back at that. If I can get through it. Okay. And so these three boxes, these three check boxes, these are alternatives for the services the backyard was either providing for the association, that would be the boxes that are checked here, correct?
Correct.
These were services that, for an additional fee,
Correct.
you were willing to provide if they hired you in addition to what was already in your contract. They would pay you an additional fee, is that correct?
Correct.
And then this third box, that's the not my responsibility,
Correct.
correct? Okay, so, and in section 5 here, where we're talking about the reserve analysis. Explain to the jury what the reserve analysis would be.
A reserve analysis is basically the same thing that a lot of people do on your house. The association, think of it as your house, right? You have a roof, you have a lot of things, and you know at some point it's going to cost you money, right? So the board, the association has a lot more of that, like the pool, the clubhouse and all that. So they go out and get a professional company to come in and look at that and figure out how much money they have to put away each year to hit that target.
So, right here it says under 005A, one of the options that you could have provided was to review the existing reserve program through the reserve specialist, and then 0005B, review common area assets and facilities and provide annual recommendations for reserve funding. You have that with respect to that box. That's nothing that you do, correct?
We're not qualified to do that. So if they want that done, we would go out and find them a company that does that.
So with respect to any drainage systems in the community, and in particular, the drainage system behind the plaintiff's residence, it wasn't your company's responsibility to determine whether or not there were any issues there. Is that correct?
No.
Okay. And you didn't in fact make those such inspections?
No.
Who would have been responsible for doing that?
If that would have came up and that had to be done, the board would have said, hey, what do we do? And we would have went out and got like a geoengineer or somebody like that to talk to the board about it and figure it out.
But just in terms of generally identifying issues that might need to be repaired in the community, that wasn't your responsibility, right?
Right.
Whose responsibility would that have been?
I'm not 100% sure about.
The association's responsibility?
Yes.
Is that the board of directors' responsibility?
Yes.
They might have contracted it out to someone else, but it's not Backyard Realty's
Correct.
because of that check.
Correct.
Ultimately, under the covenants, isn't it identifying any inspection or maintenance issues? Isn't that the responsibility of the association, in particular the board of directors?
Yes.
Given that, would you agree that with respect to maintenance of the plaintiff's drainage system behind their unit, would you agree that that is the maintenance responsibility of the association?
Yes.
Okay. And would you agree that we just talked about the quitclaim deed that came over in February of 2018? Would you agree that those duties arose upon the recording of that quitclaim deed?
Yes.
I have no further questions.
Mr. Kyle, do you have any questions?
No question, Your Honor.
Mr. Dorsey?
No question, Your Honor.
Mr. Stewart?
No questions, Your Honor.
All right. Thank you, Mr. Tolley. You can, jurors, questions. It's almost twice in a row. I escaped. No such luck. Once you made fun of their pizza. A lot of questions you're gonna get. Would you have liked to have had cheese or pepperoni? Because you didn't get any.
I don't know. I'd have been good with any.
Sir? We'll be quick.
Now we'll get to find out if I have second questions. Now I don't know exactly. Oh, it's this guy who's writing all the damn questions.
This is guys who done the card. They got some days late.
I start writing all lower caps and like cursive.
It's him been writing these down. That's the same paper.
It wasn't that long ago. They probably are. I don't know if these are witness things. Yeah. I'm also looking back at like I have all these general questions and stuff, and some of these have gotten answered in several.
Yeah, that's what's been happening to me.
Yeah.
That was quick. I only had two. I think they had two cards.
None of them are laughing.
Yes. Yeah.
Thanks.
Court on the order, man, see?
Mr. Tolley, if the fence that we've been talking about, at the back of the Ibezims property encompasses in part a limited shared area, does that part of the common area or limited shared area cease to become a common area because it's now encapsulated, if you will, by the plaintiff's fence?
That's a good question. I do not know the answer to.
Okay. Would the water issues and land inside the fence that were, if you were just looking at the property diagrams and the plats that were common areas but are now enclosed in the fence, would those be the liability and issue and responsibility of the Ibezims or of the HOA?
Let me say the question again.
Sure.
So I understand it.
Yep.
So once the homeowner puts a fence up and if the gate's unlocked, it's still association's common area. And the association would go in there and mow the grass or, take care of that type of stuff. Once they put a fence up and they lock the gate, then the landscapers and stuff can't get in there. So that's when, that's why it's in the letter saying that once you put a lock on it, that's your responsibility to maintain. And so that's how it's been.
Okay, last little twist on this. Given that part of the fence extended into the swale and thus onto common area property of the HOA, why couldn't and shouldn't the HOA have taken its own action to raise the lower edge of the fence per the recommendation of several of the experts who analyzed the situation?
Good question. And I don't, because it was their fence that.
Their meaning the HOA or the Ibezims?
Ibezims fence. The association didn't want to touch it. And ultimately, from what I got from the board meetings is, once the fence was put there, it's their responsibility to maintain the fence. If it had to be cut, if it had to be, repositioned or something, that was the owner's responsibility to do.
So we've heard evidence that Water's Edge shared with the Ibezims their view that the fence, the bottom part of the fence should be raised or part of it should be removed. Did Backyard Realty, through you or anyone working with you, ever communicate to the Ibezims, hey, one way we could work on this would be to remove a lower portion of the fence that extends into the swale.
It was already stated in the emails and everything, and it was clear from the builder side. So
You didn't add on to
I
that.
didn't add on to it.
Okay. Mr. McLeod, any follow-up in this area? Looks like, yes, you're furiously highlighting something. Okay.
Do you still have the covenant in front of you?
Warranty builders, nope. Nope. There's a lot of stuff down there.
Refer you to D1 of the Court of Covenants. If you'll go to page 28. And this is a provision, these are rules of the association. This is regarding the use of the common elements. And at the bottom of paragraph 10, it says use of common elements.
Excuse me for a second. You said page 28?
Page 28 of the covenants.
Okay, good, because I got a 27 and a 29. Keep going.
He strategically removed the page he wanted you to refer to.
Somebody,
You'd have to answer yes.
my paralegal combined an exhibit. Is that?
That's 27.
Look at.
Okay, I'll read yours.
Look at this page number.
That's what I was looking for. You have 27 and 29.
Must have copied.
I promise I didn't do it.
No, it's my copier. Hilarious, the one page. There it is. It pulled. It's 26, 28, and 27. Okay, so anyway, use of the common elements, and just to help clarify for the jury, it says, subject to the developer's rights, blah, 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 blah. And then it says the use, maintenance, and operation of the common elements shall not be obstructed, damaged, or unreasonably interfered with by any unit owner. And shall be subject to any lease, concession, or easement, presently in existence or entered into by the board at some future time, affecting any part or all of said common elements. So what that's saying is, you might comment on that? I'm asking you to what this.
Okay.
Does that help clarify?
I mean, you were doing so good.
Anyway, that's the covenant about the use of common elements. So that seems to say that any unit owner can't do anything that interferes with or obstructs with the common elements.
Correct.
And then referring you to page 11.
Let's see if we got 11. 11, got it.
It says patios and decks is limited to common elements. In addition to any other portion of the common elements which may be designated as a limited common element, either on the plat or elsewhere in the declaration, the patios or decks adjoining the units are hereby expressly designated as limited common elements, and the use and benefit thereof is reserved to the particular unit or units of which said patio or deck joins.
Correct.
In the definition section, page 2, common elements means all portions of the condominiums except the units and includes the limited common elements, unless otherwise expressly specified herein. Get to the definition of a limited common element in the declaration. It says, limited common element means those portions of the common elements if any, so designated in the condominium instruments as being reserved for the use of a certain unit or units to the exclusion of other units. So it's designated exclusively for the use of the unit that it serves. Still a common element, but it's a limited common element that serves only that unit. Right? For the patio index and elements. And last. Make section 14, page 17, and say you guys have to do this. Maintenance, repairs, and replacements. Maintenance of, repairs to, and replacements within the common elements shall be the responsibility of and shall be furnished by the association. The cost of maintenance of, repairs to, and replacements within the common elements shall be a part of the common expenses subject to the bylaws, rules, and regulations of the association. However, at the discretion of the board, maintenance of, repairs to, and replacements with the limited common elements, including without limitation, a garage within the building or parking spaces, and patios or decks may be assessed in whole or in part to the particular unit or units to which said limited common elements are assigned. And further, at the discretion of the board may direct unit owners who stand to be benefited by such maintenance of, repairs to, and replacements within the limited common elements to arrange for such maintenance, repairs, and replacements in the name and for the account of such benefited unit owners, pay the cost thereof with their own funds, and procure and deliver to the board such lien waivers and contractors and subcontractors sworn statements as may be required to protect the condominium from all mechanics or material miscellaneous claims that may arise. If, due to the act or neglect of a unit owner or his or her agent, servant, family member, invitee, licensee, blah, 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 if the unit owner, if damage shall be caused to the common elements or to a unit or units owned by others, or maintenance, repair, or replacement are required, which would otherwise be a common expense, that such unit owner shall pay for such damage or such maintenance, repair, and replacements as may be determined by the association.
Objection, Your Honor. Is there a question there, or he's going to give his closing argument?
So that was a lot. Are you done? And is there a question? I mean, there needs to be a question because you just read something and I have that all stricken if it's then hopefully not, is that what it says?
Sure. So I think if you reread your question about who's responsible or what are they responsible.
You can, I don't need to reread. You're welcome to ask in light of that question.
In light of what you just heard, Mr. Tully, you're familiar with you've read these before.
I have.
Okay. In light of what you just heard, does that help you recall or recollect who would be responsible for maintaining the area inside of the plaintiff's fence?
Yes, it would be the plaintiff.
All right. Any other questions for Mr. Tully?
I have none, Your Honor.
Okay. Does that bring any questions from you, Mr. Kyle?
No, Your Honor.
Mr. Dorsey?
No, Your Honor.
Okay. Mr. Stewart?
2 minutes, Your Honor.
All right. I wish you'd say it more often, but when you say it, it is spot on.
They've done it almost every time. You read that agreement, and it talks about he cannot interfere, obstruct the fence, and the fence can't obstruct anything, basically what it said. That would
Mean
be
the
a
covenants?
violation.
You mean the covenants?
Yes, whatever you read. It would have been a violation if it interfered, obstruct, correct?
Yes.
And you're just the messenger. You take the message to the board makes the decisions, correct?
Correct.
And the president, Mr. Smith, got on the stand and said, I went out there in the rain and held the umbrella many times. It did not interfere or obstruct. He would be the one to make that decision.
He's only one member on the board.
All 5 of the members of the board never told the plaintiffs there was a problem with that fence. that is interfering or obstructing. You know, nobody who ever told me is interfering or obstructing by the board.
No,
And as far as Water's Edge says they're breaking the covenants, the board decides whether they want to change the covenants, obey the covenants or not. They have zero influence at the time of this event to just tell them what to do about their.
Water's Edge had zero influence. Is your
Yeah,
question?
Water's Edge and Mr. Silverstone had nothing whatsoever. They had no legal right to interfere or tell them what to do.
in what?
The fence.
Oh, about installing the fence?
No more questions. Thank you, Honor.
Okay. Thank you, Mr. Tully.
You're welcome.
You may step down. Mr. McLeod, next witness.
Sean Smith, Your Honor.
Mr. Smith.
Do you swear upon the testimony given in court as the truth, the whole truth, nothing but the truth, that be God?
I do.
Please state and spell your name for the record for me, please.
Sean Smith, SEAN SMITH. How are you?
You're the president of the association, correct?
Correct.
And that means you're also the president of the board of directors, is that correct?
Correct.
And the association acting through the board of directors is responsible for governing the Mill Creek community, correct?
Correct.
And that includes enforcing the covenants and restrictions that pertain.
Correct.
And it's the duty and responsibility of the association and the board in particular to maintain the common areas and serve, correct?
Correct.
That's a pretty large responsibility.
It is.
And that's because the community was a very large community, right?
Yes, correct.
Do you guys, if I told you that the community was over 25 acres, would that surprise you?
It would not.
And there's approximately 175 units, correct?
Yes, correct.
And in fact, it's such a large responsibility that in part you've had to delegate part of those responsibilities out to the Tolly community.
Correct. Correct.
And you just heard Mr. Tolly's testimony, correct?
I did.
Would you disagree with anything that he testified to?
No, not at all.
I want to talk to you a little bit about the covenants governing maintenance. I have a lot of questions about that. Here's the D1 back to you. Let me know if there's any. You know what? I think I'm going to put this up on the screen.
Okay.
If you're familiar with the covenant. You're familiar with these covenants, correct?
Correct.
Okay. Got on, pay attention. So if we go to section 1H on page 2 of the declaration, again, it just went over this, it provides that all of the land that is not part of the actual units, meaning the walls in that we talked about, everything besides that is a common element.
Correct.
We've got units, all the little boxes that people live in, everything else is the common elements, right?
That is right.
Streets, everything, driveways, patios.
Correct.
Decks, everything else is not inside the unit where you live. It's technically a common element.
Correct.
And so for all of those common elements, the roofs, all of that sort of stuff, the maintenance of that is the association of responsibility.
That is correct.
Okay. And so the dues that people pay that live there, they pay annual, they pay initiation fees, they pay regular monthly association fees. All that money goes into a big pot, right?
We have so you have what's an operating fund, which is our normal monthly expenses. And then you have your reserve fund, which is funds that are for things like he mentioned, the roofs, future roof replacements, things like that.
Okay, and so, but by and large, y'all create a budget every year. Out of those funds, y'all pay for everything, all the common expenses that need to be paid for, right?
That is correct.
And that would include maintenance, right?
Yes. Yes.
Before you go any further, a question for me.
Yes.
We've heard different testimony on the immediate backyard of each unit, in particular, the patio slab and what would be adjacent parallel, so right up against the backside of each unit. It sounds like your understanding and testimony from a closer reading of the covenants is that that backyard patio slab and the land immediately adjacent laterally to it is in fact common area, but the language of the covenants is that it is, I'm not going to say deeded because it doesn't become the property of, but it's effectively loaned to each unit holder for their specific use. So my example of, if I'm in unit 1, I can't go sit, I may be invited, but I can on my own set up a grill on the slab of unit 4. Like, hey, this is, I can cook here. This is everyone's space. But it is still, it is community property that has been designated for individual use, but not actually owned by the unit holder.
That is correct. Limited common, but it would all fall under the common umbrella.
Sure. And then once you step off the slab, then you're on good old common area, not limited. That is the property of everyone and no one other than the association.
Correct.
Okay.
And Mr. Smith, if you'll look at page 10, that's section 7F. I'm just going to read this.
Okay.
It says that the maintenance of repairs to and replacements. So maintenance.
It's not, I just want to make sure, it's not what's on the screen.
I can put it on.
You don't need to. I was not finding.
You said page 10?
7.
Ah, okay.
Excuse me, page 10. You're correct. This is what I was. Seven F. I'm so sorry. Go to section 14, page 7. My apologies. But this is important.
Okay, I'm there.
Page 17, here it comes. Here we go. Section 14, page 17. And so it says, and this is what we did, the cost of maintenance of repairs to and replacements within the common elements of the responsibility of the association. So it's maintenance, repair, replacements. Would you agree with me that that's all encompassing?
Yes, correct.
If anything needs fixing, it's the association's responsibility.
Yes.
Okay. Subject to, later on in that paragraph, it says, however, if there's a limited common element, such as patio, anything like that, a fence, anything like that, that the board at its discretion may assess any cost associated with that to the unit owner that limited common element serves, correct?
Correct.
And that makes sense, doesn't it?
It does.
If I live in building 29 and there's something in building 30 that's a limited common element that needs repairs to, the owners in building 29 shouldn't have to pay for the repairs of that limited common element.
Exactly.
That's why that provision exists, right?
Exactly.
Okay, now, if there's a limited common element like a street that everybody uses for ingress and egress to get in and out of the community, let's say the entrance, for example, if that needs to be repaired, then all owners would share in that expense, correct?
That is correct.
That's how the association works.
Yes,
Okay, and it's set up that way because it's the most fair way for it to be, correct?
it is. I mean, we've had individuals as well where someone has hit our sign, for example. While the association may pay for that, they do end up charging it back to the actual person because the whole association did not do the damage, so.
And let's talk specifically about the plaintiffs, the area behind the plaintiffs, patio, the fenced-in area. Tell the jury, what effect did the placement of the fence have on their responsibility to maintain the area inside that fence?
So the fence itself would automatically be their responsibility. We have, I'd say 99.9% of the people in the association who have fences either have told us that they don't want us in there, or they have placed a lock on it so that they have assumed responsibility for everything that happens in that fence. As far as I've seen the fence, there has always been a lock on it. So that would effectively make that the Ibezims' responsibility.
If that fence needed maintenance or repairs, who would pay for that?
That falls on the Ibezims family.
Okay. And if there's any issues inside of that fence that need repair, maintenance, or replacement, who would be responsible for making those repairs?
The Ibezims family.
Okay. And did that change because of the installation of the fence?
Well, ultimately, once the fence was up, like I said, if they wanted us to take care of it, you have that option. But I believe it says on the ACC form, if you lock it, it becomes your responsibility. I think, I'm not sure who signed that, but I believe it was Tia. So yeah, they effectively have taken on the responsibility. It would fall on them.
Okay, let me ask you this. Let's say it was unlocked, but let's say there was still damage caused in that common area by something that they did.
Mhm.
Would the association be responsible for that, or would the Ibezims still be responsible for that?
It would depend on if it was something of negligence versus normal wear and tear. If it was, for example, we have people that have dogs and, the dogs will sit there and dig all day. The homeowner is responsible for that. You can't call the HOA up and say, hey, there's a huge hole in my backyard. Can you guys fill it? Because we're going to say, well, it was caused by your dog, so you have to take care of it.
And I understand your position. I've heard your testimony before, and it's been very clear. You don't think the fence had caused any issues with their residents. But if the fence had caused an issue, damage to the property, would they have been responsible to make those repairs?
Yes.
Now, who was responsible for investigating the common areas to see what maintenance was needed?
In that area for the whole neighborhood?
Let's say that area.
Ultimately, the board is going to, well, I'll say this, the association as a whole, which encompasses everyone that lives in the neighborhood, all the owners that live in the neighborhood, all of us have a responsibility as an association as a whole. Secondary is the board, which is only 3 to 5 members. At the time it was 3. So every member has input.
So, and let's laser down a little bit. With respect to that common area drainage issue, Was the board also responsible for inspecting that drainage system to make sure that it worked?
Yes, yes.
Does the board and the association, can I use those terms interchangeably?
Mhm. That's fine. We can. Yes.
Does the board have an established process to identify those types of maintenance issues?
I mean, usually when we go around, we see an issue, we email Tully or text Mike or whatever, and usually we'll talk about it first as a board and during our board meeting. So everyone is made aware and everybody's on the same page on the board. Usually our manager will be there so we can talk to them as well. If it's something that needs immediate, usually we'll just pick up the phone, call them. But every week, the 5 of us now have input and do it through the board, through the management company.
So we're talking about 25 acres. That's a lot of land. You do a lot of walking, right?
Correct.
Okay. Is there a regular schedule that you go around to each particular building to figure out what maintenance might be needed for each particular building?
At one point, I personally had a schedule because of the buildings were brand new. So we wanted to make sure, that we see issues and everything. Usually at least once a month now, the board will at least try to get together and do a walkthrough. It usually slows down in the winter time, but usually once spring is here and when we get a, soft ground and rainy season, usually we will look for leaks and all types of different issues that present themselves.
Right. Okay, so let's again laser back to the drainage area behind the claims unit. And we've heard a lot of testimony about the development of the community. The association board was not always responsible for the drainage area behind the claims.
No,
correct?
no.
And then we talked about the quitclaim deeds and common areas that happened in February prior to their purchase of the unit.
Correct.
But you agree that after that time, that's when the association became responsible for those drainage areas, correct?
Yeah, I believe once everything is filed and recorded, that's when the association.
And we've all put that into evidence. It's right there on the
Yeah.
table somewhere.
Somewhere.
Okay, good. And with respect to that drainage area, we all know there's a drainage swale. There's now a pipe
Yes.
underneath the
Yes.
drainage swale that the association put in. to
Correct.
Mediate the issue. Then there's the drainage inlet. You would agree with me that the defendants, they didn't install any of that, correct?
No, they did not.
The drainage inlet existed before they got there, before you took ownership. It was there.
Yes,
right? That
correct.
swale was there.
Correct.
Geosam owned the property before you, right?
Yes,
Okay.
yes.
So if there were any maintenance issues on the property at that time, that was Geosam's responsibility.
It would have fallen on GeoSam, correct?
And I believe you testified in your earlier deposition that when there were maintenance issues out there, the association, let's say they weren't cutting grass.
Mhm.
Did you have occasion to contact Geosam to maintain that property?
Many times we did.
Can you tell the jury what types of things that you had asked them to do?
Mainly the main thing, because we were just dealing with empty lots, was the grass cutting. We got reports from a lot of people whose backyards backed up to the empty lots that there were snakes, things like that, because the grass had gotten literally this high and different critters were hiding in there and everything. So the majority of the calls that went to them were, hey, can you get someone out here and cut everything back down to match the neighborhood? Plus, it just looked bad,
So you didn't own the property, but you owned a lot of the property beside it. You owned the buildings, the association. You had an interest in making sure that that area stayed somewhat maintained.
Exactly.
And you did that, didn't you?
Yes,
Okay. And did GSM by and large try to maintain that property?
they did. It took a little, at times, a few conversations, but they took care of it.
So that area wasn't totally neglected.
No, not totally, no.
When you say not totally, was it partially neglected?
It wasn't, when I say neglected, it had been sitting stagnant for, I think we've all established, 10 years, something like that. So it was just, it looked a little rough at times.
And did you ever walk back there during those periods prior to the association taking ownership?
Yes.
What was your opinion regarding the condition?
So you had immediately, and I'm looking at, because literally when I walked out, the properties are right there. So you had some areas, and I talked about the trailer area earlier. So the trailer area was opposite the street where Unit 30 is. When you come out of that street, the trailer was right there across the street. That was.
You're talking about Water Edge's trailer, right?
Well, I'm starting to think now it might have been Geosam's.
Oh.
Yeah, because based on what Trevor was saying, like, and I've said this throughout, I didn't know what the ins and outs of the relationship were. So it seems like it might have been Geosam.
That wasn't near the plaintiff's unit, though, was it?
No, no.
Is that where you were talking about there were mounds of dirt?
Yeah, yeah.
Those mounds of dirt weren't proximate to.
They're within 50 feet. Across 50 feet, because it's right at the beginning of the street.
Okay, but
and they're in that first building on that street.
But those mounds of dirt aren't in the swale.
No.
They're not. They have nothing to do with what we're.
No.
And after the plaintiff's building was submitted to the association, you got initiation fees from the plaintiffs, correct?
Correct.
And started collecting dues.
Correct.
Okay, let's talk about the plaintiffs purchased the residence in March 2018. April, May, we get to May, and in May 2018, you get an application for a fence, correct?
Correct.
Talked about that.
Yes, we did.
And it was submitted to the board of directors. The board of directors also serves as the architectural control committee.
Exactly.
And why is there an architectural control?
Just to maintain a standard in the community. If there wasn't, since we're talking about fences, for example, we don't want somebody building a 15 foot high fence, and then the person next to them is only 8. We need to make sure things are consistent in the neighborhood, just design wise. And our goal is to make sure that property values stay at a certain level. So
the covenants require an architectural control, correct?
That is true as well. Yes.
And that's so that the community can maintain certain standards.
Yes, correct.
And so you received an application from the plaintiffs to build a fence. Did they contact you about how do we do this?
No, I believe they just went on the portal and submitted an ACC application.
Was it generally known in the community that if you need anything, an application, complaint, that you go through the portal?
Yeah, it should be. It's, I believe, outlined in our welcome packages and welcome letters that goes to every new owner.
Here's how you communicate through the portal.
Correct.
And so the application, it gets to the portal. Where does the portal go?
The portal then goes to, I'm not sure how Mike had it routed at the time, but I'm guessing because Mike was our manager that it went to him. But whoever the manager is at that time, it would go to them. From there, usually they will just download the application and forward it to the board of directors to review.
Okay. In this particular instance, that application, that's not usually submitted to the builder, correct?
No.
So the Waters Edge Group would not have received notice that there had been an application for the plaintiff's.
Not at all.
And then the defendants in this case, they would have had no say-so over the approval of that or denial of that application.
No.
That is correct?
Yes, that is correct. You would not have.
And you didn't actually become involved or you didn't make contact with the plaintiffs at this time, right?
No.
In fact, you didn't really first meet the plaintiffs until after there was water issues that developed, right?
I believe the first time I met them was on September 4th of 2018.
Which would have been after. The fence was built.
Yes, correct.
So you were, let me ask you this, you've never met them personally prior to that?
No.
Did you know who they were before that?
I didn't have a clue.
So the board doesn't meet new homeowners?
No.
It's not part of this home.
No, unfortunately.
housewarming, Welcome to Mill Creek, his little basket with some crackers and soap.
No, it would be ideal, but we're just too busy.
25 acres.
Okay, let's look at section 16. No. This is the covenant about the fences. We've been through this before. And it says a unit owner is prohibited from installing or causing the installation of any decks, patios, fences on the common elements, correct?
Correct.
Okay. Has this, to your knowledge, has this section of the declaration been amended?
It has because, yes, it has.
Okay. Has it been formally amended?
Well, just to give a little bit of background on the neighborhood. So before we moved in, during the whole housing bubble burst, the neighborhood was the wild, wild west before I moved in. Everybody was doing what they needed because there was no, GeoSam was over it and nobody was really doing anything with the neighborhood. So when I moved into the neighborhood, there were a lot of fences already erected throughout the neighborhood. I know Trevor said there was one, but I think he's talking about in reference to the new lots. So the first thing that, it would be hard for us to tell future people that you cannot have a fence when there's, 20 other, 30 other fences throughout the neighborhood. So we did allow fences to come into the picture. Yes.
So it was informally modified.
Yes.
Correct?
Yes.
You've been the association president since around 2013?
I think it was, 2014, 2013, something like that.
Did the board of directors or association ever formally file an amendment to this provision?
To be honest, I don't know. I know we were working on amendments, but I don't know what's been filed already and what hasn't.
You're not aware of any form, you don't recall?
I don't recall, to be honest with you.
You remember we talked about this in your earlier deposition. Do you have any reason to dispute your earlier testimony?
I don't. And if I said then I go with that because.
All right, we'll get through that later.
Okay.
You're not aware of it being formally amended?
No.
But as a matter of practice, it has been amended?
Yes.
Can you just informally amend covenants willy-nilly, however you want?
No, but the original plans, our plans were made by somebody in New Jersey, that never stepped foot on our property.
When you say our plans?
Our covenants, rather. The company that did them was actually from New Jersey. And I guess they just, at the time, whoever the builder was, Portrait, they just spit out a covenants, because there's a lot in our covenants that doesn't apply to our neighborhood. It was just the covenants that they were given. So like with the decks and patios, for example, there's a lot in here that talks about, because I think it said originally no fences, but we have plenty of fences throughout. So
Fair enough. But the covenants do formally, there's a provision here that requires any amendments to be voted on by the association.
Yes.
Do you know if that was done or not?
I honestly, in regards to this 16, I don't think so. I'll say no.
Thank you. All right, let's talk about the construction of fences. The plans application was approved by the board, correct?
Yes, correct.
And so can you describe how that approval process works?
I mean, basically, the only thing that we look at is, okay, what are the dimensions of the building? So do you meet the width requirements? Most of the, as long as it's with, as long as it fits, we really don't have we try to keep them all pretty much the same length. But because of the area that they're in, it just backs up to woods. It's not too much of an issue, but So usually we'll just make sure visually that the fence will fit in with what's there. And at the time, Water's Edge had done the wooden dividers, which is why we allowed wood back there, because usually we don't allow wood, but they had already put up those, so.
So with respect to this particular fence, you were aware that it was going to be placed in a common area drainage swale, correct?
I can't say that we were aware that it was like in the swale. We're aware of the dimensions and, you know, that we were okay with it and we gave them permission to do it. But
did the board go back and see where the fence is going to be located during the approval process?
I believe we walked back there, but I can't tell you what day. I mean, it was just at some point a walkthrough would have been done, because we usually will at least walk the property to see what's back there.
Prior to approving the fence?
Yeah, yeah.
So when you walked back there, you noticed that the location of the fence was going to be in the common area drainage swale?
I honestly did not. I can't recall what everybody else's thoughts were, but for me, I can tell you, I didn't recognize any of that. I was just looking, because we're not looking for the engineering and all that stuff. That's the part on the ACC request. That's really not the association's objective when we go out to look.
You have new fence guidelines now, correct?
We do, we do.
And those guidelines have a drainage requirement, don't they?
I believe so. I believe so.
And that requirement is that it cannot interfere with the drainage surrounding the property, correct?
Correct, correct.
Was this a factor that the board considered in deciding whether to approve the fence or not?
To be honest, I don't remember back then what the decision was based on. I just know the approval letter was sent out.
Did you change the rules because of this situation? You mentioned now that part of the fence approval or the guidelines, fence shall not interfere with drainage system, didn't used to be in there, it's in there now. Is that because of this case?
What we did with in regards to the changing of the fence guidelines, like for example, how it says that the association has to build the fence or has to, govern the building of that fence. So we chose Pennington as our chosen vendor because we knew, one, Pennington is very reputable, and they know there's a certain guideline that has to be followed for the neighborhood. Rather than giving everybody an option to go to 100 different people and have 100 different types of fences, we just said, here's what we approve, and as long as you guys get the approval for it and do it the right way, we'll approve it.
But that didn't answer my question. You changed some of the rules about fence construction recently. It didn't used to say your fence cannot interfere with a drainage system.
We may have, I just don't remember when that change was made. I honestly don't remember.
Why was the change made?
That is a good question. It may have been a result of this. I mean, I honestly don't know why. I don't even remember when that conversation was had, to be honest with you.
Okay.
Let me give you a copy of DA. Can you see it on your screen?
I can.
So these are the new fence guidelines, right?
Yes, yes.
And you actually had a part in crafting these fence guidelines, correct?
Yeah, well, Mike makes his recommendations. He made a few recommendations with us, and then we started to look at the fences that are already built in the neighborhood, base what was done in the past, on the new fence guidelines. So yeah, we had a say in going through this and figuring it out, moving forward, what to do.
Okay, let's talk quickly about the drainage.
Okay.
Says new fence construction should not interfere with or change water drainage around the units as designed by the builder, correct?
Correct.
Did the board talk to the builder during the approval process to see if that was gonna create an issue?
We actually did not. I don't believe so. I don't believe so.
So you're gonna have to admit today that you violated your own new fence standards.
Well, I don't know that it says new fence or change water drainage around as designed by the builder. I'm going to be honest with you. I don't think that the board was, like I said, we're not engineers and all that stuff. So when it comes to that, I don't think that everybody was even thinking about this because it has never been an issue before.
Well, Mr. Smith, I mean, we've heard volumes of testimony about the water that's flowing behind the residents.
Correct.
We even talked about how gallons and gallons, thousands. And
Yes, yes.
Gallons were coming off.
I have.
But upon your review, everything seemed to be flowing smoothly. Is that correct?
When I went out there, I will say that it seemed to be flowing smoothly. I will also say over the past few days of listening to different experts and everybody else, and Mr. Ibezims himself, there were times where the fence was Mr. Ibezims said where he had dug out the fence. So it's very possible. I mean, I will say as of right now, the fence is on the ground. As of right now. The times when I went out there, I can tell you that there were plenty of times where water was freely flowing. Whether or not that was a time when Mr. Ibezims had just finished, I don't know.
Were you aware that he was out there shoveling?
I had no clue. I had no clue.
He never told you, Sean, I'm having to shovel.
I don't remember having that.
To keep water from, like, to get it into the swale.
I don't remember having that conversation with him.
Never received that complaint?
I don't remember having that conversation about that. No.
But were you able to get inside the fence?
No, we couldn't do anything with the fence because the fence was locked.
So when you were out there walking, your inspection would not have included any visuals inside the fence. It just would have been outside.
It was on the exterior. Yeah. We never had access to the inside of there.
Did you ever get a complaint about him having to shovel and that the water wasn't being allowed to get into the swale because it was backing up?
Not that I can remember.
The guidelines also require that the new fences have enough clearance for drainage, correct?
Correct.
But the association did not have any particular standard for clearance from the grade, correct?
That is correct.
Okay. And I believe you testified at your earlier deposition that with respect to this swale and the amount of water that was going through there, that you thought a 3-inch gap would have been the minimum that would have been needed. Is that correct?
I think that would be a sufficient amount of space.
And Dr. Spots also testified earlier that he also agreed that several inches needed to be of raised fence was necessary for the water that was flowing through there, correct?
He did.
And my recollection is that Dr. Spots also testified that if the fence had been cut, that would have really helped the water get back into the swale so that it can flow to the drainage, correct?
He did.
Okay. So before the association approved the fence, did the association take any actions to ensure that the plaintiff's fence has sufficient clearance off the ground for drainage?
This is before it was built or after you're talking about?
Before it was approved. Did y'all say you can build the fence, but it needs to be a certain level off of the ground? After our inspection, we think that there's a drainage issue. It's got to be so many inches so the stuff can free flow underneath it.
No, we that's not something that we do. We just approve it based off of, I guess you can say, cosmetics. How will it fit into the neighborhood? But the actual schematics and, we want to know the length and the width, but the actual effect on environmental effects, I'm not an engineer, so.
Understood. And you didn't have any engineers create these?
No, we did not.
Would you agree with me that your guidelines need to be modified after this case?
I would probably say we need to make some tweaks. Yeah.
Tweaks?
Yeah.
And one of those tweaks would be you gotta have a certain clearance off the ground.
Yeah.
So that any debris flowing through a drainage swale where you allowed a fence to be located can get through that fence to get to the drainage inlet, right?
Yes, that is correct. That is correct.
Monday morning quarterbacking, hindsight's 2020.
Yep. Unfortunately, that's life.
It's pretty clear now.
Yes.
And then the guidelines also require that the maintenance of the fence and all elements inside the fence are the responsibility of the homeowner.
Correct.
Okay. So in the association's mind, then the plan is Mr. and Mrs. Ibezims were responsible for maintaining that area.
That is correct.
After the fence was built, we're moving to after it was built, did the association make any inspections to see that the fence was built as approved?
Just a quick visual walkthrough, and then that would have been done not specifically for the fence, but for the street as a whole when I do my, just normal walkthrough.
Were you the only member of the association that was doing these inspections on behalf of the board?
No, but anybody in the neighborhood to tell you I'm the most active. It's just how it is.
You don't really have a formal process?
No, not really. Not really. It's just visual inspections.
After the fence was constructed, did the association take any actions to ensure that the fence as constructed did not have any drainage issues?
So usually if there's something that needs to be reported, I believe in our covenants, it says that each homeowner, each member of our association has the responsibility to contact the management company so that we can take the necessary steps to kind of figure out what's going on. So from our standpoint, there was no reason for me to keep going out there, not to look at the fence because there was nothing being reported. So like I said, I didn't even find out about this till September. So
that brings up a good point. Mr. Stewart and the plaintiffs have testified that they started making complaints about the water as far back as early as April. Did you receive any complaints in April?
I did not.
None till through April, May, June, July, August until September, correct?
Yes, it was September 4th. I was doing a walkthrough of Wild Basil Lane, and that's when I bumped into Mr. Ibezims.
And while the fence they were designing the fence and getting ready to build it, the plaintiffs also made a complaint about trees that needed to be cut. Are you aware of that complaint?
I was, yes.
Okay.
Yes.
And at that time, they didn't make any complaints about water.
No.
Okay.
No.
So what did the association respond and take action with respect to their complaints about the trees?
We did, and the email that that you showed Trevor earlier in regards to the communication with Mike Tully and everything. So Trevor had come out, I believe it was June 29th, and we just thought because previously there had been trees that were cut that were too close. And we contacted Water's Edge, they took care of it. So in our mind, just from description, we thought it was something like that. It wasn't until Trevor came out on June 29th of 2018, that's when he said, oh, these aren't trees that were too close to the building. The only reason they're too close now is because of the fence. Okay. So we ended up, I believe, just taking care of those.
Okay, you didn't hear a peep for 4 or 5 months from the plaintiffs, correct?
That's correct.
Okay.
That's correct.
Then we get to September, the time frame we're talking about, and that's the first time you received a complaint from, I believe it was Mr.
Yes, it was Chris Ibezim. And again, like this is just, I'm just walking around. So I ended up speaking to him. We had a good conversation. He said, he gave me his side of the story. And I told him, I said, I sent him an email the next day. And I said, from what I said, it was great to meet you and everything. From our conversation, I believe you said there's a warranty that would be covered, and that would be the avenue to go down,
Okay. And that was after the fence was constructed, correct?
Yes, that was what, 2 months after, 3 months after? July, August. It was actually June 26th is when the fence actually went up. So July, August, September, 2.5 months.
Okay, so you sure it wasn't July?
It was actually June 26th.
That's when the fence was built?
Yes. Yes, which is why I believed it was July as well, until I saw Trevor's email, and Trevor said I had been out there yesterday, and he sent that at the end of June. So I believe it was June 29th.
Okay,
Yeah.
June, July, something.
Yeah.
And you met Mr. Desmond actually at the property, right?
Yes,
And y'all actually were behind, you went back there to look at the issue, correct?
we did. We did.
And tell me what you saw or what you talked about.
I mean, it was just talk, to be honest with you, because it wasn't, I can't see anything visually,
What specifically was the first complaint, specifically as you can remember, what was the first complaint you received?
I can't remember the date on the, when I got you, just a complaint period.
Not the date, I'm talking about the nature of the complaint.
He mentioned that his house was flooding. I specifically remember the word flooding, because that was the same verbiage that was used in a lot of emails as well.
And in your mind, did he mean that the inside of the house was flooding?
Yes, correct.
Okay.
Correct.
Not the outside area. He's saying the inside is flooding.
Yes, correct.
Okay. And so what did you do when he told you that? What actions did the board take?
So when I found out about it, my understanding was that there was, based on the words that we discussed, I'm thinking that there's this big issue inside the house that is keeping them from, at the very least, being able to use the downstairs of their unit. As time began to evolve and details started to come in, I realized, okay, this isn't I wouldn't use the word flood. I would use the word, we have a leak, a small leak. The raging river terminology, that wasn't on my mind yet, because, we were just going the house. And basically from the beginning, I told him, I said, it sounds like you have a warranty. I said, and in the first email to him, I said, you have a warranty from Water's Edge Group, contact them, and, then we'll see where this goes. But I told him, go ahead and use his warranty.
But you're getting water, you think you're getting water in your house, you're excited, understandable, you might exaggerate a little bit. But he described it, he was flooding, but that's not what you saw.
No.
And so as a result of that complaint, long story short, communications back and forth with the builder, Holly, and the plaintiffs, and they file a warranty complaint. Trevor comes out there. Trevor sees, oh, we made a mistake. Water's Edge made a mistake. We didn't put the hydraulic cement in between the two foundations. So they come out, rip off the baseboard. Were you there when that happened? Or
No, I was not. No.
They pump hydraulic cement in there, and then regrade everything, make it smooth, right by there, make sure there's a positive slope. When is the next complaint that the association received that you can recall from the plaintiffs?
So I would say over the next, leading up to our annual meeting, which I believe was in January that year, we kept hearing
you know, the flooding, you know, I'm having to do this, I'm having to put up sandbags and all this stuff. When we're out there, we're not seeing anything. So finally, eventually they did show me some videos, and it was, you know, there was some significant water back there. But I can't tell you the exact dates on those because I don't remember.
Okay. So you started seeing a lot of water. You said earlier that your recollection was that there seemed to be more of a gap early on than there was later on. Is that fair to say?
Yeah.
Okay.
Yeah.
As if dirt had been moved around.
Well, I mean, the times when I went out there, things were moving. I didn't see any signs of any, you know, because I guess, well, the dirt wasn't being thrown outside the gate, I guess. So I didn't see anything. All I could see is, okay, there's water moving, you know.
Did Mr. or Mrs. Ibezims ever tell you that the problem they were experiencing was that there was a lot of pine straw and stuff on the outside of the fence blocking the water from getting through the fence, and so it had in effect created a dam, so the water that was inside the fence was just backing up? Did you ever receive a complaint like that from them?
I want to say there was an email that I remember seeing regarding pine straw, and it was a, you know, a relatively simple fix. It was, you know, okay, we'll get somebody out there to just move the pine straw.
So let me ask you this, so were Mr. and Mrs. Ibezims asking the association to remove pine straw or clear the area for them?
I can't remember if it was an ask or if it was just, hey, pine straw is coming down. Either way, you know, I'm not gonna, for something like pine straw, we would just go out there and clear it.
But that was their maintenance responsibility at the time, correct?
It was.
And during this time period, when there was this water issue first came to light, there were some dispute between my clients, the defendants, and the association and backyard about who was responsible to solve that drainage issue. Would you agree with that?
Yes.
Would you agree with me, so we don't have to go back through all these emails and all that kind of stuff, that Water's Edge made abundantly clear their position to you that this was a common area HOA maintenance responsibility?
They did.
Okay.
They did.
Did the association ever reply formally or you know, in a more direct manner, like Mr. Silverstone did, that no, builders, Water's Edge, this is not an association issue, this is a builder issue? Direct from the association, I don't think so. I know there were communications going between Tully and Mr. Silverstone, but I don't think there was a direct one from us. Okay, and then so at some point during that time period while this is going on, no complaints, or we're getting towards 2019, January, February, March. About March, I believe you had some communications with Mrs. Ibezims about the builder's warranty. Yes. Do you recall those conversations? So, let me ask, I think Mrs. Ibezims' testimony was that you told her that she should let the warranty expire and that the association couldn't really do anything out there until the builder's warranty was over. Did you hear that testimony? I did. Okay. I did. Why don't you respond to that testimony and give yourselves? So at the annual meeting, Mike was present, maybe 30 people, I'll say. We addressed the issue at the annual meeting. And what was told to them was use the means you have at your discretion. I would never tell someone just don't do anything. You use the means at your discretion, and then it was told to them that if nothing comes from that, then obviously we're going to have to step in and do something. But as a new homeowner who had a warranty, we have no idea. We know you submitted your warranty, but we're not thinking every way along every step along the way. We're not holding your hand
I'm an adult. Every homeowner in my place is an adult. If I had to take care of everybody's issues, you know, it's not something I would take on. There was an email actually where Chris is blaming Mike Tully, saying Mike Tully he neglected to submit the Ibezims warranty to their warranty company. Like that's the I don't know why, what rational thought was going on, but they were told to use what they had at their disposal. From the first email that I sent them on November 5th of 2018, I specifically mentioned the warranty to them.
So you dispute Mrs. Ibezims' testimony that you told her
I do.
not to let the warranty expire?
I do. They were told that if it does and nothing gets done, the association will step in and take care of it.
And so we get to March, and then so from September, October period, were you constantly receiving complaints about water intrusion to their house during that time?
From September of 2018 through March, you said?
Yeah, I'm saying after the initial complaint, I came out there and there was a warranty work on, and Water's Edge thought they had fixed everything.
Yes.
Until March, did you receive any other complaints in that 6-7 month period?
So we were getting a few emails. I want to say up until at the annual meeting, as we got closer to the March deadline, then the email started to ramp up. Yes.
Okay, and then and as my recollection of hearing the testimony was in around March, there was a more like, wait a minute, we've got another issue, we've got water issues. Did you agree with that?
There was. And actually, I mean, I think we've got, I'm trying to think between September and March, there were emails and maybe a few work orders, but it was nothing like, you know,
You weren't getting complaints after every heavy or moderate rainfall that they were having flooding into their residence?
No, that we were not.
And you're aware that that's what they alleged in this complaint?
Yeah, no, we didn't hear about, I mean, at this point, I'll just speak frankly, the facts are the facts. We have been going around this all week. The truth is there was one small repair that needed to be done. There has been no more water entry into their house except after that first time. There's been no reports, no maintenance, anything that have come in saying I have water. Actually, I will say there was one leak in their place, but it was not related to anything on the foundation. It was related to the roof. Outside of that, there has not been, they told you there's no leaking on the linoleum. I have heard, oh, there's possibly leaks behind the wall if we remove it. I don't care about possibly. As a board, we don't think about possibly. We have to deal with the problems at hand. I have real homeowners that have real issues going on. With those, we have to take care of. We cannot go based off of yesterday, during my last testimony, it was brought up the gutters now. If the gutters have a leak, we have processes in place for all of this. You simply submit a work order. I just got an email this morning about another gutter cleaning that we're getting ready to do. Like, we have normal maintenance schedules. If you have a problem as a homeowner in our community, just submit a work order. But no reports nothing else was reported to us as leaking in their home.
I want to go through the reports that went through. Your Honor, not completed that. Would you prefer us to keep going, or do you think we're at a good stopping point for a break?
So we've only gone for about an hour and a half. So I was going to have us go a little bit further, but we will certainly have an afternoon break, but we have a close to 5 hard stop today.
I'll carry on.
Okay, well, if this is a natural break, but we're going to take a break in the next 20, 30 minutes anyway. If this is a natural break point for you, because your computer
This is a
died?
natural break point for me and allow me to kind of condense the rest of what I want to do.
That's a good verb.
During the break.
All right, we will honor that verb and we will take a break. Ladies and gentlemen, we're going to take our afternoon break. This is your last break for this week, so enjoy it. You're not getting another one this week. We will see you in about 10 minutes. Don't talk about the case, eat the cold pizza, and we'll see you soon. So they do a bad job of saving their commentary until after the door is closed. Mr. Stewart, anything we need to talk about before we start the break?
Oh, yeah.
Okay. Mr. McLeod,
There you go.
you'll be condensing over the break?
Oh, yes.
All right. Mr. Dorsey, anything else? All right, let's be back a little after 1 o'clock. See if we can get them out here.
1 o'clock?
You're welcome to a little on that clock. Be back a little after 1. I said, did I say 1? After 3. Yeah, it's already after 1. Be back a little after 3. Thank you. And you can step on down. You don't have to. You can stay right there. I'm leaving.
Thank you.
You take a break.
I know, but I can't talk to anybody.
That's true. Don't talk to me.
Yeah.
There's only one element.
There's only
No,
one.
no, I mean, who's kind of the
Prosecuting, I mean, plaintiff.
I would guess Larry's got it. I mean, honestly, if you just say, I'm gonna show you the menu report, I think we can just get, there's, I don't think anyone needs a reference to it. I think it's 42. Good thing is like it is. And it's you, Mark. Yeah.
How long have you been practicing law?
This is my 51st year.
Wow.
No, this is my 52nd.
You got how many? 54. Wow. Got some senior minds in here.
But as they say, you know, all lawyers keep practicing, trying to get it right. I don't know anybody who actually got it 100% right.
I'm gonna give up long before you did.
Well, people ask me when I'm gonna retire. I say, well, my health is good, and I'm used to that. And I enjoy what I'm doing. And if I stayed home more than 3 days, my wife would throw me off.
Yeah, that's.
So
Mr. Kyle's gonna take up, he does golf and gardening, right?
Yeah, golf, for sure. Gardening, I've been told I'm no longer gardening. Yeah, took on that task and all my flowers died. So
His thumb's not green.
yeah, that's right.
Ty is, but not his thumb.
Screwed that up. Well,
But he's moving to the beach.
Mike, let me check.
All right.
This is what I'm saying, we're going to close it. That's the right way to do it. I just don't know what this is.
I'm gonna do 10, 15 months. I'm just going to down do you have all that good stuff?
Hello, dear. Doing fine. Well, clearly we are not going to finish today. So we'll be. Okay. Okay. I actually got a reminder from the sleep doctor, 9 o'clock, but that's not going to take 30 minutes or so. I'll be back by 11 to do this thing with weight. Yeah. Okay. Anything else? I have no explanation, but yeah, it is. It's usually a couple of months. But anyway, I'll talk to him, and if it's worthwhile, it's worthwhile. I will probably have a thing or two to do on Saturday. Let's see. Well, you haven't been there since Tuesday, right? Okay. Well, we'll at least have Thursday and Friday night to look at it. Okay. And caboodles of emails to deal with. Okay, well, I will talk to you later. Okay. All righty, bye-bye.
Yeah.
Just living the dream.
So just make up something and then say they're nuisance.
Yeah, see what happens. Give me the idea. And then Why not?
There was another one.
And see if it doesn't, we proved it wasn't an issue. And it's so much. I can appreciate that, but I live.
What is that? What is that?
Nuisance again? There is a rule, you and each other.
Court come to order on 19cv.
But probably as long as.
We're missing Mr. McLeod. Is he out condensing?
I'll get him.
Thank you.
Look for your YouTube channel.
It's out there. You go to the court's website, then you go to each judge, and each judge has his or her own feed for their proceedings.
Did come across the one you did with Rudy Giuliani.
Yeah, that has been distributed publicly. It's not the official on the court's website.
I will say, Judge, my parents have appreciated the live feed, so.
It's a public proceeding. That's how a lot of courts work.
I didn't know that. That's pretty cool.
Did you do that pre-COVID or did you pick that up?
Once we started doing this Zoom, it was necessary. We had to because there were people who couldn't come to court. And I think it has a tonic effect on increasing public access to these proceedings. You're back. Do you feel condensed?
You'll be shocked.
I'm always ready to be shocked. Mr. Casanas, if you can get us back on the record, please.
Back on the record, 3:07 PM.
Deputy Williams, are the jurors ready for us?
Yes, Judge.
Mr. Stewart, you ready?
I'm ready.
All right, Mr. McLeod is clearly ready. Mr. Dorsey, you done with snack? We won't call on you while you're still chewing whatever that is. Let's bring the jurors in.
Are they missing you in the data report, Judge?
I'm not missing them.
Not this case.
You never know. $100 million verdict, that'll get you in.
Have they got the jury in the big case?
They're probably a month and a half away from getting a jury in the big case. They're still trying to get enough jurors qualified just
All
through
right,
hardship.
jurors.
You know, I'm taking that.
Thank you.
Thank you, Deputy Williams. Thought for a moment, Mr. Kendrick, you were going to take a different seat. You were eyeing it. Look at that. Welcome back, ladies and gentlemen, from your final break of the first week of trial. Mr. McLeod, I think everyone heard you use the C word, condense, before we went on break. We're back from break and we have Mr. Smith back on the stand for you.
Thank you. All right, here we go. So continuing, at some point, the association decided, hey, we need to get some engineers in here to figure out if we can solve this puzzle and see what's wrong, right?
That is correct.
Okay, so y'all hired Gray Engineering, and the Ray's engineering report you received essentially confirmed, yes, there is some ponding of water. Would you agree with that?
Yes, I
Okay.
would.
Didn't do anything at that time. You said, okay, we need some more information, so we're gonna get another engineer, correct?
Correct.
And then you get Mr. Duckett. You've heard about Mr. Duckett. And he identified a litany of things that could have been the problem. One of the things he said was that the fence was preventing water from escaping the backyard, right?
He did.
And he recommended that that fence needed to be cut up so that the water could, if we all get the picture.
Yes.
Swale and get to the drain. Okay. So as part of his solution, he suggested doing some grading, right? And then he also suggested that the fence should be removed, right?
Yes.
That was actually a recommendation. correct?
Yes. Yes.
But at this point, the fence was not cut for whatever reason. We still don't know.
That is correct.
And so finally, after those two reports, I said, you know what, we gotta try to really solve this problem. We're gonna get a full-blown engineer out here. We're gonna have them do a full report of pictures, all that sort of stuff. We've seen this thing a lot. And so that engineering report recommended two alternatives, correct?
That is correct.
And so the first alternative, part of alternative one was to provide a clear and unobtrusive flow of stormwater through the swale, remove the portion of the fence of the affected property within the existing breach. If you saw the pictures, the breach is talking about the intrusion of the fence into the swale. If you look at those pictures, that's what it's talking about, the breach. So this engineer termed the fence to be a breach into that drainage swale. It sounds like a problem. And then it said seal off the portion of the fence of the affected property within the existing breach and realign the swale around the fence perimeter. That was an option that said was possible to today. You heard Mr. Shonkwile.
Now, let me object. He's gone on about 5 statements, didn't ask a question yet. Comments along the way about that, oh, that's a real problem, things of that nature.
Okay, so got it. Sometimes you too have asked questions that are about 4 minutes long, but the comments not good. No comments. Just ask the question. If your question is going to involve a long introductory narrative, which every lawyer in this case has done, and it's okay, and let's not object to it. Just say, I'm going to read to you a little bit before I get to my question, and then everyone, jurors included, are on notice that you're going to be talking for a while before we actually get any evidence, which would be the answer. Okay. So objection overruled to the introductory narrative part, sustained as to you saying big problem when you see something that you like.
Fair enough.
Okay.
Mr. Schunkweiler testified in his opinion, moving the swale around the fence wasn't really a viable option because you were going to have to cut into the hill, and that would essentially require a retaining wall, a permit, and a lot of work.
That is correct.
Would you agree with Mr. Schunkweiler?
I absolutely would.
So that wasn't chosen, correct?
No.
Okay, so that was option, a few other things, do some minor grading and that sort of stuff, and that was option one. And so then we get to option two. One of the requirements for option one was to have a topographical survey, correct?
Correct.
And the topographical survey would have showed the elevations of all of the area, right?
That is correct.
Really get the lay of the land, right?
Yes, yes,
But y'all determined that wasn't necessary, correct?
correct.
Okay, and so that was pretty much what was removed. And so it says for alternative two, for site drainage, which is what we're really worried about here, it says all measures outlined in alternative one, except for the survey, right?
Exactly.
And so you guys chose alternative one, correct?
Yes.
Except for the fact that you didn't do anything with the fence, correct?
Well, actually, hold on. We chose alternative two.
Okay, right. And so, and it says, for site drainage of alternative two, it says all measures outlined in alternative one, except for no pre-site topo.
Yes.
Topo survey, okay? And we just went through, one of the things in alternative one was to do something with the fence, right? You want me to pull it back up?
No, I remember that.
You remember that?
Mhm.
So really, in effect, what you actually did was alternative two, except for you didn't take the recommendation to change the fence, right?
And that is correct. And that was discussed with the engineer as well, that our objective was to try to help the Ibezims to keep their fence.
Okay, but did you discuss cutting the fence up a little bit, just to allow water to flow underneath it now?
The objective was to eliminate the water, which is what we effectively have done. I think everybody saw the video yesterday.
So that you thought that solution, if you didn't remove, you'd already received a prior recommendation saying that the fence was causing water to back up and it couldn't get to swale, right?
I mean, we've received a lot of people have blamed the fence. We've discussed that extensively.
But Mr. Duckett blamed the fence, correct?
Yes, yes.
And then so you received the final engineer report that you were relying on recommended to do something with the fence, correct?
Correct.
So you said you chose alternative two, and that's what you told the plaintiff you were going to do, correct?
Correct.
But you didn't do anything with the fence, correct?
No, we didn't touch the
And
fence.
that's because you were just trying to let the plaintiff do the fence.
Correct. Correct.
Your Honor, I have no further questions. on this witness.
Well, all right. Mr. Dorsey, you're up.
Thank you, Your Honor. Mr. Smith, in an effort to move this along efficiently, I'm going to go ahead and ask you my questions that I want to speak with you about now while you're already up there.
Okay.
Fair?
Sounds good.
Good deal. A moment ago, we were talking about this alternative one, alternative two, the engineers, Schunkweiler, everyone else.
Do you want the exhibit to stay up, or are you gonna? All right, then it's gone. Excellent.
And you said something that kind of piqued my interest. You said your goal was to eliminate the water, correct?
Correct.
And not to rehash everything that was done, but we talked about the drainage spouts, the catch basins, and all those things that route the water underground and into the sewage drain system.
Correct.
Is that what you were talking about?
Yes, exactly.
So basically, instead of having water flow either under the fence, over the fence, through the fence, around the trees, wherever it was flowing, it just no longer flowed down that hill at all. Correct?
Exactly. Exactly.
And we saw a video yesterday, the one with the lock. It was after a heavy rainstorm, according to Mr. Schunkweiler, and it showed that the remedial measures had been taken. and it really showed no ground surface water other than a small puddle here or there. Is that consistent with what you see when you go out there today?
Absolutely. Absolutely. There's normal rainwater on the ground. The same that if you're walking down the street, you'll see you saw the little puddles yesterday. There is no issue with water outside of the locked gate.
So there's no more raging river, no more water, even going through the ditch, through the swell, there's no water going that way.
Absolutely not.
And to that extent, if there is water back there, it's all inside the fence. Is that
Yes,
fair?
that is correct.
There's been some discussion about responsibilities for the fence and maintenance inside the fence. And I think that we've blurred the lines a little bit, so I want to be very clear. Earlier, when you testified that at the outset, as soon as you build a fence, you're responsible for the fence. Are you talking about the wood and the nails?
Yes.
Vertical fence? Right?
Yes, I'm sorry to. Yes, that's exactly what I'm talking about. The actual structure itself.
Perfect. And then if we go to step 2, we're talking about everything inside that fence, and that's if the gate's locked, correct?
That is correct.
So then we're talking dirt, grass, hay, pine straw, those types.
Anything in there, within the confines of that fence.
Okay, so those are 2 separate considerations.
Yes.
And in this case, it's the board's opinion that the Ibezims are actually responsible for both, given the fact that the gate remains locked at all times.
Yes. Yes, absolutely.
You mentioned earlier that after sitting here, I don't want to put words in your mouth, but maybe you feel you might have been bamboozled a little bit. I want to be clear. You're not saying that back in time, you didn't see the water flowing under the fence. That's correct, right?
No, I definitely saw water flowing on the fence.
And if we put Mr. Smith back in 2018, when you're looking at it, you were making these decisions based on, hey, there's water still running under the fence. Fair?
Correct and fair, yes.
And you just said that you were doing your best to make sure that they kept this fence. It's very important to their family, right?
Yes, yeah.
And you were just saying earlier when you were talking to Mr. McLeod, that after hearing everything, maybe you think before you arrived, when you were invited inside to look, maybe it had been cleaned up a little bit or something like that. Is that what you were saying?
Based on Mr. Ibezims' testimony that he was constantly out there with a shovel, having to clear up, I would say so. It's a safe assumption to make.
Hindsight's 2020.
It is.
Oh my God. There's been some criticism of the board not tearing down their fence, not making them cut their fence, not doing things. Would you agree with me that the board is responsible for 174 units?
Yes, absolutely.
Was this fence affecting anyone other than the Ibezims?
Not at all.
Would you agree with me that the work that was done by preventative maintenance addressed grading and water displacement?
Absolutely.
And based on some of the questions you've been asked, it sounds like you have a law degree, an engineering degree, you're a general contractor, and maybe a hydrologist. Is that fair?
Me?
Yeah.
Yeah, all 4. No, just playing. No, I have none of those degrees. This is a volunteer position. Most boards are not made up of the individuals necessary to run a neighborhood. I think everybody knows that.
You're doing the best with what you got.
Exactly.
I asked earlier if this was affecting anyone else in the community. And we've also agreed that anything inside the fence is the Ibezims' property. So to tie that together, is it your position that if the water is solely inside their fence, it's their responsibility to mitigate and fix that?
Yes, absolutely.
And that's the board's thought process as well, right?
It's the board's thought process based off of the rules that we set up and the documents and I don't know if they ever read it or just signed it, but it's kind of clear as day in the ACC contract.
And you bring up a good point. Talk about the ACC request form. And I don't want to bring this back up on the screen or anything. Everyone's seen it 100 times. But in there, it talks about the fence is not being approved by the board. The approval doesn't mean that it's being reviewed for engineering or quality material purposes, correct?
That is correct.
And you touched on that earlier, and I think you basically said, we're making sure that the community looks uniform. Is that?
Yep.
Is that essentially why you're approving or disapproving?
Yes, yes.
And then that responsibility to make sure that it complies with codes, is built well, all those things go to either Pennington Fence Company or the person that hired them to build the fence. Is that your understanding?
That is correct, which is why we chose Pennington, because at least we knew the quality part of it. You know, they know their business, they do very well. So we tried to bring in a company that we knew would fit our standard.
So you're relying on the experts there to do their job, and you're trying to do yours.
Correct, correct.
Can we pull up Defendant's Exhibit 13 very quickly?
This is the quitclaim deed.
Oh, shoot. Sorry.
Sorry.
It is, you're right.
I got it, I just tried to share my.
Only one question about this. Earlier, there was some testimony through Mr. Silverstone, and I think Mr. Tolley, maybe, and just Mr. Tolley were asked about this. This quitclaim deed, just to get the jury back up to speed, is what passes ownership of those common areas from GeoSam to the association.
That is correct.
Right here in the top right-hand corner, what's the date that this quitclaim deed was recorded?
February 18th of 2021.
Say that year again.
2021.
You may object, state your objection, and then I may sustain or overrule.
I think you're misreading the document. I think it's February 21st of 2018.
Well, you can explore that with someone, but there are certain numbers on the screen and they're being translated by this witness in a certain way. Okay?
Okay. I don't know.
Is that how you read that?
I read it as the 18th of February, 2021. But honestly, I mean.
So I don't know who's trying to talk, right? Hey, excuse me, no juries don't talk, all right? You're welcome to write something down, but don't. Thank you.
I will agree, it was drafted.
It was drafted.
Correct?
Yes, that is correct.
But the draft date recorded date can do it.
They can.
Irrespective of the legal ownership status, the association still attempted to keep uniformity among the areas and the land, and still try to keep up maintenance and put in these remedial measures and did all those things, irrespective of whether it had true ownership at that time.
That is correct. That is correct.
You still do your walkarounds?
I do.
Since this new drainage system's been installed, have you seen any indication of clogged catch basins? And catch basin is a big green grate in the ground that the water runs down into. Have you seen any of that clogged or any of the gutter downspouts clogged?
Not at all.
There was some testimony earlier that there's 6 units in building 30 and they're stair step, they're terraced essentially. From the highest one, if I stand up on unit 1 looking down, could I see over the Ibezims fence a little bit?
You can actually see right over their fence from the unit next door.
Okay, so you don't have to go in to just be able to maybe not inspect, but just peek at it.
No.
Is that fair?
No.
There's been a lot of testimony about an inability to enjoy or do anything in that backyard. What have you seen during your walkarounds in that backyard over the course of the last few years?
Let's see. March 2021, the patio had 4 chairs, bunch of potted plants, a grill in back of that, small table with a pot over here. Behind, they had a round table with a potted plant on it. By May of 2021, they had, there's these black, I guess they planted plants. So there's these black, about this high with 4 wheels, and each one is full with new plants and everything. I don't know if it's vegetables or plants that they're growing, but grill's still there. Chairs are still outside of the patio area in the rest of the yard. Sandals, you know, I mean, looks like somebody's using it to me.
No further questions at this time, Your Honor.
Mr. Stewart,
Thank you, Your Honor.
you're welcome.
Mr. Smith. Earlier today, you pointed out, you said that you've been out there 20 to 30 times. Let me finish the question. In 2018, this time, on many occasions, you had been out there on rainy days, umbrella, looking right at that fence, and it had zero cause of the problem they had because the fence had nothing to do with it. Just wasn't anything to do with it at all. You remember giving that testimony?
Yes, absolutely.
You swore you stand by that testimony.
I'm not a liar, so I would have to.
Well, now you said you went yesterday or the day before, and you looked and the fence goes all the way to the bottom. Now maybe I'm wrong. Is that what you said just a while ago?
Well, yesterday it was raining, but I was here, so I couldn't check.
What day did you go out? You said you went out this week.
This week to see it, last night is when I went and looked at the bottom of the fence.
All right, so last night you went out.
Yes.
What time did you get there? When you got home from work here?
It was probably maybe 7 o'clock by the time I got there.
Why would you decide to go out there and check one more time, 7 p.m. last night, after you've been down there many times and went out there the week before trial? What made you decide to go back and see if that fence is already around that?
First of all, when we were talking about, when the question was asked about whether or not there was clearance underneath, that's based on what I saw at the time. I never said that there was a noticeable gap under the fence. I said water was coming out of the fence.
And that's the 20 and 30 times you went out there. Every time you went out there, you said the fence was fine.
No, you guys asked me how many times I've been out there. I said 20, 30 times. I said I saw free flowing water when I looked. I can't say every single time I'm sitting there looking at their fence. I'm doing walkthroughs of the whole community. But the times that I did look at their fence, there was free flowing water.
All right, back to the question. What made you decide to go out there? We got home, court, long day. I'm gonna go back behind the claims fence at 7 o'clock last night.
I went back there because it had been raining yesterday or the day before, and I wanted to make sure things were good back there.
All right.
That's what I've been doing for the last 5 years.
So it just happened to be last night,
Did it rain?
all day long.
Then there's a reason.
Do you go by there every time it rains behind their house?
I try to, but most what the idea that I'm in a court case about water and I'm not checking when it rains. I mean, unless you think there's some mass conspiracy going on, it would make sense that I would walk back there to take a look and see if anything is going on. You guys asked for honesty here, so I'm going to give honesty when I'm here.
All right, your honest answer is, when you put in the drain pipes, it fixed the problem. So I assume last night there was no water problem in the swell.
None that I saw.
No reason to then now say, oh yeah, maybe they should cut the fence. Why do you need to cut the fence? Let me finish the question. Why do you need to cut the fence 2.5 years ago? You fixed the problem. And last night now, maybe you all made a mistake. They should have cut the fence.
It wasn't about checking to see if I made a mistake. The video was extremely clear yesterday to everybody in this room. During a hard rain, not one person saw water going in or even going up to the gate. The bottom line is the problem that exists within the confines of their fence. And it's not something anybody at this point is able to maintain. I didn't go to look in, if I wanted to see the problem, I would have looked inside their unit. I would have gone back there and peeked over to see if something was going on in there. But right now, the problem is inside the confines of their yard, not the rest of the area. And that's what I went.
So now you believe it is their fault. It's all within that 12 by 15 area, whatever.
Yeah, I think we talked about, it was either Monday or Tuesday, how cases evolve. And this case evolved a lot yesterday when we went around and showed that video and you saw the lock along with everybody else in here. So that changes a lot of things. As we go through this case, a lot has changed.
Okay. When you got those 3 expert reports, they asked you about, oh, they said this and this. 2 out of the 3 said the concrete slab in unit 4 is a problem. You need to take it out and fix it. And because water's coming from that and flooding underneath. You paid to get that report for the HOA.
Is there a question?
Let me finish talking. I will leave you the question.
You did.
You read those reports and you believe that that was a problem that needed to be fixed. You thought that's what El Nino's report said, that had to be fixed. Mr. Duck said that needs to be fixed. Now you're saying it's just all within the 4 feet of my client's fence?
This states his testimony. He testified that they did remedy the issue. And now, to the extent there is water, it's maintained in those 4 corners of the fence. Not that there was never an issue that needed to be remedied. And I think Mr. Smith's misstating Mr. Smith's testimony.
Okay, well, Mr. Smith will remember his testimony as best he does and say that's not what I said, or if you're confusing the issue. My recollection is, in fact, the HOA did take remedial measures related to the slab by putting that board there and whatnot, but he'll answer as he sees fit.
Go ahead and answer that question.
And I apologize because I thought this was clear already. Because we specifically showed pictures of work that was done by preventative maintenance. So 1, I'll say it again, we eliminated the water that was even coming through there. 2, your client went next door and talked to those people and they wanted nothing to do with it. 3, I think we discussed today that Mr. Ibezims cannot report an issue for another neighbor. So there is no more water pouring out of that hole. It hasn't been pouring out for some time now. It's being used as an excuse, but there is no more water pouring out. And we have not heard of any more water pouring out since the remediation was done.
You said no water's coming out of unit 4 coming out of the fence.
No, it is not.
Let me ask you, you testified under oath. You swore we did not do anything to the slab. He said, the judge said, you put about board we put up. You knew nothing about the board being put up the other day. You testified to.
I actually didn't. I didn't realize that that's what they had actually done. I knew they did something, but I had never been in his yard to be able to see it because it's been locked.
You heard Mr. testimony that the 2 workers who sat there and they held the camera up and videotape you, and your client said they're going to defendants have to live it like that you're standing right there when they put the board up. Now do you remember, were you there when they put the board up?
I would love for him to show that, and I wish we could show it right now because you would see exactly where I'm standing. You would see, I was on, no, I was not. I was on the patio next door.
You need to not talk unless you're on the stand, okay?
I was on the patio next door. I have a blue and white shirt on, sandals. I know exactly where I was. I know exactly what I was wearing.
Okay, well, let's talk about that. Your testimony was not that you were outside the tent. Your testimony was, I never was there. I didn't know anybody did anything.
No, I never said I was never there. I was there to take pictures of the pipe, the drain pipe, but never did I sit there with any 2 guys and go into Mr. Ibezims' unit.
Did you or did you not testify that we did not do anything to unit 4 slab the other day?
We didn't do anything to unit 4 slab. The work that they did, they never touched the slab. They've put a barrier there, but that's not doing anything to the slab.
Oh, and the other day, did you testify that they went in there? You said that you never went out there at all at any time.
I never went inside Mr. Ibezims' unit. I think we're going around in circles. How can I get in there to see what's being done if we've proven that the gate is always locked? This is like, we're trying to make something out of nothing. And it's starting to come off as rather pathetic.
All right, next question.
And now you're saying today, well, you're right, it was the association's problem. But the other day you testified, it was a defect because the builder messed it up and it was terrible, not working on March 9, 2018, when they closed the house. So it wasn't part of, we do maintenance, but the defect was the builder's responsibility, and they should have done that, not us, because that's not a maintenance decision.
Are you quoting from my deposition or are you quoting from what I said earlier this week?
You swore on the oath the other day, you said that, you agreed with that.
As I said, and my thoughts haven't changed on the issue. I still believe that the original defect is from the builder. That's not anything that's ever going to change. But I also believe that from hearing the experts, you brought in Dr. Spots. And so a lot of what he said and a lot of what Trevor Schankweiler said, a lot has changed my mind in some areas. And that's usually what happens to everybody in a court case.
Is that right?
That's why we have juries.
People change their mind in 2 days after.
That's why we deliberate, isn't it?
Don't talk over each other.
Isn't that why juries deliberate? To think about things and talk about things?
Can't answer your questions.
No, but you can ask your next question.
And I apologize for asking, Your
Okay, it's a
Honor.
rhetorical question. You didn't need to answer it.
Now you also said, I didn't hear you September, like you said that the other day, and I don't know anything about him telling me anybody else. They complain about the trees. So therefore, it must never happen. But you were on the email that the defendants introduced to show that they were complaining, because we've been complaining to Mr. Tully since April 15, 2018. You received that.
But
Mr. Tully received it. Did y'all get together and say, wait a minute, you didn't complain to me on April 15th?
what email are you talking about?
You were sitting in the court. Remember you read that, even the last 3 paragraphs?
The first time I ever spoke to anyone regarding this, and my email, which I'm sure you have in discovery because I submitted it, was on the day I met Mr. Ibezims was September the 4th of 2018.
That's correct. I don't dispute that.
So what issue are you talking about? Are you talking about a 2018 issue?
But you got an email that showed that when we introduced it, he read to you, you got it, Mr. Silverstone got it, Mr. Tully got it, where he's talking about 8:15. I complained to Mr. Tully about the water problem. When you saw that email in September, did you talk to Mr. Tully? Oh, has this been a problem since then?
I don't remember which email. If you have it and you want to present it to me, I can look at it.
I don't know what number it was, but let me find it. Attendance exhibit number 18. Read the last 3 sentences.
Sure can. Let's see. We have been asking about fence and concerned about flooding, so we wanted the fence to protect us.
What's the date of the email you're reading from?
This says September 9th of 2018.
Keep reading.
Okay, we have been asking about the fence and concerned about flooding, so we wanted the fence to protect us. I thought it was for the family, but because nobody was helping as the cover-up began.
You're reading less than 3 sentences?
From an email from September of 2018.
Yes.
And you're talking about April.
Are you reading the last? Well, I'll read it to you. I can read it up there.
Whichever part you have in parentheses, that's what I'm.
The first time I called Tully Management, says, via phone records on April 25th, 2018. And nobody was calling back, so we advised to get everything in writing. Yeah, email or letter. That was sent September 18. It shows you received it, Mike. Who got copies of it?
So the email that you're saying everyone received was a September email, and there's language in it where someone alleges a phone call was made to Mr. Tully Management in April. You're referring to an email from April that you said Mr. Tolley was copied on.
It said that email was sent. September 9th, 2018, sent from Kia to you, to Mr. Tully. Everybody talking about the problem, and her emails tells you, and it's talking about the water problem.
But you don't have an email from April, do you?
I did not say we had an email from Lisa. I said that documents the fact that the first time I called Tully man at April 25th, 2018.
Okay, I misunderstood your question. Your question sounded to me like you were saying, what about that email that your client sent to someone in April? And there's actually an email in September that makes a claim that a phone call was made. And we're talking about the same thing now?
It's the email that documented the first time they notified the Tully management.
Okay.
That went to him, went to Tully management, and the Tully management would call up and say, wait a minute, I don't remember that. Or did you contact me and say, what happened back in April?
So an email went to me in April 2018. How did he contact me? I'm curious because we didn't.
He says they went to Tully management. They went to Tully management and the management company like was supposed to through the portals on April 18th. I'm not saying they contacted you. I'm not even saying you knew anything about it until September. I'm not disputing you said September 4th. But this document that he did complain that water did have a problem starting in April of 2018, and none of you disputed that. Nobody came forward and said, wait a minute, we didn't hear anything about that.
I believe that email as much as I believe that there was no lock on the gate, which was told to us 3 days ago.
Okay, let's talk about the lock. He said it ain't the lock anymore. Once he put the camera outside the back door, and therefore he could see if somebody came into his unit. And therefore he didn't need to lock it anymore. The video was taken to show a camera outside for him. He hadn't put the camera inside the unit at that time, had he?
What?
What?
What are you?
His testimony.
He has 3 cameras on his gate. He has one on each side. And I think one, well, maybe 2. He has one on each side of his fence.
He didn't have a camera on the inside that showed against the fence where people could come in when that video was taken. He did that afterwards, and then that's when he stopped locked the door, correct? You know that testimony?
I'm not understanding. The video that I saw clearly showed, I think with everybody else who has eyes, that there was a camera. We stopped at 8-second mark. Mr. Dorsey said, is that a camera? The answer was yes. We moved on to the 11-second mark. And actually, let's back up about 10 seconds. Your Honor said, is that a lock on the gate? And then Mr. Dorsey said, oh, Your Honor, you're stealing my thunder. And everybody laughed.
But the question was, they saw the camera. That video did not go inside the gate. It showed a camera outside. It didn't show a camera on the inside that would make it safe to leave the fence unlocked, was it?
Everyone in our neighborhood has, what is the?
Mr. Ibezims put the camera up by his outside door.
Illegally.
So 2 different things. One, don't testify for your, ask a question and don't tell the jury what your client may have told you.
All right. Do you know when Mr. Ibezims put a camera coming out his back door facing toward the gate door so he could see if someone was coming through the gate or not?
I have no idea when Mr. Ibezims purchases cameras. I don't know when he put his cameras up.
And that camera is not shown, there's not one outside his door when that video was taken, was it? You can't see inside the fence where the camera.
No, we can't see inside the fence. We can see that there's a lock. We can't get inside the fence. There's a lock on the fence.
Okay, this is Trevor walking up down the fence. So he comes comfortable and said, I don't need lock doors because I got a camera. I can see when someone comes through the door. That was no camera at that time, was there?
I'm not concerned with what Mr. Ibezims, his motivation is for putting cameras up. The bottom line is there's a camera, illegal cameras, which I thought they would have learned their lesson by now. The bottom line is this case, we're here right now because of people's inability to read contracts. And I would have thought that they would have learned from this experience before putting up cameras, which require ACC, because there aren't just cameras on the back of the fence, there's cameras on the front of the building as well, which replace lanterns. Those are architectural changes. You would have thought your clients by now would have learned, oh, I'm going to follow the rules, I'm going to read some documents, but the same pattern keeps progressing, which is what got us here originally. You're asking, quite honestly, irrelevant questions. The thing is there. I didn't put this here. The association didn't do anything. Water's Edge didn't do anything. Your clients have a locked gate for which it was made very clear what the consequences were. And that's what we're dealing with. You're asking, can they see inside the gate? I don't know where they can see.
You say you shouldn't have cameras. Have you sent letters to them and maybe take them down?
We haven't sent anything to him because every time we do, we get sued. Right now.
4 years ago, right? And you talk about the gutters. And you kept saying, oh, it really that much water after all. Maybe it did get flooded in because inside the house, inside the house. How many times were you inside his house?
I've never been in the Ibezims house.
All right. And so his complaints to you, what you investigated, why you ordered 3 reports, is determined about the flooding on the outside, correct?
It was regarding, they brought up the issue of flooding.
Yes or no, then answer. You got 3 reports trying to solve the water problem that you were 100% convinced from your business that Water's Edge had created.
Yes.
And it had nothing to do with how many times we got into the house or whatever. And you never been in the house, you said.
I've never been in their house. Somebody told me they had flooding in their house. So the HOA acted to fix the problem.
Okay, so now you're convinced because there's not been much flooding, but you heard a lot of people say it's flooding in the house all the time. But that's not the conversation you had with the plaintiffs. Your conversation about we're going to try to fix the outside problem because Trevor came way earlier and worked on it. You didn't have anything to do with the inside.
The two were associated together. Let's not pretend like we haven't been talking about the same things. The fact that they got water in their house was a result of the outside. We've been talking about that all week. They didn't just magically get water inside. They claimed that it came from the swell. We've been talking about swell all week. So the bottom line is the HOA acted, got the swell taken care of. Now we're being told, oh, well, water's coming off the gutter and it's not going away from the house. Well, we can't investigate that. 1, there hasn't been a work order for it. 2, we can't even get into the gate.
How do you know that? You see one video in 2020. You don't, in the last 3 years, you said there was no problem with getting in, or you want to get in there or anything. Have you been trying to get in the house, but you couldn't get because of the lock there?
You think, you really think I'm trying to get into the Ibezims house?
I think so. It makes it sound like you were.
It's not, this is common knowledge. The bottom line is, like I said, I walk are you guys you guys are not in a 2 days ago, the words were used, a lock has never been placed on the gate. Then yesterday, it changed to a lock has been placed after the cameras were there. So everybody has been told something different to suit what was going on. Yesterday, we saw the truth.
What is so significant about being a lock and not a lock?
Because it proves that you're responsible for your yard and the effects of your yard. That's a big deal.
What's the big deal? Does he have grass in his yard at all? Has he had any grass for 5 years in that yard? Isn't it just dirt because the water's flooded so much that there's no grass at all?
Unfortunately, that's irrelevant to me because I don't get to see in there because that has never been, we can't have grass. Well, guess what? Your gate's locked. So guess what needs to happen? You need to call someone to get your grass planted and you need to manage that grass because your gate is locked.
All right. But there's no reason to have you come in to cut grass if there's no grass, is there?
You can't create the problem.
Strange directions because the question was, gosh, they have no grass. And he explained why they can't do anything about it. And your next question is, well, why weren't you going in there to cut the grass? So let's,
What's the need to go in the house besides cutting the grass? What else would the home association want to get inside their fence other than to cut the grass like they do to neighbors?
Well, guess what? I don't have grass either in my
Just
backyard.
answer the question. Why do you need to go in there? Why would you want to go in or willing to go in if there's no grass to cut? Well, whatever.
Are we worried
already
about
answered
grass
it.
or are we worried about gutter repairs?
Right, exactly. Next question.
So for 5 years, you're accepting that Board of Ed caused the problem. My clients have worked with them. I know you're mad at them and all that. But you always thought it was a problem caused by the tenant. But last night at 7 o'clock, you went out there and now you changed your mind. It's all their fault.
One, it takes 2 seconds, Mr. And I explained that in my testimony. From my house to where they are is literally like a 2-second drive. So it doesn't take anything for me to pull up real quick and just say, boo, hey, everything's good, and be gone. Simple.
One more thing. You said T was lying on the stand about wait till that you told her to wait till the warranty wears out. She was lying on the stand when she said that.
So
He said he disagreed with it.
I said I disagreed.
All right. You disagree that she was not accurate. She wasn't telling the truth.
Yes, absolutely. And I'll elaborate.
Okay, we first distinguish between she was lying.
He didn't say lying.
I didn't say
You
lying.
said lying.
I know, I say distinct.
I'm not going to distinguish something I didn't say.
Not telling the truth.
Your Honor,
You need to ask a different question.
What did, they went in September 2018 and got the warranty and was turned down. October at the time was when you said, wait until then, if they don't fix it for you, because it's their responsibility, you wait till March when it runs out. We'll help you then. Be nice with her. And that's what she's testified to. You're saying you didn't tell her that?
we said when their warranty runs out, we would help. No one told them to not use everything at their disposal. They were told to use what was at their disposal. The bottom line is 10 years ago, I had a Nissan Murano. I'm still answering.
You opened this topic.
It's gonna tell me a 10-year.
I'm still answering, I thought. I thought this is
I'll
relevant.
cut them off if I find it to be non-responsive.
10 years ago, I had a Nissan Murano, and Nissan told me, because I did not put oil in the truck, that they would not cover my warranty when my engine blew. That was a Sean Smith problem. Guess what? I got an appeal. I submitted the appeal. And a month later, Nissan wrote back, we will cover this. No one told them not to file their appeal. And the excuse that I'm from New York City and I didn't read the paperwork and I didn't know how an HOA works. I'm from New Jersey. And I've been down here 20 something years. And I knew immediately that I moved into an HOA. It's common sense, for one. The excuses that have been used are preposterous.
Okay, so how does that answer my question about, did Tina tell you that? What did she not tell the truth about, which is on the stand?
How you phrased it the first time is not the same that you're saying it right now. You phrased it as that we told them to just I believe let was the phrase that you said, let their warranty just run out. No, you do everything within your disposal. And we've talked about it for days. They did not follow the steps. They were given, it wasn't like the people said, we're not going to give you an appeal. It wasn't like the people said, oh, even though they may not be warrantable items, we're not going to cover them. They said, if you disagree. They said the land was dry when they sent someone out there. If they had so many videos of water, it's answering the question, Your Honor. They should have submitted those videos.
Different question on a different topic, because we are.
If you ask me
really
questions,
stuck.
don't complain when I answer, please.
We are going around and around.
I'm trying to get them out of here, but sorry.
Next question.
They went to the homeowners, they called the county. Went to you, they did everything they could. They had the warranty people come out afterwards, order said shut them off. Warranty people said it's not covered because it's in the swell. Trevor told you it'd be ridiculous to spend the money to appeal because it's outside the swell. They waited till the end of the, patiently till their warranty ran out in March, the time you told them to wait. And then they came to you and you hired 3 experts, maybe 3 people to look at it, whether they pay them or not. They did exactly what they were asked to do by you.
Objection.
And
Hold on, and the question is what after you
Is that
just
true? Yes
testified?
or no? You said they.
that is correct. They, after their thing, we did what we needed to do.
You said she was not telling the truth as far, they didn't do all the.
I've already
moved on.
explained
Let's
that.
stop. We have moved on from this not telling the truth. You've covered it as far as I'm gonna let you cover it. Next
My
topic.
question is, when you say she didn't file the appeal now, that's why she didn't do what she's supposed to do, she didn't file the appeal.
They know what they didn't do. They know what was at their disposal and what they didn't do.
On the appeal that they should have done, they didn't do.
The appeal would have been a very important part.
Mr. McLeod, anything else for Mr. Smith? Mr. Dorsey?
I just want to correct one thing. We did look into the deed issue, Mr. Smith, and as the point I was trying to make with the deed in the first place was that regardless, the association had, while maybe not taking formal ownership, had taken responsibility for it, which I think we got across. It was filed in 2018, so we had
Okay.
formal ownership and action because of it.
Well, I apologize that I read it wrong.
That's the only one thing.
So that stamp that said 18 Feb 21 is actually, it's like European or something. That would have been the 18th of February. No, it would have been the 21st of February, 2018.
Correct.
Okay.
Okay.
So I just want to clarify that for the jury. Nothing further, Your Honor.
Mr. Smith, I'm going to see if the jurors have any questions for you.
Okay.
And then you'll be done. Jurors? Deputy Williams? There he goes.
Excuse me, sir.
Thank you, sir. Got a lot of questions about you not putting oil in your engine.
We needed that.
When you use 2 different writing implements on the same card. That's funny. You guys also hit the century mark on questions. Word. All right, be at ease for a little while. Where's?
Can I look at her? Can I look at her?
I need one for the road.
Oh, okay. Oh, then that's fine. Deputy let it go, but this one doesn't. Sorry.
Yes. Yeah, that's super long.
What?
Get it down, second
Oh, yeah.
Yeah, they didn't really think about every single farm things against each other.
You know which colleges are coming down, Florida A&M coming down.
Florida A&M, Tennessee State, Norfolk State, Alabama State.
Who's the Sonic Boom? Who's that?
That's Jackson State.
They
The
come.
Sonic Boom in the South. I don't know. I want to say no. Who was the? It's the band we're talking about. Oh.
Work, I have to get.
And then like.
You're gonna have to do that work and my work.
Was like in a was like which is.
So when the kids fly.
That's when you would be there.
Oh, the night person, I'm not a work.
That before, and then
I draw
there's
everything I need to do.
No, but it's just, it would, it makes sense.
24 hours.
Gamecock. The gentleman run against North Carolina AT&T. They got a smoke track too.
I probably saw them once in my.
They got some running.
You know, my best friend was the assistant head coach, and then she, until last year, and she's at Tennessee now as assistant head
So
coach.
they've been putting out.
Yeah, she was there for like 10 years.
Yeah, one year they almost won the whole thing.
Oh, they've been breaking records, like especially on their field side.
Oh, I didn't know that.
Yeah.
400, they was running.
Yeah, they've been. I'm so proud of them.
okay, no, South Carolina. South Carolina. And North Carolina.
They come.
They are coming. Yeah. It should be fun.
It's like I do like a Easter or something.
I always watch that movie, Drumline.
No way, am I getting early?
Yeah, stomp the yard. I just stomp the yard on the dancing part.
Throwing a trombone is you want a fresh.
So he's been on the step show.
Oh, back in college.
That
was a long time ago. I'm old now.
What were you? Number one?
I'm number one.
Is grandma not there?
There's, I love it.
For the Battle of the Bands tomorrow? No.
So what, they just play like, I thought they did something too, like them.
They perform, they go.
The next ones are winning.
Oh,
Or is that
they're
something
always,
that-
they're different.
Oh.
They have like their
You're not.
Savannah State, Norfolk State, Tennessee State, South Carolina State, Bethune-Cookman. Oh, really? Yeah. That's new.
Wait, so why didn't they put grandma in there?
Yeah. They have to, I mean, you have to sign up for whatever activities you want, and North Carolina.
And then the money raised goes to,
They just do different.
the money raised goes to.
Oh, it's
okay.
different. Where's it gonna be? And this one's at Montgomery.
Yeah, I used to go to them, I just got tired of hearing the same song.
They play different songs, don't do
Play
that.
different stuff.
They play different songs, don't do that. You just stop supporting. They play different songs, they don't play the same.
Yeah, my kids says they learn a different field show
Every year, they got.
The one I went to, they played the same, each band did the same song.
That must have been high school.
Yeah.
They always
No,
play the
it
same
was
stuff.
college, it was college.
But they played more, each band played more than one song. So they didn't have a
They
song.
play like for
You
hours.
just don't support. Dion talking about you.
You're not a band mom?
Dion talking about you. There you go. Everybody not play the same. They might have played one song, but they had different selection. You're not a band mom.
You're gonna need to sit.
You need to sit.
You're not a band mom. Sit.
I'm not a band.
Now, if there's something dealing with nursing, you got that, but you're not a band mom. We thank you for your services.
You're right, I'm not a band mom.
You know how they have those shows about those crazy dance moms?
That's correct.
That's you.
That's us.
That's
Crazy
right.
band moms.
That's right.
Whichever's band. We are crazy.
And them band fraternity, they was
You know
serious
what
too.
I love?
I'm trying to think out for the band. They was-
Pledged in the fall.
Did he?
This is the best marching band they used to have with Morris Brown. And when they went down everything.
They used to come down every Thanksgiving up on that bridge right there.
There's lots of great marching.
There's lots of them.
I mean, I like watching, I love watching my kids perform, but I love watching other people perform.
The best bands in Atlanta are the cab bands because a lot of the directors came from Florida and them back.
Oh, yeah, they can.
South with the Cavs, Stevenson. Because they do what they call the fifth quarter. And and I was there 1 year ago. And South with the Cavs played. The game was over. South with the Cavs played the song. Stevenson played the song. South with the Cavs played the song.
What time did
We
the
went to
game?
Creekside.
Where?
It's no game. It's
So
at
what
3
time
o'clock.
is?
You in the Creekside?
My son went to Creekside.
When he came out?
So
Okay.
he's on.
Because Eric Berry came out that year ago.
We came out and taking a test. And we went to-
Okay. Down in the swamp.
Oh, yeah. I spent many hours.
You ain't no band mom.
You keep telling me that.
I just have fun. That was the name of the band.
Thank you. But I can still go see. You can.
But you can't be telling everybody playing the same song. Everybody plays so many different songs.
They play so much.
I'm just telling you what it was when I was there.
Y'all try to quiet down for me. Y'all try to quiet down for me.
What year was that? What year was that? Leave that on. Yeah, okay. Those support, baby, support. Dion talking about you. I ain't saying they had a band years ago. They did moon. They was doing it was Texas, and I was they had the whole thing moved like Michael Jackson. Yeah. You got a full ride? I don't know, man, get a full ride. Awesome. Women, everything. He's pretty tough. Because she had to audition for that too. I wish I could play the saxophone, just serenade. Game card. You played in the band too?
He's a runner.
Those volleyball.
Nah, one sport.
What field event you did? You didn't feel it?
None.
No long jump, triple jump. You
One
look like a
job.
high jumper.
I had one job. I was a specialist in that, and that was it.
You like you could jump, but you athletic one.
I don't have any coordination.
Are you serious?
I'm terrible at basketball. I love it, but I can't. I don't know what I can't. The one that can't.
Your kids don't play?
No, like my kids are real artsy. They're so artsy and liberal and like.
Your younger kid, how old are they? How old are your younger kids? You say?
3 and 5.
That 5 a boy?
Girl, both girls.
Yeah, spoiled and the mess.
They're just like painting rocks and counting leaves and planes
They gonna be pretty.
and
They gonna be
beaches.
How tall are you?
How tall am I? 5'9".
They gonna have height.
I don't know, because my husband's only like 5'10".
Okay.
So I don't know, maybe they'll just be average height. I'm just glad they're healthy.
Yeah, that's good.
You know?
He's in Washington.
Oh, here, this is perfect.
Oh, she's 4'11".
Okay, okay.
That's so cute. I always wanted a like, you know, taller. Just, he looks good in pictures too. Like you can wear some nice heels and not be towering over you.
Yeah.
Yes. To talk to her. I'm like 7 and 8 pounds, baby.
You were heels, you called me ugly. Does it offend them?
When we were dating.
Court, come to order. Hey, Steve.
Let me get the other council, please.
Thank you. All right, I'm just trying to get these in order so we don't bounce around too much. Let's start with America's favorite subject, the fence. Explain to the jurors why the homeowners association didn't insist or require that the bottom of the fence be raised a little bit, given that that part of the fence, really all of the fence, is in the common area.
So this conversation actually was had a bunch of times. There's a lot that you guys just we're not going to go into. We'd be here probably 9 months like the other trial. The bottom line is, it is a conversation that was had because that obviously was the easiest solution. Removing the fence, at the end of the day, cutting the fence was going to create problems.
So I want to be clear. I apologize for interrupting you. The question is very much focused not on removing the fence, but the less drastic measure of removing 2, 3, whatever the experts would say. If you just get the bottom 3 inches out of the way, things will be better.
Yes.
Okay, so your answer should focus on that and not a more drastic of, hey, you know what, no more fence.
Sounds good. So that would have been the easiest thing. As you all know, it was also the advice of others. That would have been much easier for us. We at the point that I submitted the restraining things, we were done discussing anything more. Simple as that.
But prior to the time where it became necessary, appropriate for you not to have direct interaction with the Ibezims, there had been discussions about, hey, one thing we could do here is remove a certain number of inches from the bottom of the fence.
Correct.
And was that an option that the Ibezims entertained?
It is no, not that they entertained. It is an option that everybody else entertained.
Did the Pennington, is that the name of the fence
Yes.
company?
Yes.
Was Pennington told anything about the fact that the fence might be extending into the swale?
Not by the association, they were not.
Okay. Did you, when you learned from the Ibezims that there was water intrusion, water coming into their house, did you ever ask to go into the house to see what the water intrusion looked like?
No, and I'll tell you why, because
that was my next question.
We were being told something, but it wasn't. It was almost an exaggeration. Well, not almost. What we were being told was an exaggeration that, quite honestly, it just wasn't credible. When the word flooding is used, but then you're only asking people to replace baseboards, like that wasn't an issue. If I tell you there's flooding, usually it's, hey, my couch is messed up, my carpet's messed up, this is messed. If you tell me only baseboards got messed up, that's not something the association is going to jump in on, because that really is an issue for the builder. And that was, quite honestly, is a small issue. It's not something that's going to put you out of your house or inconvenience you and your family for any meaningful amount of time.
Having heard some information about maybe excess runoff from the roof because the gutters aren't functioning properly, does that change any assessment you would make about whether some of the water intrusion and maybe erosion in the Ibezims backyard is due to runoff from the swale and some fence intervention thereof versus water that be coming off the roof?
I believe that at one point there was an issue with the swale. I do not believe that currently. I believe based on questioning that was brought up by Mr. Stewart, that they're now dealing with dripping from their gutters. And that is a completely separate issue from this. And that is something that will be addressed by the HOA through normal means. And I think everybody saw yesterday in the video the swell and whether or not it was full of water or not.
Tell the jurors why you didn't share with the Ibezims the engineers in the El Nino report, the report you all went with, their recommendation to remove a portion of the fence. Even though they may not have wanted to do that in terms of doing due diligence, homeowners association, hey, we hired an expert, and it's not just Sean Smith, your roving chair of the board, but folks who specialize in this saying remove part of the fence.
Okay, so when we met with the Ibezims at the firehouse, we read the entire report. Okay, we went through both options.
And when you say you read it, just so we're clear, you read aloud to them, or you gave them a copy and you had a copy and it's let's read along together?
No, we read the report to them. Usually, how it usually works is we don't share information with other residents. This is like the first time we've ever had to give information, and not that we had to, because we don't have to do anything. We shared information because we were trying to help them. So we read alternative 1 and 2. The reasons that logically, if you look at the 2, there's not that much difference. The gate, and I believe, or the fence, and I believe the cutting of they wanted to do the soil substrate test or whatever. And it says at the bottom of that report, I believe the only difference is X, Y, Z. We could do option 1, our version of it, and see, did it yield results before we jump into the other? Everything else is still an option. But the logical thing to do is let's see if we eliminate the water. Let's see if everything else is fine. And keep in mind, nothing else was wrong with any of the other units. We're only dealing with 1 unit out of 6. And this isn't even an N unit. So everybody else was fine. So it didn't make sense to say, hey, let's go 100% and do all this and do all these tests and everything, when erosion is a pretty common problem for one. It wasn't like we had this huge sinkhole that was going to swallow the building. We had an erosion issue, simple as that. And the bottom line is we did the step. We could stand out there and see, and I've said it before, all the water that was coming off the buildings, where it was going, it was clear as day. So if we could eliminate that water, there shouldn't be an issue. And we did exactly what needed to be done, and there is no issue.
Do you agree that the Ibezims could have kept their fence right where it was if they had agreed to remove a few inches along the bottom? That, in other words, the remaining 8 feet, however tall it was, that wasn't the issue. It wasn't that it blocked wind or airflow, but if consistent with the El Nino report, they had agreed to remove the lower portion of the fence, they would have been allowed by the HOA to keep the rest of the fence in place.
Yes. Logic, and in line with Mr. Ibezim's testimony that he's shoveling dirt all the time, all that dirt, he said, came from upstream. So it makes sense that within the confines of the fence, all that dirt changed the level of the swell. So like if you look there now, I'm sure you wouldn't see a swell anymore because it's been filled in with dirt. Had they done the original, water would have kept freely flowing at all times. And I think I'm pretty sure the swell would have just kept its shape, the contour of the land. So I think that would have been the easiest option, but it just wasn't going to happen through no fault of the association.
There was in the video we watched yesterday, the 2020 Chunkweiler video, there was pine straw throughout much of the swale, and there was pine straw that was up against the Ibezims fence. Is that something that the homeowners associations, landscapers would have put as whether beautification or water runoff control?
Yes, we do that regularly throughout the community. So well, when I say regularly, I think we do pine straw twice a year. Yesterday was actually, I sent approvals for our annual pine straw and our annual gutter cleaning. So each week on Wednesday, our landscapers come so that, as they're blowing and everything, if they see stuff clumped up on the side of the fence, technically they're gonna handle it, just because it's right there and they're blowing anyway. But those are the types of issues that the homeowner truly would be responsible for, because it's not through anything caused by the association. If I choose to build whatever in my backyard and I have association approval, I also have to deal with the consequences of my actions. I can't ask the association to handle something that only benefits Sean and his family. It wouldn't be fair.
So a few questions about your or one's ability to see into the enclosed yard area of the Ibezims because the fence is there. You've testified at times, I can't see if there's a camera by the back door. I don't know what's going on in the backyard. You also provided some testimony about, depending on where you stand, I know there's some chairs and they've got some planters. It looks like maybe they're growing an herb garden or vegetables or something, and even sandals. So like that level of visibility. Reconcile the two for the jury. I don't know if there's a camera there. I don't know what he's doing on the inside. That's his space because there's a lock versus, let me tell you, it appears to be occupied and used.
Okay. So for the purposes of this trial, obviously I familiarize myself with everything up until the point that the camera discussion even became, an important issue through testimony by Mr. Ibezims. I don't pay attention to cameras. There's cameras throughout the community. If you look at my house, I have 1, 2, 3, 4, 5 cameras around my house. So the thing is, you just like the cameras weren't my focus. The making sure that they were had the availability to use their backyard. That was the focus of me looking and seeing, are they actually doing anything back there?
So you have cameras up. The Ibezims have cameras up. You described theirs as the ones you've seen as illegal. I didn't hear you apply that label to yours. Tell me the difference, other than you're the president, that makes yours okay and theirs not.
So mine is, mine was an ACC request was done. For one.
So actually, better yet, describe to the jurors the steps one should take if one wants to have legal, approved by the board or the ACC cameras.
So something like an ACC camera, I mean, it's the same form, basically. You just fill out the ACC, you tell them, I'd like to install cameras in these locations. In regards to mine, I have cameras by Vivint, which is home security. So you just fill it out. I mean, it's not hard to get approval for anything in our neighborhood unless it's going to, block somebody's view of something. Like if you told me you want to double the size of your unit, that kind of stuff we would never allow. Anything that's going to cause a foundational issue or anything like that. But ACC requests are very easy. We get them all the time.
How do the residents know for what they need approval? I'm going to change my mailbox. Well, you know what? You can't have a wood mailbox. It's got to be a metal mailbox, but that's rule 419 in the rule book. how do I know that to put up my Ring camera or Vivint or whatever, I need to get the ACC blessing?
So you would, anything that is an architectural change, you would submit as an ACC. There's no way as a resident, you're going to know everything that's approved. So what will happen is you would get a rejection letter, but it will also tell you why. And then you know what steps to take and make the corrections. And then we can go ahead and approve you. It's the same. I mean, it's pretty much the same industry wide. ACC requests just need approval. Usually we need to make sure that the work being done on your home is not just some guy that you met at Home Depot. So we usually will make sure you have a certificate of insurance and a business license, because at the end of the day, if there's damage done to the building, we need to know that there's somebody that can actually pay to have that repaired, or their insurance.
If you and your colleagues on the board are doing your walkarounds and you notice something like a camera that's been installed, I don't remember that being there before, for something as much as you've removed a fixture, there was a lantern or a lamp there, and now it's a camera, does that resident get a notification, or how does that play out? Assuming, again, what went up was not ACC certified.
So usually not usually, you will get a notification. At that point, either, depending on what the violation is, either it will be like, we've had people put monuments in their front yards that obviously are going to kill the grass after, a few weeks. Those types of things we would say, please remove immediately. If it's something that others have in the neighborhood, our only ask will really be, can you please submit the paperwork?
So you can do it retroactively. You should do it proactively.
You should.
You don't make them take the camera down, get the approval, and put the camera back up.
It only becomes a problem when someone says, well, I'm not going to do it. As long as they handle we're a very easy board to get along with, extremely easy. We believe in community in our neighborhood. So everybody kind of knows everyone. If you handle yourself correctly, it'll be taken care of.
So a fine would not be assessed if upon notice you needed to get an ACC approval for this, please submit it, assuming it's approved by the ACC. There's not an issue.
Really, no. Like, we may issue a fine occasionally, but usually, for example, the other night I came home and someone that I had spoken with repeatedly had parked a tractor trailer in the neighborhood. And I knocked on the door and I said, and because I had already emailed the management company and told them issue the appropriate fine. After the homeowner and I had a good conversation and I found out the reasons behind, they were reasonable. It was a child involved and everything. I said, I understand. And I told her, I said, you did get a fine, but I said, but I will speak with the board and we will take care of it.
Have you, or has the board, or whoever it would be, provided notification to the Ibezims that the cameras they've installed weren't approved?
No, we haven't done anything yet. Specifically because of what's going on here today. It's just not the time to address that.
Okay. Want to go back to the day when your vendor, meaning the HOA, had hired someone to do some work in the gap underneath the slab of the higher up unit from the Ibezims.
Okay.
And there's been testimony you weren't there, you were there. And if you could clarify for the jurors whether you were there and where you were, not inside the fence. You made clear I was not inside the fence. Workers were, and they were doing whatever they were doing. Were you in the vicinity of the Ibezims unit when that work was being done?
So, okay, if you're looking down towards the Ibezims, when the work was being done, it started at the first unit. There was a large trench going all the way down the building. So I came up this way on this side of the building. The guys were in the ditch, digging the ditch because it had to be done. They did it by hand. So I took pictures of that just because if anything ever happens, I like to know what's happening that I can show somebody, hey, here's the work that was done. Like, this is real work being done, because we didn't want anybody thinking that, oh, you told me this, but nothing ever got done. So it went all the way down. I walked down, stopped at if I'm looking at their fence, I was on the left side. I went to the right patio, which is the neighbor on the right side of them.
Meaning lower down or higher?
Yes,
up?
lower,
Okay.
to the last unit in the building. And I believe that's the picture that he has. I had on shorts, blue and white shirt, Gucci sandals, standing there. So it's no secrets. It's just, I was standing there to see the work that was going on, not spying on anyone. That wasn't the objective.
So were both pieces of work being done at the same time? The installation of the pipe, I'll call it a drain, sort of the subterranean swale, and the work underneath that slab from unit, I guess it'd be unit 4 if they're unit 5. But in their yard, in the Ibezims yard, there was work done. I think there were a couple guys in there. Was this the same day or different day?
The day I was there, I was only there for one day for any meaningful amount of time. And then I believe the next day, I simply came to look at kind of the finished product once it was almost done to see what. So the main pipe was laid, pine straw on top of that. And at this point, I believe they were just connecting the downspouts to the pipe underground. So
the water issue that existed before that remedial work was done, the pipe put in and the downspouts directed into it, that resulted in some of the water flow you discussed in your earlier testimony. You're out there in the rain and water going under the fence, et cetera. Was that water issue, in your opinion, an HOA issue or a water's edge, i.e. builder issue?
Okay, we're talking about the water. This is after we installed?
No, sir, before. So this is before. This is before that goes in, because your testimony, as I understand it, is once that big pipe went in and the downspouts were connected, we had a scenario like we saw in the Schunkweiler video, where there's a little rain on the ground because it's raining.
Yes.
But we've seen videos where there's a whole lot of water in the Ibezims backyard, and we got those dates, and that clearly predates the installation of that big pipe. And so my question is, is it your opinion that that water issue, the water that is intruding into the Ibezims yard before the pipe, is that an HOA issue or a builder, i.e. water's edge issue?
So I will say my answer has not changed. I believe it was a water's edge issue, but I will say that sitting through this trial, you learn things. I'm sure you guys have learned some stuff about this type of stuff. So there are nuances where I've heard Mr. McLeod say things, and I'm not going to say that I disagree with his thinking because it made sense to me. But at the same time, there's things that Mr. Dorsey has said that I'm like, oh, well, that makes sense too. So I think there's a fine line. But if we're going by documents, then, water's edge had nothing to do with this, I guess you could say.
Mr. McLeod, any follow-up questions having had that exchange? Okay. Mr. Dorsey?
Mr. Smith, I just, excuse me, want to clarify one thing with regards to, we've talked about evolving opinions.
Yes.
I want to be very clear that at the time that you were addressing this issue, okay, so not in the chair you're sitting in now, at the time that you were addressing this issue, it was your opinion that water was able to flow into the fence and that this was a displacement issue that ultimately the HOA's decision resolved.
Yes, yes, correct.
And I think what you're saying is now, if there is a secondary remaining issue, you have been convinced that maybe we should look at the fence. Am I saying that accurately?
No, it's definitely, if their claim is that there's a continual issue, then it from what I heard this week from everyone, I have to kind of look at all of the factors, take a closer look at the fence, And it makes sense that the fence, if something as simple as cutting the fence can end this issue, it would make sense that that was a sensible step to take.
But the things that you've already addressed as the pool, you do contend were caused by water settlements.
Yeah, I mean, the original stuff, because at the end of the day, Mill Creek Lakes did not create the issue. Tully Community Management did not create the issue. This goes back to GeoSam. I think you've heard Mr. Silverstone and Shonkweiler talk about GeoSam. The initial issue, I stick to my belief of it. I do believe it was a GeoSam / Water's Edge issue. And the reason being, I will agree with Mr. Stewart on that, is that property that sits for 10 years changes a lot. And do I think you can just solve that with a Bobcat? I think it takes a little more.
Mr. Stewart, I'm sorry, you sort of interrupted there. Are you done, Mr. McLeod? Are you done, Mr. Dorsey?
Yes, sir.
Okay, Mr. Stewart, do you have any questions for Mr. Smith?
I was gonna show the video if he can bring it up. I'm not sure. He hadn't told me if he's able to bring it up.
Is this the video that you are saying for whatever technical reason has to be played outside of the Zoom?
Clyde has it on his phone. If we can hook it up to something.
Let me see.
Well, we're not going to wait very long to do this. So if it can't happen, that is not going to be a jury issue.
It's not working from.
Okay. So if you have a way to make it work, Mr. Stewart, you've got about 30 seconds to make it work. Otherwise, if there are other questions you've got for Mr. Smith, he sits ready for those questions.
Right. Yeah, I'll just ask one question now. Everybody said cut the fence. Did you, any of the 5-member association, Mr. Tully, ever tell Tia or Chris you need to cut your fence?
We discussed it. We did not tell them. And the reason being because, to be honest, and I've really been trying not to go here.
Objection. I don't care where he's going. That's my answer. I don't need to hear it.
Okay. I didn't think so.
Normally we let
I didn't think
folks
so.
explain their answers.
Can I explain or not?
Well, go, all right, go ahead.
Well, but you know
Criticize
what?
my clients.
Let's not.
Okay.
Let's,
I don't think
you discussed it with them, but it was not a directive to them. Is that a fair statement?
I don't think the true picture can be painted without me saying what I need to say.
All right.
But
I'm going to ask you not to go there, but
Okay.
I appreciate your perspective on that.
okay.
All right, Mr. Smith, thank you for your time. You can step down. Mr. McLeod, next witness.
Your Honor, I'm going to call Mrs. Ibezims.
Okay, it is,
I can do it in 5 minutes.
okay, because we've got about 18 minutes before we need to wrap up today. It'd be great to not leave a witness hanging.
Getting better by the end of the trial and sticking to that.
Okay, Ms. Ibezim, if you don't mind coming up, please.
Raise your hand for me. Do you swear affirm the testimony given the court today the truth and whole truth and nothing but the truth of God?
So help me God.
Have a seat for me, please. Thank you. Spell your name for the record.
My name, let me get closer to the microphone. My name is Tia Ibezim, Ibezim, first name Tia.
Welcome back.
Thank you.
Good afternoon. How are you today? I'm going to hand you what's been marked as E17 and just ask if you'll take a second to review that. You might want to start at the second page. I'll start with your report.
You're welcome to read all of it. You don't need to limit that, but it sounds like Mr. McLeod.
Can I just refresh myself with
Sure,
it?
sure.
Oh,
No, you
sure,
should.
okay.
Please take your time to read the whole thing. I want you to have complete context. So you can do it.
So I recognize this email, and it sounds like at the end of the email, I had some few questions. What did you need me to review from the email?
Okay, I'd like to tender that into evidence.
Okay, Mr. Stewart, any objection to defense 17?
Oh, yeah.
Mr. I'm not sure who's handling this witness. Ms. Wilson?
No objection.
All right, 17 is admitted.
Mrs. Ibezims. This is an email that you sent to Mike Tolley on September 3rd of 2018. Really about the time that the water issue is really coming to a head. Would you agree with that?
I think it was coming to a head a little bit before then, but yes, I think we were just trying to still try to reconcile the issue.
Fair enough, fair enough.
Mhm.
And so what was the point of your email to Mr. Tolley?
Well, it says here that, I'm not going to read the whole email, but something about the hay, because I noticed that.
I'm sorry to interrupt you. I think this is an important email, so.
Oh, do you want me to read the whole email? Oh, I'm sorry, I misunderstood. I wanted to bring something to your attention. In the back of our home, we noted that there was placed or replenishing of hay and huge white rocks a couple of houses down. I'm going to take a leap to assume that was placed because there was an attempt to absorb or slow water flow / drainage. However, what that hay, I think is this hay, has done and blocked the flow from within inside our fence and has prevented any positive drainage from our space. In other words, the hay has clogged from the opposite side of the fence. Is there any way to have that removed, at least from around our fence? We had a problem before, but now it's a huge problem. We have video of the problem it has created more so. If you would like to see it, I can send it to you. And also, when Trevor was here, there was a conversation of plan to create or help with positive drainage. Can this be reviewed on what the plan was? I have not seen any improvements being done thus far. Where are we with this project? Please follow up as soon as possible after the holiday. Thank you.
Thank you.
September 3rd, okay.
So, so you had a problem and then they put some hay outside.
When you say they,
I guess whoever put the hay, so you understand,
I'm assuming that was the HOA, yeah. Mhm.
whoever put the hay
Mhm.
there, it created, you had a problem before, and your email's clear about that. But when you put the hay there, it really made the problem worse.
Yes.
Yeah.
Yeah.
And what was happening was that there was hay piling up against the outside side of the fence. And it was preventing water from getting through the fence into the drainage swale. That's correct, isn't it?
Half. May I explain? Just because there was also water coming from underneath our next door neighbor to my right under the slab. So I was talking about that water flowing and from the gutter as well. So we have water coming from 3 different areas. Okay.
Understood. But the combination of all of that
Mhm.
was that the hay, because the fence was low enough to ground level, that the debris and hay couldn't flow through the fence to get to the swale gutter.
May I ask a lawyer a question?
You can ask, I don't know that he'll be in, it may clarify, and then Mr. McLeod can ask a different question.
Is the hay supposed to flow or is the hay supposed to absorb?
So he can't answer that.
Okay, okay,
I'm just saying whatever it was supposed to do, the issue was
right, I'm trying to figure that out, yeah.
that not all of it could get through the fence, clearly, or
The water.
with the hay, the water could not, right?
The water could not because the hay, when they refreshed it, blocked the gap that we had at the end of our fence.
And my recollection was, and so that created the water back up. And my recollection was that your husband had to pretty constantly or often, he had to get a shovel and start digging out dirt and hay and everything that's flowed through the fence. My recollection of the testimony was that it was a lot of stuff. It wasn't just dirt. There was hay on the inside of the fence as well. And so.
And we removed that though.
Right,
Yeah.
he had to get a shovel to do that.
So when we first moved there, before we had the fence, there was hay everywhere in the back. Then we removed it, honestly, because the concern was we didn't want snakes to be, underneath there when my kids stepped outside for whatever reason. Right, because you can't see the ground. So we removed the hay. So now you just have dirt out there and a concrete pad. So now the fence is up. When they refresh the hay, now if there's water coming from off of the gutter underneath the slab and water running down, now that I know it's called a swale, that water, if it came in, it wouldn't be able to go back out because now it's being blocked after it was refreshed. Mhm.
And I think we actually have video of some of that in evidence.
Okay.
Do you recall seeing that?
We're here, yes. Mhm.
So the video of that situation has been presented to.
It has, yes. Mhm.
And we may see it again in closing arguments so that everybody can see exactly
Mhm.
what the issue was. Does that video that we showed, or these videos accurately represent what you're talking about in this email to Mr.
With the hay, yes.
I have no further questions about this document.
Do you have any more questions for Ms. Ibezim?
I do. I have one more.
Okay, then you can take the document down if you want, or leave it up. Let's keep going with your. 5
Same
minutes.
drill. I'm going to hand you what's been marked as D16 and see if you, and again, it starts on the second page. So just take a minute.
Sir, is this from August 21st that I'm looking at? Tuesday, August 21st, 2018? Oh, okay, so August
I
20th.
think this is the first part, and then it goes to the first page.
Okay.
Does that make sense?
So from here?
Yeah, I just want, and you look at it, but I think this is the first part of the email, and then I
Okay.
think it flows through to the first page.
Okay. So looking at this, so I refreshed my memory from the email.
Okay, and before we put it up, well, Your Honor, may I introduce that into evidence?
Mr. Stewart, any objection to defense 16?
Oh, yeah.
Ms. Wilson?
No.
Admitted.
Thank you. Mrs. Ibezims, Mr. Stewart said earlier that you had contacted Gwinnett County about this issue. Is that correct?
My husband did, yes, and I was aware of it.
Okay. So y'all contacted Gwinnett County. Did you ever receive any plans from Gwinnett County related to the drainage on your property?
Plans? Can you further explain what type of plans you mean, like an email or a?
On the document, I believe it says that that you received plans from Gwinnett County.
So that would be from, I think, above, just because down here talks about the, you said the second page, sir? Okay.
I have it pulled up. If you'd like.
Okay. Actually, for me, I'm doing great. with Technology, believe it or not. I've been really proud of myself. Trust me, my wife was like, she wouldn't believe how successful I am. Okay, so we'll get down to report. So, Mrs. Ibezims, this is another email from, at least I guess it's from your email address. What it says is, I think there is a containment wall missing, referring to the plans that the county furnished off my request. Did you ever actually receive any plans from Gwinnett County?
To my recollection, Gwinnett County has not sent me anything, no.
So,
Well, when I say that, as far as your question, the plans,
is this an email that you wrote, or do you know maybe your husband wrote this email?
I'm aware of this email, but I'm not sure who's the author. Does that make sense? I'm not sure if it was me or him, because we use the same email.
But regardless of who wrote it, you're not recalling any plans that the county, presumably Gwinnett County,
Right.
furnished at your request or your husband's request.
Well, I didn't request anything from Gwinnett County, no.
Okay, that's part one answer. Part two, are you aware of any plans that your family received because someone in your family requested plans from Gwinnett County?
We requested that Gwinnett County come out to, what do you call it? To survey the land or tell us what the issue is. So I'm seeing Kenneth's name was there. So Kenneth came out to the property.
Okay, are you aware of any plans that Gwinnett County?
No written plans, no. It was all verbal when they came to our home.
Okay.
What knowledge do you have about a missing containment wall on the drainage swale behind your property?
Are you telling me that a retainment wall is missing?
I don't know. This is from an email that you produced during the discovery that says that you received plans regarding a missing containment wall. There was testimony that you had spoken with Gwinnett County. So I'm trying to find out if you learned or have any knowledge about a missing containment wall on the property.
So if this is after Kenneth came to our home, there must have been some type of conversation about that would help to contain the water that's coming down the hill.
Was it your understanding that the property needed a containment wall?
I believe we were told that it would help. Yeah.
Were you ever told, or let me just try that. Did you believe that a containment wall was actually required back behind your property?
We were still trying to find out, sir. But that was part of the conversation as far as what else can be done, because we're at this point, we're still trying to figure out options.
And with respect to this containment wall, do you recall when we were talking earlier with Mr. Schaumpweiler about a cut, if we had to cut into the grade, there would have to be a retaining wall put there?
Yes.
Is that your understanding of what this containment wall?
Not related to Trevor. It was, so that's probably 2 times now I'm probably hearing that from Trevor, and also with this conversation that my husband had with Gwinnett County.
So was what Mr. Schaumpweiler saying consistent with what Gwinnett County was telling you?
Not everything, no.
Not everything.
No.
But they were saying that perhaps a containment wall would help the issue, that's correct?
Yes.
Okay. You don't contend in this lawsuit that Waters Edge was responsible for putting a containment wall in on the swale, do you?
Are you saying that, am I saying that Waters Edge is responsible for putting a containment wall?
Correct.
If it would help, if they owned the land after GeoSam, sold it to them, and if that would have helped when you have the land sitting there for 10 years and people have worked on it and there really wasn't a swell there. So, yeah.
If the original developer, Orchard Homes,
Do you represent Portrait Homes?
do not.
Okay.
You're not, sorry, you're not supposed to ask me a question, but.
And you're not supposed to answer them.
I'm sorry. That was my follow-up.
All right, keep going. You're about out of time for the day.
But if Water's Edge and the other defendants didn't own that property, would you agree with me that they weren't responsible for putting retaining wall there?
Water's Edge never owned the property.
If Water's Edge never owned the common area drainage swale, would you agree with me that they would not be responsible for putting a containment wall or retaining wall there?
I understand during testimony, and forgive me if I can't remember who said it, it might have been from the association, that when Water's Edge was working on our building in that area, there was ropes and barriers up, so they couldn't even go back there to take care of it because they needed to erect buildings. So at that point, you know, if you're working on that area, then you should be responsible for that area, even if you didn't own it. Just like when the rocks and the swale were, you know, reconstructed, the one that Dr. Spot said was incorrectly placed.
But if Portrait Homes was responsible.
Don't interrupt, Tim. Keep going.
If the county's plan showed that Portrait Homes was responsible for putting a containment wall on the property and they didn't do that, they would be responsible for that, correct?
Is that what the county plans show?
So you don't.
Because I haven't seen any, I told you I didn't see any plans from, okay.
That's why I was asking the questions, because the email says that you had received plans that reference the missing containment wall, and that's what I was curious about. And that's why I was asking about this email. But if your representation is that you don't have any plans.
I physically in my hand don't have any, not at home, I don't have any plans from Gwinnett County.
So as far as you know, this email is not correct. You've never seen any plans from Gwinnett County regarding the containment.
I've never seen any plans myself, no.
Okay. And your husband has never shared any plans regarding a containment wall, correct?
No, he hasn't.
Thank you. You've answered my questions. I appreciate your time. Okay.
All right, Ms. Wilson, do you have any questions for Ms. Ibezims?
No further questions.
Thank you. Mr. Stewart?
I'll try to be quick, because you can't come Monday.
Pardon me?
I know we're really short on time, but you can't come Monday, so I'll try to be real quick here.
Okay, you got about 2 minutes. Otherwise, she will need to be back on Monday.
That's a problem. All right. Yeah.
Yes.
You heard that. They didn't call you a liar, they said you misstated the truth. When you were swearing in court the other day, before telling the truth, anything that testimony you misstated or wrong, if you think you lied, did not tell the truth?
No, I was honest in how I, collected my thoughts and everything that happened.
When you met with Ms. Smith about the warranty and wait till it runs out, that's when you gave about.
Hold on 1 second.
I'm going to object, Your Honor. This is outside the scope of the direct examination.
Well, I was gonna call as a rebuttal witness after they arrested anyway, so just quickly do it now, plus it can't come out.
I think you're right, but Mr. Stewart would have that ability as a rebuttal witness. He's in a bit of a pinch because apparently his rebuttal witness won't be here next week. I'm going to give him that benefit, assuming he finishes in the next minute or so, because otherwise I need to let the jury go because one juror has a conflict, and that will be the end of his rebuttal as well. But thank you for the objection.
Understood.
Thank you, Ryan. You heard the lawyer say either you or your husband both have bamboozled the people. Did you bamboozle people in this trial?
I did not, and I'm not intending to do nothing like that.
In the last 5 years, have the problems you complain about actually occurred, or is that something that didn't really happen like you said now? Mr. Smith figured out wasn't true.
Everything that I testified to and my husband has been true. All these things are factual.
You talk about everybody else that talked about you need to cut the fence. Did anybody at HOA, Ms. Smith, or ever suggest, can't tell you that you need to cut the fence?
Absolutely not.
You talk about, you talk about flooding. Did you use the term flooding with Mr. Smith?
I only talked to Mr. Smith a couple of times, so it wouldn't have been me to use that word, because I believe yesterday I said that most of the time my husband spoke to him. So our conversation was only to say, okay, thank you, I'm gonna have my husband call you back. No problem.
From the first time you understand, right this second. Have you sworn to tell the truth, the whole truth, and nothing but the truth? Has anything changed at all?
Nothing has changed. My testimony stands as I said it.
Is it just that you really hadn't had much of a problem after all? Or has it really been a terrible situation?
I wouldn't be here if it wasn't a problem. It's been a problem, so.
Jurors, any questions for Ms. Ibezims? Seeing none, thank you, ma'am. Appreciate your time. Good luck on Monday. Mr. McLeod, do you have any more witnesses? All right, Mr. Dorsey, do you have any witnesses that you plan to call?
Your Honor, there's something I need to take up with the board.
Okay, but assuming whatever you want to take up doesn't go on the way you want, do you have any witnesses you intend to call?
None of this time, Your Honor.
Okay, so is it safe to tell the jury that all sides have rested, except I'm going to ask Mr. Stewart in just a second if he's going to have any rebuttal beyond the rebuttal he just got? Effectively, I know Mr. McLeod has rested, and you are resting. I understand there's an issue. You've waived nothing. It's timely, whatever you want to bring up. But it sounds like if we work through it in a particular way, and I do end up calling upon Mr. Dorsey, you'd be resting. Okay, same with you, Mr. Kyle?
Yes, Your Honor.
Okay, were you planning on rebuttal?
No, you have plans for rest, total.
You doubly rest.
Well, that was rebuttal witness. That would have been my rebuttal.
Understood.
No.
Is that your new child calling?
No, that would be me trying to put my timesheet in for the week.
All right. I can tell them what you did. No work. You guys need to go. We're going to reconvene on Monday, probably here, but we may get to go back to my courtroom, which has a better jury room. The temperature is better, coffee maker and all that at 10:30 a.m. So sleep in on Monday. 10:30 a.m. on Monday. And we will start with closing arguments. We're going to go straight into closing arguments. When closings are done, I'll give you the charge. It's a relatively short charge. And then you'll begin your deliberations. You will finish on Monday unless your deliberations take you to Tuesday. But you will be in control of the matter Monday. But we're going to start at 10:30. And if we're able to get you word in advance to go to 8D, you'll know that. Otherwise, come to 9J. There may be a deputy who says, hey, we're going to 8D. It's easy to get one floor down. You go across the Sky Bridge and into the lap of luxury of 8D. Please, over the course of the weekend, no outside research. For those of you who are thinking, where's the witness going to come in to answer this question? There are no more witnesses. And so whatever questions you had were not answered through the course of the evidentiary presentation, which may give you doubt, which may cause you to decide one side prevails and another doesn't. Doubt is not an issue. It's something for you to work through. So please, no outside research. You're going through a 48-hour stretch where you may want to talk about this with other people. Don't bottle it up, because on Monday, you'll be able to talk about it with your peers until you resolve the matter for these litigants. Yes, ma'am.
To your knowledge, is parking the same at 10:30 as it is at 8 o'clock in these different lots? Because it fills up. I don't know about.
There should be spots for you all in that. You're talking about the red and the yellow, whatever
yeah.
those are. It should be, the shuttle may run a little less frequently. So if you cruise in at 10:20 thinking there'll be a shuttle, you might want to get there a little early, but we'll obviously wait for you. But you may want to try to hit that lot around 10. And that for sure you'll get a shuttle that will get you here. Always call my chambers if you run into an issue. They say, hey, it's juror X and I can't be here because I'm stuck in traffic or my wife's having a baby. And then you can't be here and we'll work through that. I apologize again that you're having to come back on Monday. The forecast was Friday and we've missed that forecast. Not for want of pushing, but we need you here Monday, 10:30. Assume 9J. If we're able to get word out to all of you, it'll be 8D, or as I said, someone will escort you to 8D. Any other logistical questions? Yeah, just leave everything in the jury room. We'll, if you're going to end up in 8D, we'll move all that stuff. Yes, ma'am.
I'm sorry, I heard you say 8D.
Right, but you're coming back to 9J on Monday unless you get a call or an email saying go to 18. Don't worry about it. If you're confused, just come here and there'll be one of those red jackets from Delta saying, hey, you need to go over to 8D. I'm just hopeful they'll be out of my courtroom because the jury in the murder trial is already deliberating. And so they may not want to come back on Monday and then they'll sort things out today. So anyway, I don't want to keep you any longer. Thank you for your time. 10:30 Monday. We'll see you.
Nice weekend.
All right, you all can be seated. I want to work through a couple things with you. I know it's Friday, it's late, but you get paid more than the jurors do.
Go ahead and leave.
Oh, sure. We're just going to talk about the verdict form and a little bit on the jury chart. So folks are free to leave. And Ms. Ibezims, it was nice meeting you. I know you're not going to be here on Monday, but I appreciate your commitment to this situation. Will your children be back here on Monday or it'll just be Mr. Ibezims? Okay. All right. All right. Have a good weekend.
Thank you, Your Honor. Good afternoon.
You bet. But the lawyers need to stay. It won't be long. You need to go?
No, I
Oh.
need to bring something to the attention of the court.
All right, we'll do that first. I forgot. Yes, you've been very patient. I wasn't trying to ignore that. I just needed to get our jurors. We had one juror who needed to leave a little earlier than she got to go, but. All right, we're still on the record and procedurally where we are is that the defendants have rested. Mr. McLeod had no further witnesses. The defendants rested. I asked Mr. Dorsey to crystal ball a little bit about what might happen after we worked through any motions that there might be, and he shared that on the record and in front of the jury. But Mr. Kyle rose with a motion or said there were things we needed to discuss outside the presence of the jury, given the Mr. McLeod having rested. And we're now at that juncture. So the microphone is yours.
Okay, Your Honor, I need to bring us back in time when the defendant rested.
Yes, that's where we are.
Okay, at that point in time, Mr. McLeod and I have come to an agreement.
So when you say I, you are speaking on behalf of Backyard Realty only.
Only Backyard Realty Group doing business as Tolly Community Management.
Okay.
Regarding a request, and I don't know if it requires the court's consent on this, but to dismiss this entity from this lawsuit.
Okay. And would that include removing Backyard Realty as an apportionee? I mean, is that part of your request or you're indifferent as to that?
I don't know what the protocol would be when you have I assume that if you have a dismissed defendant, I don't know what you feel about the apportionment. Since there was an apportionment as to both defendants,
right.
I would think they would both be on the jury verdict unless you dismissed it before the trial began.
And you may be right. I'm not sure, but I want to know.
I don't have a dog in that. I'm willing to defer to the court on that.
Okay.
I just wanted to get my client dismissed from this lawsuit.
Got it. And the party with authority to do that is Mr. McLeod's clients, and he's not opposing your motion, or in fact, I guess he'd sort of need to be seconding it.
I am, Your Honor. I thought we had basically, in effect, I think we reached an agreement to dismiss. There's another part of that agreement that relates to the attorney's fees motion against my clients. And so based on the evidence and where we think we are in this case, finally that came out, we just think it makes sense that we walk away from each other.
There was a 9/11/68. Is that the right? That I think both Smith and Tolly individually brought. I'll get to you. But what you're agreeing, it sounds like the negotiations are such that you are dismissing your claims, whether we say contribution, indemnification, or apportionment against Backyard Realty, doing business as, and
Intolerant as well.
okay, but he's been dismissed.
Right, but just making sure that
Okay, belt and suspenders. And it also sounds like Mr. Kyle will get on the record that he is withdrawing or dismissing his 9/11/68 motion because he had offered $100 to settle and actually got zero. And so attorney's fees ought to be paid. He's stepping back from that. Is that a fair statement, Mr. Kyle?
Right, we were stepping back to that. He's
Okay.
willing to dismiss that.
Okay,
In the same vein as he's dismissing the action against my client.
got it.
And Your Honor, to be perfectly frank, I don't see any evidence in the record that Holly might be held liable for anything based on.
Tolly, Mr. Tolly or Backyard Realty? Okay, because it's not the homeowners association for all the reasons we've seen that they never controlled the common space. Okay, let me get input from Mr. Stewart. Mr. Stewart, I don't think you've got a dog in the fight for the 9/11/68. Well, I'll hear you on that. But I do think you have an important perspective as to whether we keep as an apportionee Backyard Realty. I think if everyone agrees they could be removed, that I have the ability to do that. But if you object to that, I want to hear why, and then I'll need to think through whether it's appropriate to do it.
So I told my client yesterday, I said, they made a deal because they're going to take, so they're going to dismiss their attorney's fees and he's going to flip on the stand on this. It's what happened. So I don't have a problem. So when we go to argue to the jury, we can say they're no longer part of this lawsuit, but they're still on the verdict form. I can say they're no longer part of the lawsuit. They can be dismissed.
Right. Yes, my question, so let's try to do my questions. I appreciate your description of the situation and it has some merit to it. But it also is what's happened and can happen when you get a whole bunch of players in the mix. You don't have any objection to the dismissal of the 9/11/68?
Oh, yeah.
Okay, wise. What are your thoughts about whether Backyard Realty should remain as an apportionee?
I say I have a dog in that fight, but if they decide to dismiss them, that's their deal. Then they should be still be on a verdict form if they want to be. I'd rather not be, but if they're going to be verdict form, I should be able to say in close argument, they're no longer part of this lawsuit, but they're still here for you to more damage against them.
Oh, yeah, if we keep them on. And my question to you is, do you object? My preference would be to take Backyard Management off the list of apportionees.
I love that.
If you don't oppose that, I think that's the right answer, given Mr. McLeod's motion. And I think also evidentiarily. In fact, I thought you might be making a motion or renewing an argument that, all right, now the evidence is closed. How the heck is, and you may still do that. You may say it about Portrait Homes and Wells Fargo. But I'm hearing Mr. McLeod say he doesn't think there would be a factual basis to apportion any of the fault to Backyard Management, Realty, Backyard Realty.
No problem with that. I agree with all that.
Okay.
I was hoping to hear the same thing on the 9/11/68 against Smith, that they're going to deal and they're going to let out.
Well, we're not there yet. We're
not the case.
we're working our way down our set of tables. So your motion to dismiss the 9/11/68 is granted. Your motion to dismiss Backyard Realty is granted. And the verdict form, I'll modify in just a moment because I want you to see what it looks like now. I'll remove Backyard Realty from that. I don't think Backyard Realty is mentioned by name in the jury charge anywhere. The only parties by name is plaintiffs, but then I spell out the two defendants' names to avoid some of the confusion you don't need to worry about anymore. But that the jurors might think, oh, wait a minute. Yeah, punitive damages against the third party defendants. And that would be improper.
You may want to just, may I suggest, make it singular, third-party defendant rather than defendants.
Yep, going forward, anything that references that there, I don't know that there's anything that reference, but it needs to be singular now. Okay. Anything else, Mr. Kyle?
No, not, we're at the end of the defendant's case. Now we're at the end of the third-party defendant's case, and I suspect that Mr. Dorsey is going to make a motion.
Good, well, I'm gonna get to him. My question was, do you have anything else?
I have nothing else, Your Honor.
Thank you. Mr. Dorsey, now we've got Mr. McLeod has rested, the defendants have rested. We haven't rested?
Yeah, I've rested. I was gonna make one motion with respect to directed verdict to WEG Mill Creek. I thought he had something important that he needed to get to the court before we did that.
Okay, so this was still part of, you really hadn't passed the baton all the way down because you had a motion.
I didn't realize the urgent matter that he was bringing to the court's attention was our.
Okay, I had no idea. So I will get to Mr. Dorsey, but let me start with you, Mr. McLeod. You have a motion for directed, you're renewing your motion for directed verdict, but as to WEG Mill, not the operational company, but the landowner.
That's correct, and I think the evidence just shows that they just by holding title. I don't think there's any actions that have been alleged that they did anything. The plaintiff's complaint basically alleges that the actions of Waters Edge Group Inc. All of that is really what this case is about, the improper grading, all the actions that Waters Edge Group Inc. did, nothing that WEG Mill Creek did, other than hold title. I haven't heard that there was anything, this is a tort action. This is a nuisance case. I haven't heard that WEG Mill Creek LLC did anything to actually cause the nuisance. So therefore, that's why I'm doing the motion.
All right, Mr. Stewart, Waters Edge still in, not going anywhere. Motion now about WEG Mill. I understand the evidence to be that it was passive, WEG Mill. It was very active in that it bought the property, but it was passive after that. Not involved with construction or my poorly worded theory that the cause of the nuisance was the integration of the Waters Edge development into the drainage system. And that's the argument for liability. You'll say it more effectively and tie it in more with nuisance law. How does WEG Mill fit into that?
Oh, yeah, based on Trevor's testimony, even more now, because his testimony was, we actually own it where the problem is at on the slab. And we, at the time we sold it, and it was not fixed. It was a defective thing that the owner that created the nuisance. It's not just what Waters Edge did when they went out there and put rocks in the swell and didn't fix the swell.
No. I'm not talking about things that happened post-sale, because WEG Mill did nothing post-sale. Once they sold it, they were out. Now, that doesn't mean they're out per Green and West, but what did WEG Mill do to create or maintain the nuisance?
WEG Mill, at the time of closing, owned the nuisance that had been created by what they did in Lot 4. The nuisance continued as the owners.
Okay.
They were probable.
So insofar as a jury could find that it wasn't the fence, or the fence was merely an exacerbator, but there was already a nuisance, that nuisance existed. It's back to Mr. McLeod's case where one person owned higher and lower property and then sold them, and some court said you can't, that's not a nuisance because the same person owned it originally. But basically the cause of what became the nuisance was created when WEG Mill still owned the property.
That plus the CEO of both of them, the actions of Waters Edge was in the benefit of them, and WEG would not have been able to close but for that lot next door being finished correctly. As the owner of that lot, it was a negligent thing when they sold it, and their actions as the owner and controller of it contributed, because the law is a cause or concurrent cause. They both played a role in the nuisance flooding of my client's property.
You couldn't have the nuisance without both, is what you're saying.
The volume of the nuisance both contributed. what comes on that rock and everything else, WEG owned it, they controlled it, it's causing damage.
Okay.
Water's Edge did things in the ditch they shouldn't have done, they didn't fix it like they should have, and therefore they contribute to the nuisance. Like I say, current cost of the creation, continuance, or maintenance of the nuisance, and they both contribute to the current creation of the nuisance.
Okay. Mr. McLeod, you can respond. I think it's a thin argument, but for motion for directed verdict, thin is plenty thick.
Understood.
Okay. All right. I will deny the motion, and the jury will need to decide if mere ownership plus the little bit that we heard is sufficient. Well, Mr. Pye?
Your Honor, just for the record, Your Honor stated what I would state. We are renewing our motion for directed verdict, which you made to close the plaintiff's case. Generally on nuisance, damages, et cetera, and we've added the WEG mill.
Okay, and thank you for perfecting the record in that. You're exactly right. And I continue with my ruling that this won't be taken from the jury, and they will be considering liability, if any, for both Water's Edge and WEG mill. Now, I think I should turn to Mr. Dorsey. All right, Mr. Dorsey, you don't need to call any witnesses right now because no jury, but I would like to hear anything you want to say about where we are procedurally.
Yes, Your Honor. I'd like to move for a directed verdict at this time since defense has closed their case. As Your Honor is aware, there were essentially 3 claims brought against our, well, now 1 client. We started with 4, we're down to 1. And that is contribution, indemnity, and then the apportionment. And I think as we've been discussing throughout the course of this trial, apportionment is most appropriate. With regards to contribution, Brenda, please correct me if I'm wrong. I think you said we're good on that one.
Yes, I'll acknowledge that.
When you say good, meaning you agree a motion for directed verdict is appropriate, or you are dismissing whether that's count 1 or 2 against the remaining defendant?
Yeah, I'll dismiss the claim for contribution.
Okay, all right.
And then that leaves open indemnity, and I'm not challenging the apportionment because as Your Honor has addressed, that's going to put us on the apportionment beside them, but not across from them. With regards to indemnity, there's 2 ways through which third-party action you can recover indemnity. And while the directed verdict standard, and this is appropriate timing for it, given that they have closed their case, as Your Honor pointed out, the directed verdict standard is a pretty high one to achieve. However, in regards to indemnity, I believe that it's been well vetted and we've met our standard for directed verdict. And the testimony is there's 2 ways for directed verdict to be granted as to indemnity, and that is proof of no contractual relationship and proof of no vicarious liability. There's absolutely no testimony that these 2 companies could be vicariously liable for one another. That's got to have an agent-principal relationship. And in fact, Mr. Schonkweiler said there has been no relationship among the HOA and, well, now between the HOA and Water's Edge entities. Likewise, he testified on the stand that there has been absolutely no contractual agreement among the Water's Edge entities and the association. So I think on those grounds, this case should be dismissed as to indemnity because there's no contractual relationship. There's certainly no principal agent relationship in any regard. And I think that the apportionment would be the appropriate manner in which to proceed.
So an indemnity claim might be viable as between your client and Mr. Kyle's client, where there could be arguably vicarious liability because Mr. Tolley was an agent for the homeowners association, et cetera. I'm not saying it's a powerful argument, but that could probably get past a directed verdict. But there's no such connection between either of the Water's Edge entities. I'm focused mostly on Water's Edge Group. That's the one that had the most contact with your client, the homeowners association, and one didn't act for the other. In fact, we've had lots of testimony about how were you, Mr. Silverstone and Mr. Schonkweiler, on the property of the HOA to put that check dam in. One was not acting for the other. They were both acting in their own interests that sometimes overlapped. And there's no contract. The contract was, it was a property contract, if you will, was GeoSam selling some things to one party, WEG Mill, and selling some things to the homeowners association. And not any it's not a triangle relationship, it was a V. Geosand might connect them both, but there isn't that third leg of the triangle connecting either of the water's edge entities to your client.
Correct. There's no linear contract or horizontal contract. We're not working together, and there was no exchange of property or services or any of that nature. So for those reasons that Your Honor has pointed out, I believe that we're entitled to direct verdict as to indemnity and enforcement is the appropriate way to proceed.
Okay. Mr. McLeod, you are dismissing the contribution claim. I've heard argument about indemnity. What's your response to that? Or Mr. Pye, I don't mean to pick on you.
No, thank you. Your Honor, I think my understanding of the law on indemnity is just not so limited. And I would refer the court to the City of College Park case that is 271 Georgia Ave 446. And the issue relates to the difference, I believe, between joint and successive tort feasors. And so the evidence in this case is that we were alleged to have improperly graded the swale, which originally caused the nuisance. Since that time, the third-party defendant has come in and done additional acts on the property that the plaintiffs who testified have made it worse or still further caused their issues. So I think we could be successive tort feasors such that the damage that they.
If you were held liable for everything, the argument would be, well, wait a minute. You became the intervening cause when you put in that pipe and connected the drains and did incomplete work with
gutter damage, that sort of stuff. And so the analogy is, and College Park is a fairly great case to actually get an analogy from. There was a wreck and the cops caused the wreck and there was some damage. Then the injured person goes to the hospital does further damage. And so those two were separate and distinct acts. And so if the cops get hit with all the liability, they have a right for indemnity for the part caused by the hospital. So I think this case is kind of similar in that regard based on the intervening acts.
Yes.
I guess what I'm saying is that the jury determines that the regrading of the swale and the piping and all that further caused or contributed to or were separate and distinct injuries, then I think we would have a right to indemnity. That's my theory.
How does it look? Assume for a minute that I deny the motion for directed verdict, then we have something else on the verdict form, and it is that the one second. One of you is right, according to my staff attorney, but she doesn't say which. She said he's right on the money. So one of you is about to win. But what does that look like on a verdict form? It's if you award damages to the plaintiffs and you find that one or both of your clients is liable, is there any of that amount for which, because if we're apportioning, I don't know how you have both. Does that make sense?
I do understand that, Your Honor. We just pled all of this in the alternative in our amended complaint. So I'm really doing this to preserve our rights. But I'm totally fine with the way we're going forward on apportionment. I don't know if we need to add a separate instruction.
Well, if you are not asking for this jury to issue a finding on whether the HOA needs to indemnify your client for any amount, then we don't need to do anything. But if there's a possibility that they'd be indemnifying you, if that's the relief you want to pursue from this jury, I think it's inconsistent to also have the HOA as an apportionee. I don't know that that's right. That's just my gut feel that, wait, you couldn't have both, because then you would have the jury saying, you know what, the Ibezims went through a lot, and some of it was because of Water's Edge, none of it's because of WEG Mill, so 30-0, and some of it's because of this HOA, and that's 20.
So let me do this. I haven't spoken about this particular issue with my client. Can I have just a couple of minutes to explain these alternatives?
You can have till Monday.
Okay.
We don't need to sort this out. I'm going to make a note that's sort of on the cusp of things, but I'll tell you, I'm not ruling yet. I can't see Mr. Stewart. He may have some things he wants to add, but you'd need to show me some case law that says you can have both. I think you're going to need to elect.
Understood.
Okay,
Understood.
so talk with Mr. Silverstone, Mr. Schonkweiler about what they think, and I need to just see.
Maybe I'm wrong anyway.
No, I'm not saying, no, then she left. I didn't get which one of the two of you. Oh, here it comes. Okay. All right, talk with your client. And we'll work through that.
I do understand what Your Honor is saying. I just want to make sure that we're good at proceeding that the way we're going. I think I'm fine with that.
Okay. Consulting with clients is a wise thing. Mr. Stewart, let me show you all the verdict form and the way I have modified the jury charge about nuisance. And then I'll see what you want to get on the record now too.
I believe they're going to discuss the issue, trick of closing argument and jury charges.
They can talk. I'm going to keep going. Let me take one thing out though. All right, verdict form first. All right, this is page 1 of the verdict form. I have removed backyard realty. So otherwise it looks the same. Fine for the plaintiffs in the amount of X, or we fine for defendants. But what I'll say is I should do this like we did before. All right. And then you'll see on page 2, punitive damages, it's now broken out by the specific defendants. So I know in a moment, Mr. Stewart, you're going to want to argue about maybe removing other names from this list, but there'll be some names on the list of apportionment. Any issue with the format of the verdict form?
No, Your Honor.
Okay. Mr. Pye?
No, Your Honor.
All right, Mr. Dorsey.
No, Your Honor.
Okay. Then the jury charge. The only change I made, and it may be blocked by this, let's see if there we go, is this sentence that I've highlighted. And let me tell you what I think the issue is. Green and West, I think, address the issue that an owner of a property who created a nuisance doesn't get a walk away from liability because he sells that property. But it addresses that I created the nuisance. Baudin deals with continuing, I'm using the word perpetuating here, it's continuing a nuisance. And so they're not inconsistent, but they also are talking about sort of the tail of the elephant and the back of the elephant. I think that insofar as Mr. Stewart is going to argue for liability for any party for the continuation of the nuisance, the jury needs to be told the law from Baudin, which is what is in that highlighted sentence. I think it's an incomplete instruction to only talk about the creation of the nuisance and not the perpetuation of the nuisance. That's how I'm processing it. I'm gonna start with you, Mr. Stewart.
Where are we reading from? I'm looking at the verdict form about,
Oh, is that not what's on the screen?
we got the verdict form on the screen.
Oh, okay. Let me make that go away. I thought I had switched documents. Like, why do you look so confused?
Well, that happens quite often, Young. I
There.
acknowledge that.
All right. I won't repeat myself, but you all can. The only thing that's new is the highlighted sentence.
Okay. And I think that's totally inappropriate now based on Trevor Shamqualler's testimony. Baudin stands for the principal architect company should be out because they left and they never owned anything. They helped create the nuisance, but they were not owners. You go to Green versus Eastland Homes. In that case, they were owners. They sold the properties and they said, yes, they come back in. And of course, that's going to the injunction, but clearly it's for liability as well.
Right.
And so that's what we have here. They owned it, the patio he said they owned and all that from lot 4, that's part of the nuisance. And so since WEG owned it, they're liable.
But
well, they would be same people, just like the people that are in Green.
is it an incorrect statement of law to say to be liable for continuing a nuisance? I know I used the word perpetuating, but that was purposeful, and don't get hung up on perpetuating. To be liable for continuing or maintaining a nuisance, a party must have both a legal right and a legal duty to terminate that nuisance. Is that a wrong statement of the law?
At the very minimum, it's confusing in the sense that in Green, where they talk about negligence is not element of nuisance, you can do the thing in the due care and do everything just right.
Right.
But if you cause harm, you're still liable in nuisance.
Agreed.
So you talk about a legal duty. Why do we have to have legal duty? If you
to terminate, you have to have a duty to terminate it. If you don't have a duty to terminate it, how could you be liable for maintaining or perpetuating it?
Well, I agree. They have to have a duty to terminate it, but
that's what it is, a legal duty to terminate. That's what it says. I agree.
The word legal, I don't see why that's in there.
Okay.
That's something comes from Baudin. Baudin talks about legal duty. That is not in any other cases where they say they have to show they have a legal duty.
Well, if I remove the word legal and simply said, you have to, maybe from both, you have to have both a right and a duty to terminate the nuisance. Are you less I don't mean for it to be confusing. I also don't mean for the jury to have an incomplete presentation of the law. And I think it's a correct legal statement. I don't mind removing the word legal in front of duty.
Okay, I'm not sure why we got perpetual. I thought earlier you said that's going to confuse whether it's continuing nuisance or regular nuisance. I'm just use the word nuisance. Why do we need? I agree it is perpetuating, but the term is a continuing nuisance.
That's fine. I could say continuing it. I just didn't want you may, because you are fluent in this, be talking to the jurors about here's what a continuing nuisance is. This little piece of law only applies to someone who is perpetuating the nuisance. And so that's why I used it. I don't mind using the word continuing, and I would then replace the other perpetuating in a previous sentence. I just picked a different word so that if any of you use that term continuing nuisance, which is a term of art, the jurors wouldn't say, well, wait, that here all these people did was they maintained or they made the nuisance keep going. And I think you are entirely able to collect from someone who they decide, you know what, the cause, that was Portrait Homes, but the continuers, that's anyone who was involved, and that would include Water's Edge. So that's why I thought it was important to include that. And I know that's non-standard language saying perpetuating. I'm open to a different word.
Yeah, I like it. All the cases do it, and the jury charges it. Have you put in the other charge you asked for? It always uses the term continuing nuisance.
Okay. So let me edit it and then hear from you.
And also, why do you have a right and a legal duty to terminate? A right to terminate? What does that mean? It makes it sound like the defendant has a privilege to terminate it. To me, it should be essentially, to be liable for a continuing nuisance, a party must.
It's both. If you don't have a right, in other words, if the only way to terminate the nuisance is for me to kick down your door and get in your house, I would need to have a legal right. So I would need to get that injunction from the court saying you need to go in there and do that. You can't trespass to terminate a nuisance.
To be liable for a continuing nuisance. Are we talking about the defendant or the plaintiff? I guess I'm confused by the sentence.
So
to me, it'd be to be liable for continuing nuisance, a party has a duty to terminate the nuisance.
Well, you could have a duty, but if the way you had to terminate the nuisance was to come into my house and go into my basement and do something, you don't have a right to go into my basement to terminate a nuisance, do you?
No, I'm not, they're just deciding nuisance. We're gonna do the permanent injunction on that afterwards, so I don't know why the jury needs to hear all what they have to do. Just to be liable for continuing nuisance, but normally it is the party has failed to abate the nuisance. Use the word, you say they have a required, they are required to abate the nuisance. You're liable if you don't abate the nuisance.
But if you don't have a legal ability to abate it, how are you liable for it?
Well, that goes, we will argue about a failure to, a person who creates a nuisance who fails to abate it is liable, basically what the law is. And so when you have a right to abate it, it sounds like they got a privilege, they have a duty.
Did Green stand for the proposition that the creator of the nuisance was liable for the nuisance as it continued beyond the sale of the property, or simply that they couldn't wash their hands of all liability because they owned it for a year and the nuisance continued for 2 years? So yes, they're on the hook for the damages for that first year.
All right. Cox versus Cambridge addressed the issue. That's 1977 terminated case. In that case, the plaintiff has a right under the law, if it's a abatable nuisance, which this is, every time it causes damage, rains, the next time you got a new lawsuit,
Understand.
And under Cox, it says the plaintiff can choose. He can seek all his damages up till the time of trial and they get a permanent injunction. Or he can just seek the damages, not get a permanent injunction, and sue again and again and again.
Understood. That doesn't answer my question though. So I don't know who the plaintiff was in Green. Let's say who the nuisance causer was. Pretend it's Green. Green causes this nuisance, and for a year on property he owns, there's a nuisance that's generated that is bad news for the next door neighbor. Green sells the property and Blue buys the property. And the litigation is, well, how could Green be liable because Green doesn't even own it anymore? Does Green stand for the proposition that Green is liable even for the nuisance as it continued through Blue's ownership? Or simply that when the neighbor sues, the neighbor can collect from both Blue and Green can't say, I don't even own it anymore, but you did for a year. And while that nuisance continued for a year, that's $1 million worth. You're on the hook for that first year, $1 million worth.
Yeah, it stands for the proposition that's irrelevant whether you sold it or not. It don't even address that issue. They created a nuisance, it's continuing the damage, these amount of damages, and therefore plaintiff's entitled, if you find in favor of the plaintiff, for damage up to the time of trial, regardless of whether they sold it or not sold it. They need, that's not even addressed to the jury.
So they're still liable for damages caused after the date of sale. That's what Green says.
Yeah, you know, law now is no more joint and several. It never was a nuisance. It's always been separate. And the defense can argue, hey, we only did the creation. Everything after that was caused by the HOA. You should award them. We didn't do anything wrong, but if we did, HOA had the problem from 2019 forward. But they're both concurrent nuisance. The jury decides, no, you created, you should be liable for it all, or we think they should be liable because they didn't fix it after they had a chance. And so it's both are concurrently liable for all of it or none of it, and the jury decides in the percentage block how much you blame HOH, and how much you blame the builder.
Right. Your thoughts, Mr. McLeod? I'm less convinced I need to, that I should put this sentence in here. The legal right part is throwing me.
I think that has flowed through from Bodan, however we say it now, through the cases. And if you read in particular the Briggs and Stratton case, and it's the other one, the ones I cited, it clearly says, and I'm reading from, this is from the Briggs case, in order to be held liable for maintaining a continuing nuisance or trespass. And this is where I got my instruction.
Okay.
In this case, Simplex nails, whatever, must have a legal right and be under legal duty to terminate the cause of the injury sustained by whoever the parties are.
Sure.
So if you read these cases, it shows, it's very clear that, and I'll give you an example from the case. It says, because the defendant owned the polluting pipeline that ran through the plaintiff's land, as well as an easement and a right of way, those are legal rights. That's a legal thing. Just like the association has a legal right and duty to maintain the common areas.
Well, what's the legal right? They have a duty. What's the legal?
Well,
what's the right? I
think it's the same thing. I mean, when
If it's the same, then we only need to list the duty.
when you get to the duty part, well, it's to terminate the cause of the nuisance. Since they're responsible for repairing, replacing, anything on the common areas, that's where their termination, that's where it must be, and to terminate the cause of the nuisance. And that's why, look, I don't think, like I said yesterday, I don't think Green changes this analysis. The issue of whether there was a legal duty wasn't raised in that case. It was not.
Well, but it was in the sense that if they're holding whoever first owned the land liable for nuisance damages after that person sold the land, then they had a duty to terminate or abate after they sold the land.
Unfortunately, it may not have been raised by counsel.
Okay.
I mean,
That's exactly what.
it may not have been raised, and I think if it had been raised, I think they would have hit Bodan square in the face, and the analysis would have had to flow from Bodan. And I think if you read, I don't want to read these cases.
No, don't read the cases to me. Are they the 4 cases that are cited from wherever you found this charge?
Yes, so I'll give you the sites for them.
No, if they're the 4 that I have what you submitted. So if it's those 4, if there are additional cases you found, I don't have those. I've got the 4.
If you read Mock and Briggs and Stratton, I'm pretty sure they're in there. That should be enough for you to understand power.
Okay.
The normal language would be to be liable for a continuing nuisance. The party must have failed to terminate the nuisance after receiving notice. That's what the law is, and that's the way it's normally worded. They got notice and they didn't do it, so the continuing nuisance, and so they're liable for everything that's happened because it's continued.
Well, but not really, because what if they sent me notice that there was a nuisance? I don't have to, I'm not on the hook for anything. You have to have had a duty to terminate it. I mean, so it's not just you got notice that there was a, what else? It's not just someone told you, someone tells me there's a nuisance. It's fascinating. There's a nuisance at Mill Creek. Okay. Why are you telling me?
Once the defendant's given notice, you have to.
But what makes them the defendant? It's because they have a duty or they have a right. It's not, you just don't send someone a notice saying you have to abate this nuisance. It has to be the right person. And who's that right person?
Who created it?
Who's the creator of the nuisance?
Before I file a lawsuit all the time, I said, demand letter. My clients are being flooded out. You created this nuisance. You must debate this nuisance. So we're going to file a suit against you. And you're on notice that we get punitive damage to attorney's fees because you got to abate it after this notice of this continuing nuisance.
Okay. So it's the creator. It's not just anyone who gets notice.
Well,
to be liable for continuing a nuisance, you have to be the creator of the nuisance.
Or maintainer or continuously, those three things.
Okay,
And there's a distinction between those things. And that's the distinction versus creator and maintainer, is that if you're the maintainer, you have to have a legal duty to terminate the nuisance.
Let me
That's the distinction. And frankly, Your Honor, I almost think that there should be a separate instruction for creation of nuisance and maintaining the nuisance. I think that would, since there is a distinction recognized in the law, I think we should have separate instructions about it. So as to not confuse the jury that, hey, well, create, maintain, whatever it is, it's all the same. Because then I think my argument about you have to have legal duty to terminate it gets kind of just washed away in the analysis. Is, hey, who's liable for creating the nuisance? If that's my clients, then whatever the damage was from that, they're responsible for it. Okay?
I'll make it simple.
hold on.
I can make it simple.
And then if
You haven't yet.
I will,
you've got
right?
the maintaining portion of it, who is liable for maintaining the nuisance? I could see a jury say, you know what? I don't think the third party defendants did enough, and because they didn't do enough, it made it a lot.
Right, they could have three segments to the line. The first is Portrait Homes created it because they did a crappy swale. But then it's really Water's Edge maintained it because then they connect the building, and maybe they worsened it because there's more flow from the roof, et cetera. But then they're out of the picture, and it's the homeowners association that then maintained it. So you've got creator and continuer or maintainer.
Right, and so I do think the law recognizes the distinction that we should also use.
Okay, but Mr. Stewart's going to simplify.
Well, simplify it. Whatever you think is good, if he agrees to it, I'll accept, and I'll just explain to the jury what it means. I'm sure any wordings you want to put there.
Okay.
I mean, let's.
I'd like to get it right.
Let's put 3 more paragraphs.
No, I won't. I will tweak it over the weekend, and
Whatever you have is fine.
I will send to everyone, and really what I'd like is for it to be correct. And I'm not doubting either of your perspectives. It's just not an area that I'm in a position to push back with confidence. So I'll read some more and we'll see how it works.
You see the language all the time that Tyler, Lincoln, and possibly on this is all the subsequent case, everything that they get the buzzwords. Maybe like say you want to use terminate instead of bait. That's fine. Don't feel like people understand what a bait is, but that's 99% of the time you'll see a bait the nuisance.
Right. No, I'll probably say terminate just because I think that'll be clearer. But again, I'm changing the words only for clarity's sake. And if they have the reverse effect, you need to flag that, saying that makes it more confusing.
That's fine.
Your Honor, I guess one of the things I think like to think about is if we do owners in the chain of a nuisance, you could conceivably see an owner, somebody who caused a nuisance, and the next owner had no idea that there was a nuisance, underground pipe, oil leaking out everywhere. They sell the property. Does everybody in the chain of title then, are they, under Larry's theory, are they all liable for creating or maintaining a nuisance, and it's all the same, no matter?
It may be that there's a cause of action against all of them. And then if you are that second owner, your defense is lack of knowledge, but I don't know that you don't have a duty to abate if the pipe is on your property. You may not have known about it, and I bet there's case law. I don't know about the nuisance. That doesn't apply in this case.
But I'm saying on down the line, if you got brought into the suit, they may say, hey, I don't have any legal duty to terminate the nuisance now, so I can't be liable for maintaining the nuisance at that point. And I think the law says they're out.
Okay. Well, I will regrettably read nuisance law over the weekend. And I appreciate, Mr. Stewart, what you've said. I'm not going to just leave it as is without reading some more, because I may be able to get it closer to what the murky law requires. But we'll have a chance on Monday to look at that. We will be back here. The jury didn't reach a verdict in the other case, so they need to be in the jury room in 8D. So you all should come to 9J. It'll be open 9 in the morning. We'll start as close to 10:30 as we can. I will be dealing with some criminal stuff, which is why we're starting at 10:30 in 8D, because the jury will be not in the courtroom. Then I'll come here at 10:30. I'll come here as close to 10:30 as I can, because we have to close the loop on what this jury charge is going to look like. The verdict form, everyone has blessed. Did you have more argument? When did you want to make your argument about the other apportionees?
Well, I want to make some directed verdict to that Geo and Wells Fargo and Portrait Homes be dismissed, because Trevor said 100% they did nothing wrong. And the statute says you must prove some kind of causation. You can't just put them on the verdict form because you don't like them. They said that, hey, not only did we not do anything wrong, it was perfect the day of closing. And the three of them, no, they didn't have any problem. So there's no reason those three should be on the verdict form when the defense themselves acknowledged they were not negligent in any way and did not contribute to the nuisance.
Well, that's half the story. The other thing the jurors will hear is that the swale was defective and insufficient to accommodate the water that was, and these were all plans that were platted by Portrait Homes. And what Schonkweiler said was, we didn't mess with, I mean, you got them to admit, of course, they had to do something because there's stuff growing on the swale, but other than removing vegetation by an inch of dirt or something, they didn't do anything to the swale. So if the jury thinks that the swale is defective and is the cause of the intrusion, then the jury would be entitled to say, well, who made this defective swale? And Portrait Homes.
What evidence is that? The only evidence we have is them saying they didn't do anything wrong. Who's saying they did something wrong except the attorney?
So there's factual evidence and there's opinion evidence.
What opinion?
The factual evidence is Portrait Homes did the grading.
And everybody
Finish
says
the
it's
facts as I understand them. Portrait Homes did the grading, built the swale. Wells Fargo acquired the swale. Continuing nuisance.
There's no nuisance.
But and then Geosam acquired the swale. And then they sold the swale to the HOA.
Where's there any evidence?
I'm not finished.
I'm sorry.
So they sell it to HOA. So this defective swale changes hands across all these parties. Fact. Opinion, the swale is defective. Opinion, Schonkweiler, the swale is perfect. Best swale I've ever seen. The jurors aren't required to buy either of those opinions, or they could pick your view. And I really can't tell what Spots was saying, that the swale wasn't big enough or it was bad because the fence was in the way. Sort of seemed to be what he said. I don't think that's the swale's fault. But the jurors would be entitled, I think, to conclude that the root of all evil is the swale, and that's not water's edge. And why would the jurors not be able to make that determination?
What evidence was it that it was a nuisance when Geo and Wells Fargo owned it? There was no nuisance then, no testimony that there was a nuisance till they got involved. All three of those people, as Trevor said, no nuisance existed. Not only that, there was no plaintiff that got harmed by it.
Well, then I guess I direct a verdict for Mr. McLeod's clients, because the nuisance didn't begin until they owned nothing and controlled nothing. The nuisance began when your clients owned something and the HOA controlled it. So by your theory of the case, denied and granted. I don't think that's the correct argument.
Why with them? There is evidence that they created the nuisance. They did work at it. They didn't fix it. They created the nuisance.
Okay, and that's your argument.
Well, what evidence is that somebody created the nuisance or contributed before Water's Edge? There was zero.
How was there a nuisance before your clients owned the property? Simple question. How was there a nuisance before your clients owned the property?
My clients were not harmed till they bought that property, and the first flood event is when they had damage. And that's a regular. Now, well, the law is, the case law was 1 time is negligence. 3 times is a nuisance. Then the court came back and said, what about twice? I said, oh yes, twice. You had to flood at least twice. That's when the nuisance begins. You're not a nuisance, you've been flooded twice. So the nuisance never existed until my people bought the property and they got flooded at least twice.
Okay. So
that's
using your words, the nuisance never existed until my clients were flooded twice.
Correct.
I don't know if there's evidence they were flooded twice. Maybe it's the videos, but assume they were flooded twice. And flooded is a big word. I don't know that the jury's going to find that there was ever flooding, but let's say that they were flooded twice. And that's when the nuisance existed. Where was WEG Mill when the nuisance existed? What did they own? What did they control?
The slab.
No, they
They
didn't.
created it.
No, Portrait Homes did.
What do you
Oh,
mean?
you're right. They stay in the case. All right.
Your Honor, if we may end on a high note.
Yes.
We've come to an agreement, I believe, with a portion.
Okay.
Is that fair?
We don't want to go back, we're good.
So
We think that.
are you withdrawing indemnification or you're not opposing the motion for directed verdict?
I'll withdraw.
I guess dismiss is the verb we'd use. Okay. So you've dismissed contribution against the homeowners association and you have dismissed now indemnification, and all that remains of your three claims is apportionment. And so the verdict form that no longer has Mr. Tolley's company on it does still have the homeowners association. Okay.
Yes, Your Honor.
Noted. So what I need to do over the weekend is think about the way I want to finalize the jury charge concerning the continuing nuisance and the interplay of Baudin and Green and Ponce de Leon and those cases.
Your Honor, if with regards to the fact that the landscape of the case has changed drastically, just from apportionment, third party and all that, if I can be creative enough to write something for Your Honor to address that, because in opening, obviously, we were all over the place because it was V everyone.
I need to tell the jurors something before you start closings, that one party is no longer in the case and we'll need to get agreement to, all they need to know is that Mr. Tolley's company, Backyard Realty, is not in the case anymore. I'm happy to say they've been dismissed, but we don't even need to engage in that if that's going to create some thoughts in the jurors that, the plaintiffs had a bad case. They don't have a bad case, and they didn't have a case against Backyard Realty. So I want to be thoughtful about, in the same way that we talked about the Gwinnett case was withdrawn and not dismissed, because that could cause the jurors to think, either there was a settlement, there wasn't, or there were deficiencies in their pleadings. There may have been, but that's not why the case went away. So you're welcome to draft something. Just know that the more circumspect we are about it, that Backyard Realty is no longer in the case, and the only claim against, the only way that the homeowners association is involved is in connection with apportionment, and I will be talking to the jury about what apportionment means as we go through the charge.
Okay, that works.
But you're welcome to draft something, and please do, and just email that to all the lawyers and Ms. Niles, and then I'll tweak it a little and we'll discuss it as a group before it's anything that I'd share with the jury.
Thank you, Your Honor.
Okay. Anything else, Mr. McLeod? Okay. And Mr. Stewart, I'm sorry if I was abrupt with you, but I want the record to be clear. You have timely made and articulated a motion to have, I don't know that it's a directed verdict, but your motion was well verbally pled. You think that the three previous owners, the original owner, Portrait Homes, the subsequent owner, Wells Fargo, and ultimately GeoSam, they should not be included as potentially apportionable parties at fault.
Correct.
Okay. And I don't know technically what the mechanism is. You're challenging the 15-12-33 notice. And because your contention is there's a failure of proof showing that any of those three parties in any way caused or contributed to the nuisance, they ought not to be considered. And I've denied that motion. They'll remain on the verdict form, but you have preserved that issue. Should there be an appeal, you'd be able to argue that one of the errors during trial was the inclusion of those three parties on the verdict form.
Your Honor, Do you think it's appropriate or necessary? I didn't really have an opportunity to respond to his motion. Do you think that's necessary to preserve for the record? Or
I didn't mean to exclude you from the conversation. If you want to get something on the record, highlighting the reasons why you think the motion should have been denied, you can do that. If it was error to deny it, it goes up on appeal. You'd be able to argue whatever you want. I don't think you can waive any arguments in support of a ruling, because I think you were in support of it.
yeah, I am.
Okay. All right.
Thank you.
Sure. Just looking at my list to see if we missed anything else. I think that's it. It's been a long week. 10:30, 9J. I'll try to get here a little early to close the loop on the jury charge. Our verdict form is good to go. One thing you all could do, please, before, if you get here a little before 10:30, is to go through all the exhibits and see, one, if they're in order, and two, see if there's agreement as to what goes out with the jury and what doesn't. There are a few things that were entered only for the record. Someone may think that's changed now and it should go out, but I tried to keep track of what was record only. But it's great if you could work that out in advance, because then the jury's not just sitting back there. They can't start till they get those exhibits. And it's important that we use their time efficiently on Monday. All right, let me go down the list. Mr. Stewart, anything else?
No, Your Honor.
Mr. McLeod
No, Your Honor.
and Mr. Dorsey.
No, Your Honor.
All right, are you coming back, Mr. Kyle, on Monday?
I might come back just to watch.
All right.
He's sitting back there. I hope he's sitting at council table.
Don't sit in the front row of the middle section. It's broken here.
Can we ask if you have a list of those that were admitted, or just ruled on our records, so lawyers can perhaps get those numbers?
Sure, that won't take long. From plaintiffs, by my count, everything except for 3, 4, and 19. So there were 26 exhibits. Everything except for 3, 4, and 19 were admitted. 16, 17, and 26, the Ray engineering report, the Duckett proposal, and Dr. Spott's affidavit I had as record only. Everything else was going back to the jury. Third-party defendants, 8, which was the request form for the fence. And then defendants, I had 1 through 22. (27, 28, 30, 32, 33, 36, 38, 39, and 41. And I didn't have anything there listed as record only. But that doesn't mean that I caught all of that. All those, I didn't have noted that someone objected to that going back with the jury. So I think that's the universe of exhibits. You all should confer on Monday and then let me know if there are any disputes about what's in or out. And then secondarily, in the universe of what's in, if there's a dispute about what goes back with the jury. Mr. Casañas, will you be with us on Monday?
At the moment, no.
Okay,
Things can change.
okay, but someone from Veritex will be here?